Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you for joining us today as we are going to continue our coverage of Utah versus Kouri Richins. Let me just make sure my audio is okay. Let's see here. Welcome in, everybody. Welcome in.
Hello.
There we go. Okay. So, welcome in, everybody. Lily Wayne, Christy, good to see you. Hell Rider, good morning to you. Ali B, good to see you. Jennifer King, Debbie, Allison, good morning, good morning. Shirley, Deviant, good to see you. Sharon, good morning to you. Kimbers, good to see you. Kathy Davis, hello, hello. Welcome in, everybody. Tammy, hello. Good to see you. Thank you for joining us today. Let's see, who else is with us? I know a lot of folks are coming in now, so let me catch up to you guys. Terry Trial Watcher, good morning to you. Camilla, good morning, good morning. Looking forward to another great day, Lily Wayne says. Alice Howell, good morning to you. Thank you for sending that photo of your mug. Here's to you. Hell Rider, hopefully you'll get your mug soon. Couldn't Karen Less, good morning to you. Aya9, Sparkling Princess. Ruth Ann and Pammy, good morning. Lazy Boys, good to see you. Dream Horse. Shoshana, thank you for joining us. JMS, Selena K. Gordon and Nana, thank you for joining us. Jane Dixon, good to see you. All right. Marlene, good morning, good morning. All right. Squid Kid, good to see you. Iowa Backyard. Brat, yes, there is enough time. There's enough previews for you to go get your popcorn before the feature film starts. Lisa, good morning. Good morning. Kimbers. Betsy, good to see you. Joyce, good morning to you. And Willow Johnson. All right. Silver Fox. Poison Pinks, hello, hello. Lori. Mallory, good morning to you. Amby. Pat, good morning to you. American Girl. All right. Let's get settled in, everybody. So yesterday we were doing pre-trial prep for Kouri Richins in anticipation of today and tomorrow. So she has two live hearings. They are going to be a 1 hour delay. So it starts at 11 their time, or our time, I should say, starts at 11 our time, but with an hour delay. So it's going to be noon. So we'll be watching quote unquote live, but it's going to be an hour delayed. So until then, we're going to pick up on where we left off yesterday. If you guys were with us yesterday, we watched about 7 or 8 hours of preliminary hearings. We watched her book interview. We watched the people that interviewed her be interviewed by their own people, which was kind of interesting. And then we watched, she was suing Eric. Then we watched the Walk the Dog. We looked at the Walk the Dog letter. We watched that specifically, the trial or the hearing that was specific to that motion to dismiss due to prosecutorial misconduct. We heard Ronnie speak. We watched that. And then we watched Sky Lazaro leave. And we saw some news on that. We watched her new defense team come in, and then we actually watched with the new attorneys. Specifically, they wanted to throw out the Walk the Dog and how they acquired that, how the correction officers acquired the letter. So we watched all that yesterday. All right, so for you, for those that are new to the channel and new to this case, Eric Richins is the victim. He was poisoned with a Moscow Mule and fentanyl, like 5 times, I believe, the normal dose of fentanyl he was given. And the state is alleging that came from his wife, Kouri Richins, who is now 36 years old. So this happened on March 4th of 2022. She's up for all kinds of charges. Among them are aggravated poisoning, insurance fraud. Remember, she was getting all these loans based on Eric's business, and she was using his bank statements and putting her name on it. So she was fraudulently getting loans, and she had vendors that she was saying, yeah, sure, I've got millions of dollars, when in fact she had nothing. It was all based on Eric. Forgery, because she was signing his checks and putting her name on his bank statements. Controlled substance distribution, obviously, and that's all with the fentanyl. Now, we heard a lot about CL yesterday, and that was her maid, and that's where she alleges that that's where she got the fentanyl from. So the judge is Judge Richard Mrazek. We love him. He's got a very deep voice. I know you guys like him a lot. Prosecution is Brad Bloodworth. And then the defense was Sky Lazaro. If you see, it says first lawyer. She has withdrawn. We saw her withdraw. She withdrew in 2024. What are my notes? Let me get you the exact date. Let's see. May 17th of 2024, Sky Lazaro left, citing citing ethical mandate from irreconcilable and non-waivable situation. So basically, Kouri was also kind of talking trash about her from the jail. So she left. So that was Sky Lazaro. And then in came Wendy Lewis, Catherine Nestor, and Alexander Ramos. Now, Wendy and Catherine, we looked up, or we heard from the news, that they are very successful public defenders, and they've been around the block, and they're very successful. All right, so Kouri Richins, 36, is accused in the March 4th, 2002 passing of Eric Richins, her husband, who was 39, who was found deceased in the couple's Utah home after allegedly being given a drink containing a lethal dose of poison. Now, she called 911, I believe, around 3:22 she called, and she waited. They are saying that she waited about 15 minutes. Her phone, this came in as evidence yesterday, where her phone was open, closed, around 3:10, 3:05, something like that. So they're saying that it took her 15 minutes to call 911. When 911 got there, Eric was just non-responsive, and he was gone. So prosecutors allege the deletion was intentional and financially motivated, pointing to life insurance policies, financial distress, and digital evidence gathered during the investigation. Let's see. So on March 4th, 2022, Eric Richins, a 39-year-old father and successful business owner, died suddenly at his home in Kamas, Utah. Now, they have 3 kids. They have three boys who are like, what did we say? They're like 9. What are they now? They were 10, 9, and 6 in 2023. So they're like 9, 12, 13, or they're going to be that old this year. So an autopsy later revealed he had 5 times the lethal dose of fentanyl in his system. His wife, Kouri, claimed she had served him a Moscow Mule to celebrate a business deal before finding him unresponsive. Now, a year later, Kouri self-published a children's book titled Are You With Me? To help her sons cope with their father's accidental death. She even appeared on local television to promote it, portraying herself as a devoted, grieving widow just weeks before she was arrested and charged with his murder. Now, we watched that yesterday. If you guys haven't seen that interview, I encourage you to go back and check that out yesterday. We showed that yesterday, and then we also showed the 2 people that interviewed her being interviewed by their own channel, by their own station, I should say. So if you haven't seen that, definitely go check that out. The prosecution argues that this was not a sudden act, but the end of a long-term plan. Eric had survived multiple instances where he believed Kouri was trying to delete him, including a trip to Greece years prior and a Valentine's Day breakfast in 2022 that left him unable to breathe. Now, apparently that was an egg salad sandwich or something. She tried to give him an egg salad sandwich. So. And he thought it tasted weird, and he even told, we'll get to it. He told his family, watch out. Because of these suspicions, Eric took highly unusual legal steps to protect himself and his 3 children. So the beneficiary changed. So he secretly cut Kouri out of his will and living trust. Hey, Joanne, good morning to you. Garden Critters, good to see you. Tosh, welcome in, welcome in. Naming his executrix, he appointed his sister, Katie Richins Benson, as the personal representative and executrix of his estate. Now, you remember we heard from Amy. Is it Amy yesterday? Amy Richins was involved in a physical altercation days after his passing. And then Katie Richins is his executrix. So we also heard from Amy. That was the first hearing we watched. That we heard from Amy saying that Kouri attacked her and punched her and called her all kinds of really, really mean names. Sharon, yeah, I don't know who that Lotto was. Yeah, we heard about this Lotto, and I have no idea who Lotto is. We got to figure that out. Hey, Stella, good morning to you. Yeah, we have to figure out who this Lotto person is. All right, the hidden motive. Eric explicitly told family members that if anything happened to him, Kouri was the prime suspect. He didn't tell Kouri about the changes to his will because he reportedly feared she would delete him for the money if she knew she was being cut out. The discovery of the secret will led to immediate and public conflict. When Kouri realized she had lost control of Eric's millions, her reaction was reportedly violent. Here's the physical assault we heard about yesterday, and we saw Amy talk about this in court. Just days after Eric passed, Kouri learned that Katie Richins Benson had been given power over the estate. During a confrontation, Kouri allegedly punched Katie, actually Amy, in the face and neck, or maybe Katie was there too. I know Amy definitely said it was her. This resulted in Kouri being charged with misdemeanor assault and battery. Destruction of the safe. Kouri reportedly attempted to claim a safe at Eric's business that held between $125,000 and $625,000 in cash. When the family refused her access, she hired a locksmith to drill and saw into the safe, essentially ruining it in an attempt to retrieve the money before the legal executors could secure it. Prosecutors allege Kouri was drowning in debt from her real estate business, owing over $1.8 million to various lenders and nearly $200,000 in unpaid taxes. Now remember, she was able to get that much money because she was putting her name on Eric's bank statements. That's how she was able to accrue that much debt. They believe she took out Eric to access his life insurance policies, which she had secretly attempted to modify, and his $5 million estate. Remember, he had a trust and he also had an estate. And they sold his he had a masonry business that they sold, and she wanted access to that. And we watched that hearing yesterday. So if you want to check that out, we watched that yesterday. In addition to the purple charges, she faces the purple charges. I just read Deviant's thing. What does the purple TV mean? Those are just times. Those are just times that you've been a member, Deviant. So it goes by months and then it goes by years. Okay. Let's see. In addition to the deletion charges, she faces 26 felony counts for financial crimes, including identity theft and forgery, allegedly forging Eric's signature on loan applications, insurance fraud, attempting to claim millions in payouts following his passing, money laundering, shifting funds between accounts to hide her financial state. As of January 26, 2026, Kouri Richins remains in the Summit County Jail after several delays and a failed attempt by the defense to move the trial to a different county. The legal schedule is now set. February 10th of this year, jury selection begins. February 23rd, they are expecting it's going to be a 5-week trial, and that's when they are expecting opening statements. All right, so let's bounce over here. And so again, Kouri's hearing today is going to start at 12 o'clock Eastern. It is going to be an hour delayed, so they are technically starting at 11, but it's going to be an hour delayed. So we will be here. We will be covering it. But until then, let's watch some pre-trials. So this is a pre-trial from August 26th of 2024. And let's check this out. Okay, don't want that one. Okay. Let's just go here and get ourselves set up while we wait for...
Do you recall when they started communicating?
So it's going to be all things Kouri for the next 2 days. We did Kouri yesterday. We're going to do Kouri today and Kouri tomorrow as well. All right. So again, this is a preliminary hearing from August 26th. Let me go ahead and pin this. All right. We will pin that. We'll come over here. and do that, and then we shall continue on getting to know Kouri Richins.
All right, counsel, let's go back on the record. We're back on the record in 231-500-139. Mr. Bloodworth, anything before we continue with the state's case?
No, Your Honor.
Ms. Lewis, Ms. Nestor?
No, nothing else right now.
Okay. The state's next witness, please.
Your Honor, the state calls Christopher Kouri Richins.
We're going to bring you swear in.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pleas and penalties of perjury?
Please proceed.
Thank you. Sir, could you please tell us your name?
Chris Richins.
Is that a common spelling of the last name?
Yes.
Thank you. Mr. Richins, what can you briefly tell us your background?
Yes, I'm a 23-year law enforcement veteran. The last 11 years of which was spent with the Salt Lake City Police Department Homicide Squad and the Salt Lake County District Attorney's Office Homicide Team, where I was an investigator there.
And did you retire from law enforcement?
I did. At the end of 2022, I retired.
What have you been doing since then?
I started an investigations firm.
And what's the nature of the investigations that you do?
So we do investigations, training, and consulting work. So regular investigations for criminal and civil offenses, training for attorneys and investigators related to various subject matters. And then I also do some consulting work in criminal and civil cases as well.
Do you have any education, training, or experience with forensic digital evidence?
I do.
Can you briefly describe that for the court?
Yeah, so formal training. I have a 40-hour certification from the ZX Trax. It's a 40-hour training course, call detail record analysis and location mapping. I also have a 40-hour formal training, also with ZX Trax. As a subject matter expert. I'm a Cellbrite certified operator and a Cellbrite physical analyzer certified as well.
Judge, may I ask Mr. Kouri Richins to put the mic closer to him?
Thank you. And since you've talked about that, what is Cellbrite?
So Cellbrite is it's device extraction, hardware and software. It extracts data from electronic devices.
Have you been retained by the state in this case?
I have.
In what role?
As an investigative consultant and to analyze digital forensics data.
And have you analyzed and reviewed digital extractions of cell phones in this case?
Yes, I have.
I want to talk to you about a few phone numbers and just to identify phone numbers of different cell numbers or cell phones you have analyzed in this case. Do you recognize the phone number 435-671-1987?
I do.
Whose phone number is or was that?
That was the primary cell phone for the defendant.
Okay. You're getting kind of quiet again. Can you pull that microphone?
It's and the phone. There you go.
Normally, that's not an issue.
There. Could you just repeat that answer?
Yeah, that's the primary phone number for the defendant.
When you say primary, does that mean that there were other phone numbers that the defendant used?
Yes.
And do you recall what those numbers were?
Yes, there's two other numbers that we're aware of. One ends in 1152, and the other ends in 9592.
And when you say that the 1987 was the primary phone, what leads you to believe that was her primary phone?
In this context, it's the phone that the defendant utilized for her normal, everyday business, communications with most friends, her business, that type of thing.
And the other numbers, let's talk about the 1152. What kind of device was that associated with?
That was associated with her 1987 device, but it was a number being utilized on that device. It was a Google Voice number.
Okay. So, can you just describe what a Google Voice number is and how it can be used on a cell phone?
Sure. It's basically a number that you create through Google Voice services, and you can use it just like a normal cell phone. You can make calls, receive text, that type of thing, and it's utilized through a Google Voice app.
Now, the 9592 number, was there a device that was associated with?
Yes.
What was that?
It's referred to in evidence as a blue phone, but it's an iPhone that was obtained by the defendant after her original phone was seized by police in April of 2022.
I see. So was that phone activated roughly that same time?
Yes.
Now, speaking specifically to the device that 1987 number was associated with, did you observe a forensic extraction of that phone?
Yes.
And did you analyze that extraction?
I did.
Did you notice any information or data deleted from that phone between January and mid-March of 2022?
Yes.
And can you describe what type of or types of data had been deleted off that phone?
A lot of data, primarily and most relevant to the investigations in this case, the call logs, texts, web history, and web search.
So when you say that the texts have been deleted, does that mean the entire text threads between different parties?
Yes.
And was it everybody in that time frame, or were there specific people?
Pretty much everybody.
Now you mentioned that web history had been deleted.
Yes.
And was there a specific date that prior to which that web history had been deleted?
Yeah, so there on that phone, the web history for that device, that primary device, was basically ended. It picked back up on March 10th of 2022, but prior to that, all of it was gone.
I see. The deletions that you observed on that extraction, can you say how those deletions were made?
No. Like, I would presume that it was completed like most deletions are completed on a phone, which is manual deletion. But there's no indication in the software of, any other means of that, whether it was active or remote or anything like that.
Okay. The data's just not there.
It's just not there.
I want to talk to you about a person came up during this investigation by the name of Josh Grossman. Did you associate a phone number with a device belonging to him?
Yes.
Do you recall what that number was?
The last four is 1260.
And a witness by the name of Carmen Laubert, did you identify numbers belonging to devices that were associated with her?
Yes.
And was there a primary number that was associated with her device?
Yes, and I believe the last four, that was 6127.
Same question for a Robert Crozier. Do you recall a number for him?
Yeah, Indian 0540.
And finally, you're almost done with this test. Mr. Richins' phone number. Do you recall the phone number associated with his device?
Yeah, the last four of 9317 for Mr. Richins.
Thank you.
That passed.
Great. We'll get back to you. I want to talk to you about the defendant's communications with Carmen Lauber. Between the time period, well, let me ask this first. Were you able to determine by other means besides the defendant's phone whether there were communications between those two?
Yes.
And specifically for the time period of roughly January 1st, 2022 and March 15th, 2022?
Yes.
And where were you able to see evidence of those communications?
Through the call detail records.
Whose call detail records?
I primarily focused on the defendants, but also Ms. Lauber's as well.
And what does a call detail record tell you?
A call detail record is exactly what it sounds like. It's a detail of calls recorded through a carrier. It will tell us, tell an investigator or anybody looking at the record when a call or text was made or received, the duration of that call, and potentially location information related to that account as well, or that device as well.
And who stores that information?
The carrier.
So that's separate from the data that's extracted from the phone, correct?
Correct.
So if data were deleted off of a phone, would that still be available through the carrier?
The communication, the timestamps and the direction of the communications would, yes.
Okay. What about location data?
Yes, potentially.
Okay. You say potentially. What would cause it not to be available?
Time, quite frankly, is usually the inhibitor there. But most carriers retains call detail records for a year to 2 years with location history. It could also be that a carrier does not report location data for, say, for instance, text messaging. Some carriers do, some carriers don't.
I see. Specifically, the carrier for the defendant's phone, was location data available for the call detail records that you analyzed?
At the time the records were sought, no.
And do you know why that was?
Time.
Okay.
Yeah, where Verizon retains location information within call detail records for 1 year.
Thank you. I would like to turn your attention, if I can grab a binder of the exhibits that have been pre-admitted here, to Exhibit 33. Have you seen that Exhibit 33 before?
I have.
And what is that?
This is a Facebook Messenger record between Miss Lauber and an individual named Nicole Cummings.
Do you know who Nicole Cummings is relative to this investigation?
I do.
Who is that?
My understanding is a friend of Carmen Lauber, in which the friend is the one in which Carmen received a second phone number for Mr. Cruzier.
I see. Now, turning over to 34, State's Exhibit 34, do you recognize that document?
I do. 34?
Yes. Yes. And what is that?
This is it's like a phone extraction record.
And the bottom input in that record, is there any number there that is relevant to this investigation?
Yes.
What is that?
This is a message, or this is a contact in a device for a number identified as Mr. Crozier's number, the ending in 0540.
And is the name of that contact Robbie-Nick?
Yes.
And is that the same Nicole that we spoke of a moment ago?
Yes.
Now, I don't necessarily need you to go through those, but I'm referring now to State's Exhibit 35. In Ms. Lauber's call detailed records for her device, do you see communications between her and Crozier on February 10th of 2022?
Yes.
And you recall approximately when those began?
It was in the evening. I don't recall the exact time. On the 10th.
Do you see calls between them on February 11th as well?
Yes.
Also on February 11th, through Ms. Lauber's call details records and the defendants, did you observe any text messages between them on that day?
Yes.
Do you recall how many?
About 30, I believe.
And were there any text messages the next day, February 12th of 2022, between Ms. Lauber and the defendant?
Yes.
And you recall when those occurred?
I don't. I want to say midday, but I'm not 100% sure.
Okay. But those would be contained in State's Exhibit 35, that call detail record?
Yes.
And speaking of these, the call detail records, are these in Mountain Daylight Time or Mountain Standard Time?
These are UTC time.
Okay. And UTC is what time?
It's Greenwich Mean Time. It's basically zero. It's a method for everybody to basically stay on the same time zone, as odd as that sounds. Basically, you just add or subtract your time zone from UTC to get local time.
Okay. So if these are in February of 2022, what subtraction would have to be made to find the local time?
7 hours. So during daylight savings, when we fall back in November-ish, we go to -7, and then we spring forward in March usually, where we're -6.
Okay. Thank you. Moving ahead to the February 14th, 2022 call detail records. Did you observe any, sorry, like I went away from that. Did you observe any text exchange between the defendant and Ms. Lauber on that day?
On February 14th?
Yes.
Yes, sir.
You recall approximately how many?
I don't. Not off the top of my head. It's several.
Okay. More than a dozen?
Yes. I want to say 30 again. Seems right.
I want to turn your attention now to State's Exhibit 43. Well, and before we go on to there, I just want to clarify, when you see this call detail record, you're not seeing the content in any of those messages, correct?
Correct. Only that the message was completed, sent and received.
Okay. But when you do a forensic extraction of a device, if those the content of those texts are still on the phone, can you see the content at that time?
Yes.
Okay, thank you. On February 26th of 2022, do you see communications between Ms. Lauber and the defendant on that day?
Yes.
Do you recall when they started communicating?
It was in the evening. I want to, if I recall, around 5 p.m., 4 or 5 p.m. on the 26th.
And you recall when they stopped?
About 10:30 that night.
From those call detail records, specifically from Ms. Lauber's, were you able to see where she traveled that day?
Yes.
And was she at or near a Maverick and Draper that day?
She was.
And how are you able to tell that from the call detail record?
So within that call detail record, AT&T is Ms. Lauber's provider. AT&T does provide location data for SMS messaging. So we're able to determine what tower is being utilized when the Ms. Lauber's device made or received text messages as well as calls.
Okay.
So we put it into a mapping software and are able to determine which tower was servicing the device during any given point in time.
So it's the location of the tower that phone is connecting with, correct?
Yes.
And down in the Salt Lake Valley near Draper, are you able to see multiple towers? Fair to say there's more than one tower in the Salt Lake Valley.
Yes, typically speaking, the more dense the population and the urban area, the more dense the cell phone arrays are.
Does that make it more accurate to pinpoint where that phone is?
Typically, yes.
And is the contrary to that true? The less populated an area is, the less cell towers there are.
Typically, yes.
Speaking specifically about Midway, are there less cell towers in Midway, Utah, than there are in or near Draper, Utah?
Yes, significantly.
Now, when Ms. Lauber's phone appears on those towers near Draper Maverick, was she there on any other dates besides that 26th?
Yes.
What dates were those?
February 11th, 2022, and March 9th, 2022.
Did you observe her phone being tracked in that area on any other time in the records you reviewed? Were you able to track her movements from Summit County to Draper and back?
Yes.
And is that, again, just through tracking the towers that she's pinging off of?
Yes, the tower utilization, yes.
Okay. And we talked a little bit about Midway. Does the precise location become more difficult when she's in a more rural area?
In this case, yes.
Okay. And why is that?
You have less towers serving a larger area, so with a larger estimated range or area in which the device could be in, the harder it is to pinpoint more precise location.
I want to turn your attention now to Exhibit 31. Flip that. Do you recognize what's depicted in Exhibit 31?
I do.
And what is that?
Is a depiction of messaging on a device from January 18th and January 20th of 2022.
And the top of that, the first page there says Kouri. Do you recall whose device these images are taken from?
I believe they're from Ms. Lauber's.
Can you take one more look at those?
I will, yes.
Could those be from a phone belonging to a Hayden Jeffs?
I need to look at the contents.
Oh, sure,
of the
sure.
text, just to make sure I'm looking at the right thing. Yes, I misspoke. These are devices from Mr. Jeff's phone. Or, I'm sorry, messages from Mr. Jeff's phone.
And they start on January 18th and they go to January 22nd.
That's correct.
Of
Yes.
2022.
Yes.
I'm going to ask you to flip to States Exhibit 36. Do you recognize the record depicted there?
I do.
Is that for the number ending 1987, the device belonging to the defendant?
It is, yes.
Was there a call made at 8:53 a.m. on February 14th?
Yes.
And do you know who that call was made to?
I do.
Who's that?
Mirror Lake Diner.
And moving to State's Exhibit 38, are these call detailed records for a number ending 9317?
Yes.
And did that belong to Eric Richins?
Yes.
Was there a phone call between Mr. Richins and the defendant at about 11:09 a.m. that morning?
Yes.
And is there a record of a photo being sent or some sort of multimedia message at 11:27 that morning?
Yes, and that was obtained via Mr. Richins' device.
Okay, so that's not here in the call detail record. That's in
It's his physical device. Yes.
Okay. Were you able to see what that image was?
No.
Was that deleted from his phone?
It appeared to be yes.
And were you able to see that on the extraction of the defendant's phone?
No.
Why is that?
All of that was presumably deleted from the defendant's phone as well.
Did the activity on Mr. Richins' phone on the 14th of February 2022, did that cease between 11:39 a.m. and 1:32 p.m.?
Yes.
Was he active on that phone before and after that dead period?
Yes, he was.
And can you describe the volume of his activity?
Yeah, it would be what I would describe as normal phone traffic for that device. Calls and texts between friends, business-related things of that nature, yes.
Now, I'm not certain it's made it into the binder. Let me... I've handed you what's been marked as and admitted as State's Exhibit 7A. Do you recognize that?
I do.
What is that image of?
This is a screenshot obtained from a device of the defendant's phone, her navigation app within her device.
And is that from February 14th of 2022?
It is.
So this has not been deleted, correct?
From the defendant's phone, it was not in the defendant's phone. It was in Mr. Grossman's phone.
Okay, thank you for clarifying. Did that originate from the defendant's phone?
Yes,
Was that sent to Mr. Grossman?
it was.
And was that sent at approximately 9:48 a.m. on February 14th?
Yes.
What? And can you just give a little more description about what that navigation shows?
Sure, it's a typical screenshot of a normal navigation application. There is a location on Rockcliffe Road. The device is it's depicted that the device is traveling northbound, and it gives an arrival time, an estimated time of arrival, and a mileage for that trip that it's depicting.
And on Mr. Grossman's phone, were you able to read any text messages surrounding this time frame?
Yes.
And did the defendant indicate why she was sending this to him?
Yes.
Why is that?
She said she was on her way to see him. He asked if it was about an hour, if she was about an hour away, and she said yes and sent him this screenshot to verify her ETA.
speaking to the defendant's communications with Mr. Grossman, do you recall approximately when those began?
For the 1152 number, which is the first one I'm aware of, it began, I have a trail, basically a digital trail on that phone beginning in November of 2021.
And what was the volume of text calls, anything of that nature, up until March of 2022?
The volume varied depending on the day, but it was pretty much daily communication between the two during that time frame.
And are these phone calls and text messages?
Mostly text, but yes, some phone calls.
And have a number of those texts been recovered from Mr. Grossman's phone?
Yes.
And if I could just have you just thumb through exhibits 29 and 30. Are those excerpts from the extraction of Mr. Grossman's phone?
Yes.
And are they approximately December and January of 2021, 2022?
Yes.
And if I could have you thumb through 39 through 42. Are those also excerpts from the extraction of Mr. Grossman's phone?
Yes.
And are those roughly the time frame of February and March of 2022?
Yes.
And finally, the three exhibits, 44, 45, 46. You could look at those. Similar question, also excerpts from Mr. Grossman's phone?
Yes.
And are those specifically March 2nd and March 3rd of 2022?
Yes.
And finally, exhibits 50 and 51, if you could look at those. Also excerpts from that extraction?
Yes.
And a little bit later in time, March 20th and April 9th?
Correct. Yes.
So it's fair to say around the time that Mr. Richins passed away, there were ongoing messages between the defendant and Mr. Grossman?
Yes.
I'd like to ask you now about the extraction from the defendant's phone relative to the morning of March 4th, 2022. We discussed this at the detention hearing, correct?
Yes, we did.
And at that time, you were relatively new to this case?
I was, yes.
Have you had a chance to analyze further the data on the defendant's phone regarding that date?
Yes.
I'd asked you at that time about movement on the phone at approximately 3:08 a.m. Do you recall that?
I do, yes.
Are you able to say at this time whether that was the phone itself moving or a connected device moving?
It appears to be a connected device.
And when you say a connected device, what does that mean?
In this case, I believe it to be a smartwatch. It's a device connected to the, like, for instance, the defendant's cell phone that is tracking movement data.
I see. When was the defendant's phone first unlocked that morning?
Right before 3:07 a.m.
And this movement activity, when did that take place?
3:08.
Do you recall how far the connected device moved?
I believe it was about 250 feet.
And was there a series of unlocks on that phone in the next 15 minutes?
Yes.
Was there additional movement around 3:21?
Yes.
Do you recall approximately how much?
I believe it was around 140 feet, 143 feet, roughly.
Do you see a 911 call on that device?
Yes.
What time did that happen?
Just after 3:21 a.m.
Do you recall if that approximately 140 feet movement was made before or after the 911 call?
Exactly.
So in about that 15-minute time frame, the connected device moved about 370 feet.
Correct.
Your Honor, if I just said one. Thank you, Mr. Kouri. Those are all the questions I have for you this time. Thanks.
Afternoon.
Afternoon. How are you?
Doing great. How are you?
Good.
Good. All right. Let's talk about, go to State's Exhibit 45, please.
Okay.
Let me know when you're there.
Okay, I'm there.
Mr. Hill had you review Exhibits 44, 45, and 46. Do you recall that?
I do.
And he asked you whether that indicated there was communication between Ms. Richins as well as Mr. Grossman. Do you remember that?
I do.
Okay, so let's go to 44. And on 44, how is one of the senders or the parties identified as?
On 44,
Yes.
we have Mr. Grossman.
Perfect.
Yes.
And then let's go to 45. And how is one of the parties identified as?
My princess.
And then above that, where it says under party, first number 1, it says from, and then it has owner.
Yes, 9317 is Mr. Richins' number.
So that is not Mr. Grossman?
Correct.
Okay. So just to clarify, going back to Mr. Hill's questions, your testimony that what was included in Exhibit 45 was Mr. Grossman, that was incorrect.
Yes, I was mistaken.
Okay. You indicated that you were asked about the usage on the phone, about whether it was, you indicated it was normal tracking for that device. Do you recall that? And Mr. Richins' phone, just now.
About normal usage. Is that what you're referring? Yes, I do remember that. Yes.
Phone calls,
Yes.
text messages.
Yes.
Okay. Interestingly, you said normal tracking for that device. I suspect you mean for that person.
They can be one and the same. Yes.
The device doesn't do anything by itself.
Right, it has to be manipulated. or
Correct.
Activated, yes.
So when you say normal tracking for that device,
Yes.
you mean normal usage by the person who that device belonged to?
Typically, yes.
Okay. You have no way of knowing really what the normal usage is unless you review everything, correct?
To the number, no.
Correct.
Yeah.
Perfect. You indicated that when responding to deletions on Miss Richins' phone, you indicated that it was from everybody.
Yes.
Okay.
Pretty much, yes.
Was there a time frame for that?
Yes.
And what was that?
January through March. About March 10th or so.
And that was for which phone?
It was for the 1987 number.
Perfect. Testified about attending a Celebrite certified operator course.
Yes.
When was that?
2017.
Have you been recertified since then?
I have not.
A Celebrite physical analyzer course as well.
Yes.
And when was that?
The same time, 2017.
Then a 40-hour cell phone analysis and mapping course.
Yes.
That one was not through Celebrite. That was through Zetex and Trax. Is that what it was?
ZX is the company.
Correct.
Trax is the program. Yes.
Thank you. And so separate from Celebrite, but when was that?
The initial was, I believe, in 2013, and the subject matter expert class was in 2017.
And have you been recertified in that?
No.
The Trax technology gathered from the testimony, that's related to mapping?
Yes.
Okay. And is that what you used here?
Yes.
Now, you were retained by the Summit County Attorney's Office, is that correct?
Correct.
Were you hired by anybody else?
No.
And it was specifically to evaluate the digital evidence in this case,
Yes.
to analyze it,
Yes.
specifically phone extractions
Yes.
of Eric Richins,
Correct.
of Kouri Richins,
Yes.
of Carmen Lawler,
Yes.
others.
Yes.
Now, to be clear, you didn't perform the extractions.
Correct.
Who performed queries on any of her phones?
I believe the RCFL did those.
Who at RCFL?
I don't know that.
Who did the extraction on Eric's phone?
I don't know.
Who did the extraction on Carmen's phone?
I don't know.
What about the other phones?
I don't know. The examiner's name is in each report, but I don't know them offhand.
So you didn't perform the extractions. You weren't present when they were done.
Correct.
In fact, I think, if my timeline's correct, you were hired after the extractions were done.
Yes, for most of them, yeah.
So you don't have the benefit of having observed the extraction examiner do the extraction
Correct.
or validate the results of the extraction.
Through the examiner, no.
And you don't have the privilege of observing the extraction examiner perform manual decoding methods
Correct.
or manual decoding methods in the hexadecimal code.
Correct.
You didn't confirm whether the extraction examiner validated their extraction tools.
No.
Let's talk about the Celebrite extraction process.
Okay.
We're going to go from the device to the data.
Okay.
Okay? That, I'd like to be so visual. So this is a target device.
Correct?
Let's
Okay.
assume this is a target device.
Okay.
Let's hope it's not a target device for my sake.
Right.
This is a target device. We're going to say that this right here is UFED. Okay? So that is the Universal Forensic Extraction and Device, correct?
Yes.
That's what it stands for?
Yes, he further, yeah.
Your Honor, I'm going to make an objection to this point as to relevance. I don't know that this is necessary at this point in time to a probable cause standard.
I'm not sure where we're headed, so I'm going to give Mr. Ramos a little latitude here until I know where we're headed.
Thank you.
This is UFED. Okay? You're going to plug this into this, and then what it's going to do is it's going to spit out something.
Yes.
Correct?
Yes.
I mean, it's not the technical term, but. So once we have that, it's in a raw format.
Correct.
Now, you have been given, when you were brought on, the output, what it spit out,
Correct.
right?
Yes.
Okay. So your testimony, both at the detention hearing and here, is based on this, on the
Yes.
spit out version.
Correct.
Okay. You have not received the raw data.
There is raw data available, but
Correct.
no.
Correct.
Yes.
There is raw data available. You have not received it.
Correct.
You have not analyzed it.
Correct.
You have not cross-referenced it with what you were given.
Correct.
Perfect. Now, let me pause. When you state that information was deleted, it doesn't tell you in what you've been given how that happened,
Correct.
why that happened,
Correct.
where it happened.
Also correct.
The raw data could potentially hold that.
Potentially.
Now, you use Celebrite, these extraction tools, you rely on them to provide you this information so that you could then assist, in this case, the Summit County Attorney's Office, with their case, correct?
Correct.
With meeting probable cause standards.
Correct.
In terms of location of individuals,
Yes.
such as Miss Lawler.
Yes.
Okay. Now, to be clear, I only have what you've been given as well. So I'm relying on the information that has been spit out, but not on the raw data, just so we're clear.
I want to talk to you about your validation process.
Okay.
Validation of data.
Okay.
As, or having been rather, certified, you know the importance of being able to validate the data that you review.
Yes.
One of those methods is possibly to use it with the, or compare it to the raw data. That's one way.
Yes.
Another way is perhaps to use the cell data location from call detail records
Yes.
in terms of location.
Yes.
Now, when you use the software, that was a form of validating, sorry, I apologize, the, what did you call it? The TRAX technology, that TRAX software.
Yes.
That's a way of validating whether the information that you received is accurate.
Correct.
You talked about the cell towers.
Yes.
Now, this program, we're going back to spitting, does it spit out something for you?
It does.
Okay. Now, have you provided that to the Summit County Attorney's Office?
Yes. You're talking about the mapping?
The mapping?
Yes.
Okay. And are those towers that you referenced earlier, are they sectorized or omnidirectional?
They're sector.
Okay. When you use that program, were you aware at that point that software had been found to be unreliable in courts?
I'm not aware of that.
You've not been aware of it.
No.
But you haven't been certified since 2017.
I've been certified since 2017, but I have not. There's no need for a recert on that course. It's a learning, and then it's a continuing education.
What software version did you use for the tracks software?
Off the top of my head, I don't know.
When you did it, was it the most up to date?
Yes, as far as I knew.
Had you updated it since 2017?
Yes, it's web-based, so it's updated constantly. So you can rely on the fact that if you're updating, say today, that it would be the most up-to-date software package.
And what about Celebrite itself, your Celebrite certification process?
Yes.
There are no requirements
Correct.
to recertify,
Correct.
but they do recommend that you recertify
They do.
every 2 years.
They do. Yep.
But you've not done that.
Correct.
Along those same lines, there is no state of Utah, say, standard for mobile forensic extractions.
Not that I'm aware of, no.
There's no national one.
No.
There's no international one.
No.
It's pretty much whatever Celebrite says.
Well, they're one company.
Correct.
So,
To my point.
yeah.
Did you review or were you given rather any mobile data sets from the individuals who performed the extractions on all these phones? Like sample data sets, controlled data sets?
No. No, it wasn't.
Are you familiar with external enrichment?
I'm not.
Or you had indicated rather, you were asked about the activity sensor of an Apple Watch.
Yes.
How did you determine between the detention hearing and now that it was in fact an Apple Watch?
A review of the download stated based on the Celebrite extraction that it was a connected device.
Now, are you qualified in mobility metrics?
No.
Do you know what mobility metrics are?
No.
You testified about the distance that was covered on the morning of March 4th by a connected device.
Yes.
And you were very specific on the number. Okay?
Yes, more or less. Yeah.
But you don't know how that number was calculated.
I don't know the internal calculation process of the devices, no.
You just read it.
Yes.
You read what was spit out.
Correct.
You don't have the data, the raw data. Correct?
Correct.
So everything you've testified to is basically because you've read it.
Well, yes, and the extractions from the devices, but yes.
Correct. Just what was given to you.
Yes.
Were there items that were deleted from Mr. Richins' phone?
Mr. Richins' phone?
From Eric's?
Not that I'm aware of.
But it could be.
Could be.
Have you ever worked with Mr. Todd Gabler?
With? No.
Alongside?
Alongside and, quite frankly, against.
On this case?
No. Well, with, yes, on this case.
With on
yes.
this case. And has he provided information to you?
Yes.
Has any of that information been used in your testimony today?
No.
I believe that's it, Judge. If I could just have a quick second.
Take them all. Ms. Nestor, just push the button.
Thank you.
Just a couple more, Your Honor.
Go ahead.
Has the Richins family ever hired you?
No.
Have they ever paid you?
No.
Is the money?
I did sound quieter.
Did sound quieter.
Let us just check for a second, folks.
It sounded like my conscience was speaking.
Like my mic is muted. Brittany, you broke everything.
Way to go, Brittany.
Yeah, my mic is muted. Why would we need something that's going overhead? I think, well, the things going overhead are muted, so
A lot of things go over my head.
there we go.
Oh.
Have they ever paid you?
Yeah, that's perfect. What was provided to you by Todd Gabler?
Off the top of my head, mostly tolls.
Tolls?
Yeah. Yeah. Call tolls, toll records from the Verizon toll records.
No further questions. Thank you.
Mr. Gillen, you redirect?
Just briefly.
Okay.
Mr. Ramos asked you about any deletions that you observed from Eric Richins' phone, and you had previously testified that a picture that he sent on the 14th was deleted. Is that
Oh,
right?
yes, that's correct, yeah.
How could you tell that that was deleted?
Well, it's not present any longer. It shows a file path that it used to exist, but the image itself is not there.
And so to follow that, when he asked you if there's anything else that's deleted, did you see anything similar to that picture or any remnants on that phone or relics that showed deletion the same way that photo did?
Not that I could recall.
Thank you. That's the only question I asked.
Mr. Ramos, anything on that?
No, Your Honor. Thank you.
Can we let this gentleman step down? Mr.
Yes.
You can step down, sir. Thank you.
Your Honor, can I suggest please, a brief recess. Mr. Burmister's going to set up the computer
Okay,
for about an hour.
no problem. Why don't we take a 5-minute recess? Who's testifying after the recess?
Your Honor, Ms. Carrington, Brooke Carrington.
Okay, she's present.
She is.
All right, we'll take a 5-minute recess. Thank you. Court's in recess. Thank you.
All right, so you guys remember Daisy Link. For those that were with us for the Daisy Link trial, which happened last year, there's OS updates, right? OS updates. I think my OS, I've got an iPhone updates maybe every 3 months or so. And specifically, Daisy Link, that trial was happening in 2025. Oh, Aussie, thank you so much. Oh, look at that. You've got, I'm not sure how you pronounce that. Jadziadax received a gifted membership. Mike got a gifted membership. Silver Fox got a gifted membership. Holy smokes. Awesome. Awesome. Thank you so much, Aussie. Good job. You got 3 people that are actually in our chat right now. And then hardcore Barbie Meow got one. All right. Fantastic. Thank you, Aussie. You got 3 out of 5 people that are in chat. Good job. Aussie Gardner for the win. Whoop. Fantastic. Cool. Now you guys get to use emojis. Chat, show them what emojis are there. We got Super Ball. We got fitted for the orange pantsuit. We got Jim. Awesome. All right, cool. All right, so just real quick, okay, with Daisy Link, that trial was 2025, and then in 2022, they did the extraction. The extraction is the same, but processes provide different data. So technology changes and improves. Didn't do additional extraction, but additional processing. And Aaron's working on new emojis. All right, cool. Aaron's working on some new emojis. So he hasn't been certified in 7 years because this was from 2024. And 2017 was his last certification. That's not good. I mean, data is the data. I get that, and it shouldn't change, but it does. The technology improves. Celebrite improves their data extraction as well. So I don't know about that guy. That's a little sus in my book. I'm not so sure. I'd be like, you do realize technology updates. You do realize that, right? All right. So we have 2 hour and a half more to wait around until they go live. Remember, they're going to be an hour delayed, but by noon our time they'll be live. So I have an hour and a half to kill, as it were. Here, let's do this. Let's change it up just a little bit. I really want to get to know these lawyers. You guys were like not really keen on them. I want to hear what these guys have to say. So this is an interview.
In an unprecedented.
Sorry. This is an interview with these 3 lawyers. So yeah, let's get to know them for a little bit. All right. Hey, Michael, good to see you. How are you? Let's see. Sparkling Princess. Yes, no reason to not take another course or so since 2017. I don't like that, right? That's just re-up yourself. I mean, at least I would think every year. Personally, I would think every year, but is that really going to make a difference to the jury? They're going to be like, I don't know. We'll see. We'll have to see. All right. So this is an interview from October 15th of 2025. So interview from October 15th of 2025. I know some of you are saying you don't really like them too much, but hey, BFM Cookies, good morning. So let's see what they have to say. In an
unprecedented move.
We were willing to take an unusual step of coming forward.
Look, I never thought I would be sitting here.
Kouri Richins' attorneys
She is distraught. She is heartbroken.
reached out to 2 News Investigates
That's exactly why we came here. And really, it's an ethical duty.
We have a lot of confidence in you.
to set the record straight.
One thing that's been reported on that they have let go, have not corrected.
If their goal is justice, they have not lived up to it, at least in this case.
A 2 News exclusive.
And I feel that when I see these narratives come out, it becomes a game. It becomes another line. And we forget that there's somebody on the end of that. And that's a client. That's a human. That's a mother.
A Camas mom charged with murdering her husband.
The narrative is that your client is the Moscow Mule murderer. Is that accurate?
A narrative of alcohol, drugs, and greed.
There are certain things that are out there that we know right now, sitting here today, just aren't accurate.
And her attorneys say false information.
I do think the prosecution has declined to correct false information that has come out in the media, and we've waited and hoped that that would occur, and it never has.
Tonight, Richins' attorneys speak out only to 2 News Investigates.
That's a very, very different narrative.
Camas, Utah, a small town in Summit County with about 2,000 residents. Among them, Kouri and Eric Richins and their 3 boys.
Their family was so beautiful. Everything was picture perfect.
Linda King used to work with Kouri Richins at Home Depot and remembered Eric, who was a contractor coming into the store.
You could never forget his laugh. And I love that laugh so much.
Linda says she encouraged Eric to ask Kouri out after she caught his eye.
I says, go over there and check out with her, so they did. And anyway, they ended up having a date. From then on, they were like glued to each other, it was perfect, I thought.
Perfect until March 4th, 2022, when Eric was found dead inside the couple's home. Police originally ruled that there was no foul play in Eric's death from fentanyl. Then a year and 2 months later, things changed. On May 8th, 2023, Kouri was charged with her husband's murder. Prosecutors have added additional counts of financial crimes as well. As of today, Kouri's charged with aggravated murder, attempted criminal homicide, 2 counts of insurance fraud, and forgery.
Wendy Lewis, and I am lead counsel in the Kouri Richins case.
Kathy Nestor, I am one of the attorneys on the Kouri Richins case.
Alexander Ramos, co-counsel on the Kouri Richins case.
Wendy Lewis, Kathy Nestor, and Alex Ramos took over as Richins' attorneys in May of 2024 after her previous attorney declared a conflict in the case.
What we came in here today were to focus on 4 very serious areas that have been absolutely factually reported incorrectly and that have been discussed publicly in court, in open court. I do think the prosecution has declined to correct false information that has come out in the media, and we've waited and hoped that that would occur, and it never has. And so that is why now, at this moment, at this time, we're coming forward and saying, well, then we're going to correct it. So that's where we are, and that's why we're here.
First up,
the narrative is that your client is the Moscow Mule murderer. Is that accurate? Can you confirm what the murder weapon is?
I can't confirm what the murder weapon is because the prosecution has never told us their theory. They have never said that it was given in a Moscow Mule, that fentanyl was distributed or in a Moscow Mule. During the preliminary hearing, their lead detective was on the stand, and I asked him the question, sitting here today, do you know how Kouri Richins administered fentanyl to Eric Richins? And he said, no. The prosecution has never said that it was in a Moscow Mule. That came up because there was discussions, and I believe a statement by Ms. Richins early on, that she and her husband had drank a Moscow Mule before dinner. So that was something that was just grabbed onto. It's sexy, it's interesting, the Moscow Mule murderer, but the prosecution has never said that that is their theory of the case, not once. I still, sitting here today, don't really know how they're going to claim that Eric Richins ingested fentanyl.
Does the prosecution have an obligation to correct the record, the public record of this?
I mean, it's the prosecution's job to bring justice. That's what you do as a prosecutor. As a defense attorney, you protect your client's right. A prosecutor needs to find justice, fight for justice. And I believe by not correcting the record, by letting falsities sit out there, that's not what is happening. Now, we'll see what happens in the courtroom, but that, in our view, is something that they should have corrected.
Can you confirm then that the fentanyl was administered in the Moscow Mule, given what you just said about the lead detective O'Driscoll? He couldn't confirm it, correct?
We cannot confirm what their theory is. We believe Ms. Richins is innocent. And, we're not here to convince you or anyone else that she's innocent other than those 8 people that are in the box at the trial. Those are the people we need to convince that she's innocent. So that's not why I'm sitting here, but we do want what is accurate to be out there. A lot of it will come out at trial, but there are certain things that are out there that we know right now, sitting here today, just aren't accurate. And the Moscow Mule appears to be one of them. Now, since they have not ever said to us exactly what they think their theory is, I suppose we could be surprised at trial and they'll say, oh, it was the Moscow Mule after all. But they have never stated that in court, ever, or in any pleadings or in any way.
The prosecution has painted your client as the Moscow Mule murderer. What is your opinion on that?
The Moscow Mule has never been stated in open court as being used to cause someone's death. I'm not sure where the press came up with that, but the lead detective has testified under oath that as of now, he does not know how fentanyl arrived in Mr. Richins' body. And so the press claiming that there's a murder weapon, that this was it, is just wholly fanciful. It just didn't happen, and it's not ever been said by the prosecution in this case, and it's never been in a pleading in this case, and it's just inaccurate.
Second was Kouri in financial distress because of her real estate business. Prosecutors have said at the time of Eric Richins' death, Kouri Richins Realty owed hard money lenders more than $1.8 million.
Kathy, before this, was your client solvent?
So that's one of the issues we felt compelled to speak to the press about. There has been quite a bit of reporting about my client's financial situation. And the concern that we have is that the reports that have come out about her business, the solvency of her business, utterly failed to take into consideration a huge piece of property that she obtained 2 days after her husband passed away. And that's removed from all of the state's calculations. So the equity in that house alone, the value of that one piece of property was enough to cover any debt that she had in her business. And we just feel that that is improper reporting, that arbitrarily cutting off what condition her business was in prior to her husband's death without taking that into consideration is misleading. Furthermore, all of the reporting that is done only focuses on what we call debt service, not the actual value of the property she held. So that's completely being kept out. So it would be like if they said, Ms. Halloran, what is your net worth? And you left out your house. I mean, that's a piece of property is an asset and it has value, and that's never taken into consideration. And so we believe that that has also been misreported, and that's something we felt ethically compelled to come forward and correct.
Third, life insurance.
Well, another one that's out there is false is that she took out hundreds of thousands of dollars in life insurance on him shortly before he died. That's not true. She took out one policy that came in the mail, and it was one of those mailers we all get from our credit union saying, sign here for $100,000 free life insurance. Sign here for yourself, sign here for your spouse. You can get $100,000 free life insurance. That was sent in. She sent that in about a month before he died, 4 or 5 weeks before he died. All the rest of his life insurance, and he had a lot of life insurance, was all taken out by him long before that. And he knew of all the life insurance policies that were out on him. And we don't know if he knew of that last one. But in terms of her taking out a life insurance policy on him, that's the only one, $100,000. So their motive, according to the state, is, oh, she took out life insurance, she was going to cash in on all this money. And again, that's not accurate. I mean, she took out an extra $100,000, which may seem like a lot to a lot of people, and it is a lot, but to this family, the other life insurance was well in excess of that last $100,000. And that amount of money for this family was not really all that much.
Does the prosecution have an ethical obligation to correct these things that are out in the narrative?
Again, I think if what they want is justice to be served, they have an obligation to do that. Of course, their real obligation is in the courtroom, and we'll just have to see what happens then.
And the final point? The Google searches regarding how much fentanyl it would take to kill someone.
There are a number of things. You talked about the Moscow Mule, which we believe is not their theory. They've never said it was their theory. And I think the facts that come out in trial will make it very obvious that that isn't even a possibility. But one thing that's been reported on that they have let go, have not corrected, is that Ms. Richins Googled how much fentanyl does it take to kill someone. And that's been in the press, and it's been extrapolated from that she Googled that before Eric Richins' death. And that's just not the case. We've discovered through court records, through exhibits, that she Googled how much fentanyl does it take to kill someone a day or two after she was told he died of fentanyl poisoning, not before. Which makes perfect sense. She doesn't know how her husband died. She's told, your husband died of fentanyl poisoning, and she's looking, well, what does this mean? How much fentanyl would someone have to take to die of fentanyl poisoning? That's a very, very different narrative than to leave it out there that, oh, the Moscow Mule murderer Googled how much fentanyl does it take to kill someone. No, that's not what happened.
One thing that's also been different in this case for the attorneys is how the prosecution is handling it.
The language that the prosecution uses in its filings, do you feel at any point that they have crossed the line?
Yes, this has been interesting. I have not seen the personal language in filings typically in court that we're seeing here. The prosecution does seem to have a very strong opinion on this case, not just here's the evidence. They seem to have a personal opinion, which I think is reflected in their pleadings and has been reported on, some more than others. The poppycock memo was one that got reported on, which is surprising and unusual to see language like that in legal pleadings. So we've been uncomfortable with that. I see the prosecutor's job, like I said, is to fight for justice. It's not personal. It's not personal for them, and it shouldn't be personal for us either. We're all there doing our job. We're there to protect our client's rights. We're there to make sure our client gets a fair trial. They're there to serve justice. And what they think is justice and what we think is justice is very often the opposite. But it begins to get personal sometimes, I think, when it's a case that it is high profile. There is a lot to it. They've been working on it a very long time. And, I can see that sometimes you can't help but get personal. Sometimes we can't help but feel personally upset about our clients. It's hard. It's a job, but it's hard. Some prosecutors are better than others at not making it personal. It's just been my observation, and maybe I'll be proven wrong at some point in the future, but this has become quite personal for them.
So why did the defense attorneys come to 2 News Investigates? Why now? Why not just correct the record at trial?
Look, I never thought I would be sitting here. I don't think I should need to talk to the media. I really believe that I should be able to get a fair trial. But the way that this case has gone, I don't think we can do that. We have to make sure that when we step in there in February, that we have leveled the playing field, and we can't just hope for that.
Is that why you came to me?
That's exactly why we came here. And really, it's an ethical duty. There's a rules of professional conduct that says if we think that there are facts out there that have been laid out in such a way that we think goes against our client's best interest, that we have a duty to come out. I think some defense attorneys do hide behind, hey, I'm just not going to speak, no comment. And I think that's fair. I do it a lot. But this is different?
Because we don't get an opportunity to argue the facts until we're in front of a jury. The judge decides the law, a jury decides the facts. And what's in the narrative right now and in the public media is facts. So we won't have that opportunity until we're at trial and the jury is sitting in the box. And like I said, our concern is, can she get a fair trial when all of this is out there before we ever get an opportunity to show our side of the story and to show what we believe really happened in this case.
What do you believe happened in this case?
We believe that she's innocent, and the rest will come out during the trial. Because like I said, it's the people in the box that we need to convince, not the viewers, not anyone else. We just want to make sure that people don't come into that trial believing things that are absolutely false. We don't want to spend the time in the trial convincing people that what they've already heard is wrong. We want to spend our time, presenting our case without having to go back and argue against what's in the media.
Is the prosecution in this case injecting a false narrative to the media?
I don't know if they're necessarily injecting it, but they're certainly not correcting it. And I think that's why we're here today, is we honestly feel that we have an ethical duty when we have a client who is facing such serious charges and there is misinformation out there and it is not being corrected. It's a disservice to justice.
With that said, then, how critical should the public be with this narrative? Or is the public just taking the prosecution's statements and narratives at face value because it's the prosecution, it's the state of Utah?
I think that's part of it. I think also it's easy because of the headlines to just go along with it. And when somebody who we trust, right, the county attorneys throughout this state, the district attorneys, we trust that they're going to make the right choices when they charge, but also it doesn't end there. It's also through the prosecution of a case. And with such a high profile case, I think the public needs to be even more critical, because if what's going on in this case goes on to a lesser degree in other cases that don't get the exposure, that don't have the appropriate resources, that's when our country starts to become in danger.
And if I may ask you this, I'm not sure if you will answer, but has the Summit County Attorney's Office vilified your client?
It's not their job to either vilify or create or make them insane, but it is their job to stick with the facts. And that's something that they have not done in this case, especially with how it's been portrayed in the media. If their goal is justice, they have not lived up to it, at least in this case.
Why reach out to 2 News Investigates?
I don't know. I mean, we have a lot of confidence in you, and we're hoping that you can get the word out, and that it's kind of the one pebble in a pond, right? That once you throw a pebble in, and the waves spread out. And we're hoping that once we correct it in one place that's credible, that's a well-known news source, that maybe the other news sources will also start to question a little more about what they're hearing and what they're covering, just so that the importance is that the facts that are reported accurately, and we really appreciate the opportunity to come forward and correct what we think has gotten out there incorrectly.
When you hear these false narratives and you know what you believe to be the truth,
it's extremely frustrating. I think being a defense attorney, being a judge, a bailiff, it feels routine. You possibly in your job, when you're doing things, feel routine, but you're doing so much in your job that means something. And it's no different in the courts. We walk in, we joke around, we know everybody. At the end of the day though, we're doing something very special in there. Every single hearing, and especially when we're in trial. And what we're doing is we're upholding the Constitution. And that's a very high bar. And I feel that when I see these narratives come out, it becomes a game. It becomes another line. And we forget that there's somebody on the end of that. And that's a client. That's a human. That's a mother. And it does really frustrate me.
is Kouri aware of these narratives, and how did she handle what you claim is misinformation being spread about her?
She is distraught. She is heartbroken. This has been very, very difficult for Ms. Richins. She's been in jail now for over 2 years on these charges and doesn't have an opportunity to really tell her story until we're in trial. So yes, it's been very difficult on her.
I asked Summit County Attorney Margaret Olson and Chief Prosecutor Brad Bloodworth for an on-camera interview for this report. I received the following statement. We are aware of the recent filings submitted by the defense. We will address all matters related to this case through the legal process rather than in the media. Our formal response will be part of the public record next week. We ask that this comment be included in your report to ensure our position is accurately represented and the reporting remains balanced.
Yeah, so they chose not to talk to the media. They just put out a press statement instead. Yeah, I don't know. That kind of I'm agreeing with a lot of you in chat in the sense the defense is saying she's not going to get a fair trial because of media attention and all this stuff. You're tainting the jury pool. What if potential jurors saw that report and now they're thinking one thing or one way or the other. All right. You guys asked to see the why Sky left again. Here is a couple news reports because we still have about an hour and 15 minutes or so to go. So.
Thanks for joining us here for the news at 5. I'm Sarah Murphy. Brian McElhatton is on assignment. We're following breaking news out of Summit County for you. A closed-door hearing in the high-profile Kouri Richins case just wrapped up. The judge granted a request from the defense team to withdraw from her case, saying they can no longer represent her. Now, Richins is the Camas woman accused of fatally poisoning her husband in 2022 and then writing a book about grief. Court documents filed last week show the request may be linked to her civil cases. So to give a bit of context, ABC4 spoke to a local criminal defense attorney not involved in this case to hear his expert opinion on this new development.
Now, it seems that reading into that, there's some kind of conflict with the law firm that the defense attorney works for, which is a large entity, many attorneys, many other clients that the law firm represents.
All right, so the next step is a court hearing that's scheduled this Friday at 10 o'clock a.m. Turning now to Spanish.
So Sky Lazaro leaves citing an ethical mandate from an irreconcilable and non-waivable situation. Was it because Kouri didn't have any money? Was it because the civil case is now being held over? Was it because Kouri was talking trash about her from jail? Could have been any number of things. Could have been any number of things. Here's also, this is from the 24th. We played this yesterday too, but we'll play it again. I think some of you were saying that Kouri was talking trash about.
It has been a busy day for Kouri.
Kouri was saying some bad things about Sky Lazaro from jail. Did she run out of money? All kinds of things. Who knows?
And it has been a busy day for Kouri Richins and her murder case. Just 3 days after her attorney, Sky Lazaro, withdrew representing her in her murder case, a new law firm has been appointed. And this comes just a short time after recordings of Richins in jail were released. Now, ABC4's Annika Johns joins us with the very latest in this trial.
To be able to speak out for the first time is terrifying, but is much needed. The world has yet to hear who I really am, what I've really done, or what I really didn't do.
From behind bars, the Utah woman accused of poisoning her husband is breaking her silence for the first time. In audio released to ABC4's affiliate, ABC News, Kouri Richins shares words of her innocence and is asking for the world to give her a chance.
Give me a chance to prove it to you. I'm going to show you the facts. I'm going to show you the evidence. I will not give up. I will not give in. Please, just give me a chance.
The audio was released just days after her attorney Sky Lazaro filed a motion to withdraw from representing her.
Okay, this is 231-500-139, State of Utah versus Kouri Richins.
Today in court, a brief hearing was held where Richins' former attorney was officially relieved of her duty.
Ms. Lazaro, your motion to withdraw is granted. You are being removed as counsel from this case.
And now Wendy Lewis, Catherine Nestor, and the team at Nestor Lewis PLLC are the newly appointed faces tasked with representing Kouri Richins.
We have a newly appointed indigent defense counsel, Ms. Lewis.
According to the law firm's website, Lewis and Nestor started practicing law together in 2022. And now, moving forward with this case, the two of them have been given time by the judge to get familiar with the case. He canceled and rescheduled the preliminary hearing originally set for June 18th.
We are staying any briefing deadlines related to the motion to disqualify or the motion to suppress.
The motions the judge is referring to are first the motion to disqualify state prosecutors from the case. The second is a motion to suppress the 6-page walk the dog letter the Summit County Sheriff's Office located in Richins' jail cell late last year.
What I've really done is protect Eric at all costs. What I really didn't do is murder my husband. I could not and would not ever do that to Eric or anyone for that matter.
That was ABC4's Annika Johns reporting.
All right. So now let's get back to the most recent hearings. This one was from December 8th, and then we're going to hear one from January 2nd, and then we'll roll into the trial or into the hearing. We'll be, it's going to start. It's an hour delay, so it's starting 11 Eastern, 9, what are they, Mountain? I guess Utah's Mountain. Yeah, so 11 Eastern, 9 Mountain, but it's an hour delay, so it'll be noon Eastern, 10 o'clock Mountain. So until then, we have two more brief hearings. This one's only about a half hour. The other one's about 20 minutes. So let's hear this one. Let me just get us queued up here. So we're getting close to when the today's hearing is going to take place.
This is 251.
Okay, so again, this is from December 8th. Just cue this up for us. All right. Move this over here. Okay. So this is from December 8th of 2025. So just last month.
500162, State of Utah versus Kouri Richins. Mr. Bloodworth, on behalf of the state, Ms. Richins, this is a new set of charges. We've handed you a copy of the information showing them. Do you have that? Okay. I don't need to read it to you unless you'd like me to.
We've waived reading.
All right, very good. I am appointing Wendy Lewis, Catherine Nestor, and Alexander Ramos to appoint to represent Ms. Richins in case ending 162, at least through the first scheduling conference in that new matter. And we're going to set that. How about April 17, Council? Is that agreeable? Mr. Bloodworth?
Yes, sir.
At 1:30 p.m. April 17, 1:30. Mr. Bloodworth, anything else on the new case?
No, sir.
Sorry, Your Honor.
That's okay. April 17, 1:30 p.m. for a scheduling conference. We Brittany will inform the county manager that you've been appointed on the new case through that date at least. Okay, anything further on that case, Ms. Lewis?
No, Your Honor.
Okay. Let's return to case ending 139. We're here for a pretrial conference. Mr. Bloodworth, what is it that your team wanted to address today?
Your Honor, I think we should briefly discuss the, just to kind of maybe review what we're expecting for January 7th and January 8th motions hearings. The state then would like some of the court's guidance on filing, whether the court prefers non-public filings in the motions in limine practice and subpoena practice. We should probably touch on jury instructions a bit. The parties have reached an agreement to extend some of the briefing deadlines that we'd like to put on the record, I guess, or just let the court know.
I saw those. We'll talk about those. We can go over those. I just need to make sure I have enough time to read, so I'm prepared for the 7th and 8th.
Understand.
Yeah.
And then there's one kind of reminder for the court that Greg White's motion for a protective order, docket 933, has been fully briefed and requests to submit for decision.
Is that... Yes, I recall that from the first trial setting. It was unclear whether that was mooted by the resetting of the trial.
I don't think so.
Has he been re-subpoenaed
Exactly.
to appear?
Right.
Okay. Okay, it's on the list. I got it.
That was what was on the state's mind, Your Honor.
All right. Let's talk about January 7 and 8 first. And perhaps you can all give me a better sense of what has not yet been filed but is likely to be filed to be heard on those days. So in terms of things that were filed prior to the first trial setting that have not yet been decided, I think there's defendant's motion to exclude the state's expert witnesses, which is fully briefed, right?
Yes, sir.
Are we anticipating any supplementation or amendments on that one?
No, sir.
Yes, sir.
Yes.
They just, noticed up a brand new expert, and I anticipate adding him to the list of people that I want to exclude under 702.
Will it be a new motion telling me why that particular new person? Okay.
But, I mean, you asked about supplementing it. I'm probably just going to, it's going to be a new motion, but
Right.
it makes sense that we hear all of them together. So I look at that as just like one more objection under that ground.
Yeah, I think, with Rule 702 motions, right? The
Correct.
devil is in the details.
Correct.
So it'll have to be specific to that expert's
Of course.
proffered testimony. Okay, I understand. So another expert-related motion to exclude is likely coming.
Yes.
Okay.
In Your Honor, I think the parties are in agreement that the experts, I guess whoever they are, on January the 7th can appear by WebEx.
Okay, very good. Are we doing any of, and forgive me, I didn't go back and pull all the briefing. To what extent will we be doing any of their, or viewing or reviewing any of their expected testimony and declaration, or are they going to do a trial run on the 7th? How much is happening on the 7th? What's your expectation, Ms. Nestor? Have you received summaries or reports from the experts?
We have received both, actually. My only concern about it is if we only rely on the summaries and the declarations, that if we don't prevail on the motions and then it expands at trial beyond what we argued, then we're right back to where we started. So it would be my preference that the experts take the stand and make sure that we fully understand, exactly what the limits of their opinion will be, is so that the court can rule on it all at once.
I don't know that we set aside enough time for that kind of exercise.
We have, so right now the experts that have been challenged are the FBI profiler,
Right.
the domestic violence expert,
Right.
the handwriting expert,
Sure.
and then this new one. So there will be 4.
Okay, so let's take the domestic violence expert
Right.
as an example. I understand your position to be there is no factual nexus between that type of expert in this case. Under 403, it shouldn't come in.
Right. We also have issues with her qualifications.
Okay.
Yeah.
Her qualifications are what they are. Either they meet the standard. There's no allegation that she's lying about them on her CV, right? They're either good enough or they're not.
Right.
Okay. What does she need to testify about on January 7th?
Well, the nature of her opinion. So it's my understanding that she's
Haven't you received a report or a summary of them?
a summary, yes.
And based upon that summary, you're persuaded that there's no fit, to use the word, the 702 language between her opinion in this case?
Right.
Your Honor, if I may jump in on 2 things. 1, I don't believe they've consulted with her yet, and 2, she's not offering an opinion.
Then why is expert testimony appropriate at all?
She's testifying about characteristics of domestic violence relationships, but she is not offering an opinion as to the relationship between the defendant and Eric Richins.
Understood. She, as I understand it, will be offering specialized knowledge that is beyond the knowledge experience of a lager.
Correct.
Okay. And then the state's intention would be to make argument using her testimony as foundation.
Correct.
Okay. I understood that. I'm not precluding you from asking that person questions. I'm just not sure we'll need much to fairly address your arguments regarding that testimony.
I agree.
The FBI profiler, I just don't know. We'll find out, I guess. Mr. Throckmorton, there I can appreciate why you might want to voir dire him a bit about what he didn't do, didn't look at. I think we'll have sufficient time for that. Do you have he usually produces a report with exemplars. He has a standard form. You've received that. So you'll be able to jump right in with him on the 7th. You wouldn't need the state to lay any direct testimony. Okay. And then who's the new one?
It's, I would, I guess, let Mr. Bloodworth answer that.
Your Honor, it's a detective with experience in...
oh, that's right, yes. Illicit drugs in Salt Lake County in a certain time frame.
Correct.
Got it. Okay. And you've received a summary or a report?
I don't think we've got that.
Your Honor, just a summary.
Okay. All right. Well, I stand corrected. I think we'll be able to get this done. Whether I'll be able to rule on all this by the end of the day on the 7th, I'm less certain on, but we'll figure that out. Okay. All right. And then I'm jumping around here a little bit, I apologize, would the intention be to hear oral argument on as many of the motions in limine that the court wants to hear oral argument on the 8th?
I think that makes sense.
Your Honor, that makes sense. I think there might, some, I guess depending on what the court's interested in hearing, might require testimony.
Give me an example a little bit. They'll be fully briefed, right?
Yes, sir, they will be fully briefed. Your Honor, some of the factual allegations in the defense's motion in limine, I don't think they're supported. It's not like a lot of times the state can say, we agree to this proffer because we know you could prove that.
Right.
I don't think that's the case through many of the factual assertions in the defense's motion in limine.
Which, give me one that sticks out in your mind. I perused some of their defendant's motion in limine. I thought I looked at it. Are you trying to say that their characterizations of what the state would be seeking to admit are not accurate?
Your Honor, there is that in the motion, but I also think that we can address that in the written briefing.
Right.
I think that the some of the factual allegations. I know there's not a facts section of the briefing, so it's just difficult to, in a sense, tease out the factual allegations, but there are factual allegations. Paragraph 1, after the death of her husband, Ms. Richins and her son wrote a children's book together. That
I don't need to make
to
that
the extent
finding, though.
to the extent the court that's just the first example, but to the extent the court needs to make factual findings, there may be a need for the court to take testimony.
Okay. I think to the extent there is a dispute about what a piece of evidence says or doesn't say, what a witness is going to be offered and testified to or not, there may need to be some back and forth among counsel. Hopefully that'll get teased out in the briefing. We may need to lock some folks in. We also need to recognize that, especially with live testimony, sometimes witnesses turn left instead of right, and we're going to have to be a little bit nimble during trial to say, well, that ruling no longer applies. We have to make some amendments. So.
Yes, sir. Sir, my sense is, since we'll be together on the 7th, if at the latest on the 7th, but as early as possible, if the court recognizes potential factual disputes and will give us a heads up, we can have witnesses ready.
Okay. I would hope to do it before then. This is a good way to back into, under your stipulated extensions, when will the motions in limine that you can contemplate sitting here today be fully briefed?
Your Honor, the agreement that the parties have reached really only relates to the defense's motion in limine, and it is a 1-week extension for the state's response and an additional week for the defense's reply. That would put the state's response due on December the 24th and the reply due on January the 7th.
All right. Can we move the reply date a little bit?
January 5th?
Yeah. Yeah, at least then I can read it on the 6th. Okay. So that would be defendant's reply in support of their motions.
Correct.
Okay. January 5, Ms. Lewis.
Yes.
Thank you. Mr. Bloodworth, I need a binder and a thumb drive on January 2nd. And it needs to have, the binder needs to have the briefs that I'm considering on the 7th and 8th. And the thumb drive needs to have PDFs of the brief plus PDFs of any exhibits.
Yes, sir.
Okay. Understanding that the reply brief we just talked about won't be in it.
Sure.
Okay. All right. Okay, back to the list. We've talked about defendant's motion to exclude the state's expert witnesses and a forthcoming additional motion in that regard. We have the state's motion to determine the admissibility of the walk the dog letter. That is now fully briefed and just submitted for decision, correct?
Correct.
Your Honor, actually, that was submitted for decision 8 months ago. I can do it in writing, but I object to the reply that was filed 8 months later and move to strike the reply.
If you do it in writing, give your reasons why, and then We'll give the state an opportunity to respond to the motion to strike, and I'll consider it. Okay. State's first notice of intent to offer 404B evidence, that has fully briefed, but there's a second notice, correct?
Correct.
Is that second notice fully briefed yet?
Your Honor, hasn't been briefed at all.
Okay. Is there a plan for briefing it?
Your Honor, we've not discussed one, but
Okay.
the state's open to whatever.
We're going to respond before the 12th as we were directed. And then I guess they can reply. So I thought we had a briefing schedule for all the motions that were filed on the 26th, I believe. According to the docket, our response is due by the 12th.
Okay. Very good. Mr. White's motion for protective orders on the list. I haven't lost track of it. There were additional motions limited filed by the state recently, correct?
Yes, sir. And may I note, too, there's the motion in limine related to the orange notebook that was filed back in, I don't know, early 2025 that has not been fully briefed.
Or submitted for decision.
Or submitted. But we spoke with defense, or emailed or something with defense counsel the other day. They know it's out there. They plan to submit a response.
Okay.
And then the state will either reply or submit.
I know it seems silly, but in any docket, and especially one of this length and complication, the request to submit is literally how the court knows whether to pay attention to something or not. It's the difference between me leaving open the possibility that you all worked it out in the process of the briefing versus knowing I need to pay attention to it and how quickly. So please follow that procedure so I make sure I don't miss anything. Okay. Let's talk about private versus non-private. I take a rather expansive view, especially given the proximity to jury selection, of what can be filed privately in this case, especially if counsel agree. If you all agree that a specific particular return of service or all returns of service, subpoenas or all subpoenas, all motions in limine should be filed privately to prevent incomplete, misleading, or just absolutely inaccurate reporting of the content of those documents from poisoning the jury pool, I will not get in your way.
Understood.
Any objection, counsel? No. Yeah, you don't need to. The procedure that the parties have been following on both sides of the V is acceptable to the court. The benefit of doing it as a private document is that you all can see it, I can see it, court staff can see it, the public cannot. And there's good reasons for that given the proximity to jury selection.
Yes, Your Honor, the state appreciates that. The state would ask, just as a courtesy, if counsel files non-public, if they could send us a courtesy copy. We don't have access electronically to non-public. You have to walk down to the court's office.
Is that true?
It is.
Don't you have the same green filing access that everybody does?
We don't use green file, Your Honor.
No. Is that a government thing?
It's a government thing.
That is news to me. I apologize.
And so the state appreciates the non-public filing this close to seating a jury, and the state will engage in it itself. But filings after hours are, we don't get them till the next morning. When we walk down.
Is it a simple matter of your office just buying a green filing account for a couple of months?
It may be. I don't know how it works.
Fair enough. I'll let you all work that out. I did not appreciate that. Okay. Yeah, there may be a way we can work around that for you. Okay. Okay. Ms. Lewis, Ms. Nestor, Mr. Ramos, anything on that? You folks, through green filing, are able to see it instantaneously, right? Correct. Okay, very good. Any objection to what I've just proposed?
No.
Okay. All right. The juror questionnaires are scheduled to go out on December 16th. You've received a copy of it. We included the changes that Ms. Shervanek emailed over after a meet and confer some months ago at the end of October. One additional question came up. Do we want to include a single additional question asking the juror if they're paid hourly or salary? I don't know if that's something you'd want to know when culling or creating categories. There are certainly other fields where someone who believes the financial hardship would be too great would have an opportunity to tell us. Yeah. If you're comfortable with the way it is, that's fine.
We're fine with the way it is.
Okay. Ms. Shervanek?
Yes, I'm fine with the way it is.
Okay. Very good. We are intending to send questionnaire responses to council on or before January 19th. Those will come in the form of a PDF and an Excel spreadsheet. We are also keeping a separate Excel spreadsheet of people that the court strikes in advance of them filling out the questionnaire because they tell us, hey, I'm going to be in Europe for 3 of those weeks or things like that. We'll keep a record of it so you'll be able to recreate it if necessary. Okay. Anything else on jury selection, Mr. Ramos? No, Judge. Okay. Ms. Shervanek?
No.
All right. Did we get through your list, Mr. Bloodworth?
Your Honor, jury instructions?
Yes.
So at this point in time, we've gone back and forth. We have a proposed set of jury instructions and then a separate document that lodges some defense objections. How would the court prefer us to submit those?
I recall in the run-up to am I recalling this correctly, in the run-up to the last trial, there was the stipulated set, then there was a set of defense proposed that were not stipulated and states proposed that were not stipulated. Is that accurate?
That is not, Your Honor. We never got to jury instructions in the run-up to the prior trial. This is our first go at that.
Okay. I thought we had it. Yeah, and my apologies. I'm getting my cases confused.
Sure.
That's typically the most helpful, is a stipulated set with citations to authority, if in the footer, if possible.
Right.
And then to the extent that the state or defense has a subset of proposed instructions that are not stipulated, just submit those separately with citations to authority. The real question is, to what extent do you want to be able to talk about your instructions during your openings? If you do, we need to come to rulings regarding as many instructions as possible prior to giving openings. If you're less concerned about that or have no intention of doing that, we don't. Some instructions we simply won't be able to finalize until we see how trial proceeds.
I think probably the only one we would use in opening would be the presumption of innocence and burden of beyond a reasonable doubt, which we've stipulated to those two. So, well, there's one additional one we're asking for. So we might be able to just resolve the ones we want to use for opening, and then whatever ones they want to use.
Are there, without getting into too much detail, are there any live disputes or genuine disputes regarding what the elements of the charges are?
There are.
Okay. That seems like an issue that we should try to resolve prior to opening.
Agreed.
Okay. All right. Bear with me for a moment. If I canceled a civil trial, I could liberate February 19. Do we want to talk about your instructions on February 19th?
Sure.
Yes, sir. That's fine.
Okay.
That's
It's the day after the last scheduled day of jury selection. I'm cautiously optimistic we will have picked a jury by then.
That's a Thursday, correct?
It is. Okay, let's plan on. We plan on 1 p.m. on. No, I have a criminal count. I have a criminal count on Wednesday. 1 p.m. on February 19th in person for a discussion of jury selection. Jury instructions. My apologies. Ms. Nestor, does that work?
Yes, Your Honor.
Yes, sir.
Okay. In that case, what I'll need is given that it sounds like there's a dispute regarding the elements of the charges, just a little bit of briefing. It doesn't need to be long, but I just need to know what your position is and why before I walk in on the 19th. Something along the lines of a pocket brief, a citation to authority, a little bit of discussion so I can know what you're relying on. You can only do so many things at once. Can we have those briefs just cross in the mail and be filed on February 9? Does that seem workable, counsel?
Yes, sir.
Mr. Bloodworth?
Yes, sir.
Okay. Very good. Mr. Bloodworth, keep going.
Your Honor, that's all the state had.
Okay. Mr. Ramos, Ms. Nestor, Ms. Lewis?
We have nothing else.
Could I persuade you folks to just check in with me on January 2nd to make sure we're on track? Is that workable? You can even do it by WebEx if you prefer.
What time would you want to do that?
Brittany, would you recommend the afternoon? In the afternoon.
That should be fine.
Do you want to say 3 p.m. on January 2nd? Would you like to do it in person or by WebEx?
WebEx.
Okay. Mr. Bloodworth, Ms. Sherman, is that all right?
Yes, sir.
Okay. Let's have a continued pretrial conference on January 2 at 3 p.m. to make sure we're on track. Give me just a moment. Mr. Bloodworth, there is a motion to reconsider the severance.
Yes, sir.
When will that be fully briefed under the same schedule?
No, sir, that schedule's advanced. We didn't shift that schedule, so it's the normal. Actually, we gave. Yeah, so next Wednesday will be defense's response. So that's the 10th. And then the state's reply would be due December 17th.
Okay.
The docket says that all of our responses are due on the 12th, so if we could just clarify. We thought, I pulled up the docket and it says the 12th.
I don't have a dog in this fight because I won't know about them until they're fully briefed. But if you have any, I mean, I'm sure you and Brad can.
I don't care if it's the 12th.
Yeah.
We may have some on the 10th. I just don't know yet.
Okay. I haven't read it. I would have looked at the caption.
Sure.
But that feels like one that I could rule on the briefs. Any objection?
No objection, Your Honor. I think you can roll on the briefs.
Okay, very good. I will endeavor to get a written ruling out on that as quickly as possible,
Yes.
so that you folks know whether you're trying The amended information as it looks now or something else?
Yes, sir.
Okay. All right. Let me just pause for a moment and see if anything else comes to mind. Go ahead. I imagine they're going to come in with the briefs on January 9th. I'll be more explicit. January 9, I need your briefing on jury instructions to the extent they're disputed in your stipulated set. That's a February. February, my apologies.
Right.
Yeah. Stipulated set, disputed set, and why I should rule one way or the other on the disputed instructions. Jury instructions tend to be an iterative process in any case in general, and certainly a case of this size, and so we may have to discuss them over time as we iterate through. Okay, let me go around the table one more time. Mr. Ramos, anything else today?
No, Your Honor.
Okay, Ms. Nestor?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay, Mr. Blood?
No, Your Honor.
Ms. Sherman?
No.
Mr. Burmester?
No. No, Your Honor.
Ms. Olson? Okay. Counsel, I appreciate seeing you in person. I look forward to working with you on this case. We'll be back together by WebEx on January 2 at 3 p.m. If anything comes up between now and then, I'll do my level best to make time on my calendar and get you in. Ms. Richins, I wish you the very best. We're off the record. Thank you.
All right, so we are waiting for the feed to kick in. They are going to be on a hour delay, which means theoretically they've already started their time, but we're waiting for them to for the feed to kick in. So we have a little bit more to yes, we have a little bit more to play. We have the January 2nd hearing. You heard them talking about the WebEx January 2nd hearing. We're going to go ahead and play that. And that should get us really close to the top of the hour, which is noon here on the East Coast.
All right, good afternoon.
All right, let me just get this sorted out. All right. All right, and again, this is from... let's see. This is from January 2nd. So you heard them talking about their WebEx meeting January 2nd. So this is a hearing from January 2nd, 2026. Wow. Hard to believe. Hard to believe. All right. Hearing from January 2nd, 2026.
All right, good afternoon. We're on the record in 231-500-139. State of Utah versus Kouri Richins. Can I have counsel for the state make their appearances, please?
Your Honor, Brad Bloodworth, Lindsay Shervinack, Margaret Olson, Fred Burmester, and Joe Hill on behalf of the state.
Very good. On behalf of Ms. Richins, please.
Wendy Lewis, Catherine Nestor, and Alexander Ramos on behalf of Ms. Richins.
Ms. Richins is present by WebEx. We're here for a brief pretrial conference in advance of the hearings that are set for next week. Mr. Bloodworth, from the state's perspective, are we on track as planned for January 7 and 8?
Yes, Your Honor, but I do have a few questions. Has the court at this point identified any witnesses it would like to hear from on the 8th?
No, unless one of you specifically asks for an opportunity to voir dire a witness live in advance of trial, I'll make decisions either based upon just the papers that have been submitted or a combination of the briefs and your oral argument.
Okay, it was my understanding, is this incorrect, that we were going to hear testimony from Molly Amon and Brittany Fox on the profiling issue.
I think that's on. It was unclear to me whether we'd be doing that by live testimony or by declaration, but that would occur on the 7th, right, as part of the 702 issues.
Okay. And we had agreed that those witnesses could appear via WebEx. So,
Fine.
I mean, unless the court doesn't find it helpful, I mean, I think it would be helpful to hear from those witnesses. We're questioning the scientific methodology of that particular witness.
I find it helpful to the extent you believe it's necessary to develop defendants' arguments in support of your motion to exclude under 702. If you don't think live testimony is necessary for the court to understand and rule on those arguments, then I'm not going to independently question those witnesses.
Okay.
Your Honor, back to January 8th.
Yep. Well, may we stop just for a moment on those two witnesses? As the defense told the state that they want you to have those two people available to be questioned on January 7th.
They will be here via WebEx.
Got it. Okay. Sounds like everybody's options are preserved. Amon and Fox.
That's
right. Well, Amon is ours, Fox is there.
And Fox is ours. Yeah.
Yep. Okay.
Right.
Yep.
Your Honor, did the court on January the 8th want to address the motion regarding Greg White's subpoena, Maria Bramwell's subpoena, and the motion to appoint counsel for Lisa Darden?
No, I'm hoping to rule on all of those in advance of January 7 on the papers. I candidly had hoped to do that by now, but other cases got in the way. Now, if I haven't seen the Bramwell law firm, Mr. White, ask for a hearing, did I miss it?
I'm not aware of that.
Yeah, and so I think I can rule in the papers on those.
Okay, sir. There's an issue regarding the motion to appoint counsel for Lisa Darden.
I saw that.
That I would like to address non-publicly today if we can.
You guys just got to give me a basis to do it non-publicly. I just have to make some findings in order to close the record.
Your Honor, it involves counsel in this case.
Okay. I'm inferring that discussion of what you want to discuss on the record in a public manner regarding that motion would materially prejudice defendant in advance of trial.
It's possible. The thing is, at this point, I don't know.
Okay.
But I think if we were to have a quick discussion today, non-publicly, it could resolve itself.
Okay.
It could become a thing. I don't know.
We'll do that before we conclude today.
Yes, sir.
Okay. Anything else on your list at the moment?
Your Honor, confirmation regarding the deadline for defense Rule 16 disclosures.
Go on.
I guess the state's question is it 2 weeks before February 10th jury selection or 2 weeks before February 23rd trial?
I mean, normally it would be before jury selection because that's when the trial starts.
And to some measure, the disclosures, particularly witness disclosures, may impact voir dire.
Right. Is Ms. Nestor, Ms. Lewis, is that possible?
I think that's what we were planning on. I think the last time we talked about it, the court had told us ours was due February 6th, maybe, but I guess that would not be 2 weeks before jury selection. Is that, so we're asking to make it sooner?
I don't know. I don't recall that, but that's entirely possible. My apologies. Tell me what your current plan is.
Currently, we you were planning on producing on the 6th of February, because I think that's when you had required it previously on the hearing when you set their disclosure date. If they need it, I mean, I think I could get it a week earlier if that would solve the problem. I don't think that's going to be a huge problem to get it a week earlier. But
Mr. Bloodworth, what does the state need?
A week earlier works, Your Honor.
Can we agree on here? Can we compromise on February 2nd in case they need the weekend to finalize some stuff?
Yes, sir.
Okay. Ms. Nestor, February 2, please.
And that's for both witnesses and exhibits?
I'm getting yeses from the state.
yes, I've got that, Your Honor. We'll comply with that date.
Thank you. Mr. Bloodworth.
Your Honor, I think right now that's all I have.
Okay. All right. Ms. Nestor, Ms. Lewis, Mr. Ramos, are we on track for next week?
Yes. We were wondering, and this isn't really about next week, is there a date that we know we will have all the jury questionnaires back? I know before you said no later than January 19th. Does that mean we may be getting them on January 19th, or could we get them possibly all by January 17th? When could we plan on seeing those?
Yeah, that's a timely question. Let me, I had some correspondence with the jury clerk that's managing that process. Let me give you an update. One moment. Okay, as of December 30th, 1,486 questionnaires had been completed. 345 had been summoned but had not responded to the questionnaire. Those 345 were getting reminders to do so today with a deadline. Well, they'll get a reminder either today or on Monday with a deadline to finish it by the end of next week. I asked the jury clerk to send me the Excel spreadsheets on or about January 13. My plan would be to send it to all counsel on the 14th or 15th.
Oh, great.
Thanks.
If I may, I mean, you all have this firmly in hand, but if I may make a recommendation to avoid errors that I've made in the past, create a working copy of the Excel spreadsheet. One you treat as sacrosanct as the original. The other is the one you play with sorting in. If you make a mistake sorting them, it's almost impossible to undo.
Good advice.
Okay, keep going. What else do you have on your list?
I don't think we have anything.
Ms. Nestor, anything else until we go into a closed session?
I don't think so. I did want to just clarify as far as the jury instructions. I was having trouble understanding my own notes. You wanted just basically like a little brief summary of our support of any instruction that we're asking for that is not agreed on, right?
Yeah, and it can be of varying amounts of substance. Sometimes it can just be simply a citation in the footer to the controlling case that says it was reversible error not to give the instruction, right? I can connect those dots. If it requires a few paragraphs of explanation, maybe put together a short brief saying, here's why we're entitled to this instruction.
The other question or just thing I needed to bring to the court's attention. So the state on a few days ago, and it's the holidays, and I'm sorry, but the days are all confusing to me because they've all been in the middle of the week. But within the last week, the state has amended their exhibit list to include approximately, 20 to 30 new exhibits. I anticipate that at least some of those exhibits I am going to have objections to in the form of a motion in limine. I will try to get something on paper this weekend as quickly as I can. I don't know if it would be in time to hear it on the 7th and 8th, but it might be something we need to take a few minutes on, prior to trial. I don't know.
I imagine there will be several of those between now and opening statements.
Well, and I assume they'll have some motions in limine on anything I want to introduce, which they won't even see until the 2nd. So I assume there will be one more round of motions in limine, but I am just giving the courts a heads up that I do anticipate objecting to at least a few of those new exhibits.
No, I appreciate that.
And some of them are going to fall under the same type of objection that I've already made in my motion in limine. So it may just be that we can just add those into the argument because it's the same nature of document on the argument we have on the 8th. But if that's stressful to state and they'd rather argue it separately, we can. But I think some of them are going to just be connected to the same type of objections I've already made.
I'm less concerned if it's stressful to the state and more concerned if it's stressful to me. There are 8 or more of you and there's one of me. And so the limiting factor is my ability to be prepared, be able to make timely rulings and keep it all straight. I would understand if the defense waited to see what came of the hearings on January 7th and 8th, and then both sides of the V fashioned future objections with the information of what we did on the 7th and 8th.
That makes good sense. We'll do it that way. But I just didn't want you to think I was hiding in the weeds on it or anything. I do anticipate that coming.
I anticipate that this will be an iterative process.
Yes. And also, I think I announced the last time we were before the court that I was planning on filing a Daubert challenge to the DEA drug expert. We are not going to file a Daubert motion on that one. So I didn't know if you were looking for that, or if you even remembered that I said it, but we're not going to proceed with that one.
I'll only consider and rule on what gets filed.
Yeah.
Okay.
I guess one other thing quickly is just to keep it straight, since there have been so many filings from our notes and perspective, I think the only thing that needs to have briefing completed before the 7th and 8th is I think we still need to file a reply motion to our motions in limine, which I believe is due Monday. If
you choose to.
Right.
You're not required to.
Okay. And Brittany, I think one of our paralegals emailed you, but if there's anything else that's not fully briefed that we have let go, if that would be not too difficult to let us know.
Yeah, with respect, Brittany's not the person for that job. You all need to just go through the docket and figure out if there's anything that you want to have submitted for decision that isn't yet. But we can't ask Brittany to do that for you.
All right, understood. That's fine. I thought she might just know because she's Brittany, but
she might. But that's not her job to do that. Okay, Mr. Ramos, anything today, sir? All right, let's see. The potential scope of testimony of Ms. Darden, Ms. Richins' mother, is a sensitive topic that may or may not implicate Ms. Darden's Fifth Amendment rights, may implicate a proffer of testimony or other evidence that may or may not be admissible. That all has the potential to affect the jury pool this close to trial. It has the potential to affect the voir dire process. Out of an abundance of caution, the court finds it is necessary to consider the motion to appoint counsel for Ms. Darden as a potential witness in a closed hearing in which the lawyers and the parties will be fully participating, but that will be sealed from public view or review. Ms.
Your Honor,
any objection?
No objection, but could we ask that our investigator, Chris Bertram, be allowed be brought into the meeting, please?
Yes. Anybody else?
No. No, no one else.
I think the victim representative is entitled to be there. Should I add the Richins family? Okay. All right. We will now go into that closed session via breakout room. Give me just a moment.
I think Katie Richins Beckson is also on.
Okay. I can't see her, I'm sorry. Oh, KRB. If you'd all accept that, please.
I think that's it.
Pause.
No, they're coming back.
Okay. We need to take a pause for just 1 minute for a technical issue. We'll be right back. Proceedings to. Okay, we're back on the record in an open proceeding at 231-500-139. This concludes the proceedings today. We will reconvene next week on January 7 at 9:30 a.m. in person in Silver Summit. Counsel, I wish you and your clients the very best. Please take care.
All right. So you heard him. January 7th at 11:30. Well, what do you say 9:30, which would be 11:30? Huh, that's interesting because if it's a delay, then it would be 12:30. No. All right. Well, we're waiting for the feed to kick in. So until it kicks in, we'll just hang out. Okay, here we go. Delayed feed should be up around 12:08 Eastern, 10:08 Mountain. So we got about 20 minutes or so. We have about 20 minutes or so to relax. Let me see if there's really nothing. Let me see. What else can I play for 20 minutes? Let me see if I can find something else. What do you guys want to... Oh, I could read Walk the Dog. Do you guys want to check that out again? Let's do that. For those that did not see the Walk the Dog yesterday, we can do that. Let's check this out again. All right. All right, so here's the Walk the Dog. For those that were not in our chat yesterday, here's the Walk the Dog. And for those that did not see it, all right, so here's the Walk the Dog letter. Page 1, Walk the Dog, big exclamation points, but take vague notes so you remember with a little asterisk. So remember that asterisk because she references it later. Sky is saying, Sky Lazaro, her first attorney, Sky is saying, even if the gummies have fentanyl in them, the prosecutor will say, I tried to put the fentanyl in the gummies. So even if the gummies have fentanyl, the prosecutor is going to say that she put the fentanyl in the gummies. So Eric would have them. Stupid, I know, but that's what she's thinking. We will still test them, though. However, she wants to link Eric getting drugs and pills from Mexico. So we need some kind of connection. Her private investigator is doing some research on the ranch cartel place where Eric would stay at. Here's what I'm thinking. but you have to talk to Ronnie. Ronnie is her brother, and we heard from Ronnie yesterday. You have to talk to Ronnie. He would probably have to testify to this, but it's super short, not a lot to it. He will need to tell Sky at the meeting next week. Upon information and belief, just like they say, a year prior to Eric's passing, Ronnie was over watching football one Sunday, and Eric and Ronnie were chatting about Eric's Mexico trips. Eric told Ronnie he gets pain pills and fentanyl from Mexico from the workers at the ranch. Not to tell me because I would get mad because I always said he just gets high every night and won't help take care of the kids. There are pictures in my phone of Eric passed out on the floor or in the chair. Ronnie should have texts from Eric talking about getting high as well. Eric told Ronnie he keeps them in an allergy pill bottle in his work truck, so I wouldn't find them. Ronnie never told me about the conversation. Eric finally told me and asked if Carmen could get him some. So I wonder if Carmen is CL. I think Carmen is the CL. Remember we were wondering about the CL, and that was their maid, and that's where supposedly allegedly the pills came from, the fentanyl came from. So Eric, you all right, dude? All right, Houdini's going crazy. So Eric never wanted anyone to know he had an issue, especially. Let's see. Eric didn't want anyone to know, especially Eric didn't want anyone to know he had an issue, especially get caught. He always wanted Kouri to go down for him. When they traveled, Eric would put his drugs in Kouri's bag at the airlines right before they boarded. That way, if they were caught, Kouri got in trouble, not him. Once they got to wherever they were going, Eric would pull the drugs out of her bag, and it would cause a huge fight. And this is what she's telling Ronnie. Well, she's telling her mom to tell Ronnie to tell Sky. Right? So she was pissed at him. She was pissed he would risk her going to jail for his drug use. He just would laugh about it. Eric couldn't ruin his image that he had drug issues, so he would do whatever he had to. Kouri has never done any type of pills, didn't like them. Rarely would she consume THC, only if Eric begged her because it was a special occasion. And then here's another asterisk. Reword this however he needs to make the point, just include it all. Right? So she's telling her mom to tell Ronnie, her brother, to tell Sky so that he can testify this way. So again, witness tampering, full-on witness tampering. The connection has to be made with Mexico and drugs. Ronnie will have the messages to prove Eric confided in him about getting high. He can be short and to the point, but has to be done. Upon information and belief, LOL. They never found pain pills or fentanyl in my house because he hid it in the allergy bottle in work truck. And Cody emptied out work truck within a week, so they were never found. When you talk to Ronnie about this, page 3, when you talk to Ronnie about this, meet up with him in person. I worry sometimes your house and phone are bugged. So now she's getting paranoid. She's thinking that the house is bugged. I would assume by law enforcement. Maybe drive down to SL, I'm guessing that's Salt Lake, and meet him after work without Bree. Not sure who Bree is. Without Bree. Sky has to make the connection between Eric and Mexico because that makes the most sense to her mind. If it's Ronnie's information and belief about the conversation over football, she can use that as a connection. Tell Ronnie don't overanalyze it. It was a quick 2-minute conversation, LOL. Tell him I need him to do this. Bring me home and then we will get those damn bitches. Now that is in reference to Eric's sisters, Amy and Katie. Allegedly. Also, please text Lotto. Now here comes Lotto. Who is Lotto? And it's really funny because I Googled Lotto, who's Lotto, and it came back as the family dog. I'm like, And then I looked it up again, and it's like, no, it's, well, actually, I didn't look it up. I said, because the AI came back saying it was the family dog, and it got sick after it ate the egg salad sandwich and all this stuff. I'm like, wait a minute. Here she's saying, please text Lotto or call. Tell him, do not text me anything about us doing things together ever. So obviously not a dog. So tell him not to text me anything about us doing anything together ever. So now we're thinking this might be her boyfriend. This might be her paramour. So like church, skiing, trips, nothing that puts us together. It doesn't look good. We're so close to the end. Let's push through, have the conversation with Ronnie before he meets with Sky. Then tell him to tell Sky at the meeting about the conversation. Hang in there. We're almost there. Love you to the moon with a little heart. And then there's that asterisk. Remember, she had the asterisk up here. But take vague notes so you remember. There's the asterisk there. And then we come back down here. Okay, come on. Take vague notes of all this so you remember before you walk the dog. Right? All right, page 4. So apparently there were 7 pages, I think, when we were watching yesterday. I think there were about 7 pages. So it seems like page 3, that's the end of it. Right? But it goes on. I saw a commercial yesterday. Utah Mortgage Relief, Google them, please. Okay, so Utah Mortgage Relief, Google them, please. It's for people behind on their mortgage. Can you see if they can help at all on Marissa's house, please? We have to get hers, yours, and Chelsea's taken care of ASAP. Try to go to that place in Camas, right? Camas. What about asking Lotto to do a loan solely in his name and not have y'all on there? Right? So Lotto is not the family dog. I know he can do a home equity line of credit on his house and hideout. Not sure if he would, but I know he has like $1 million in equity. Maybe he just doesn't know about a HELOC, which is a home equity loan. If he wants to help me, taking care of these loans is most important. I don't give about the, I'm not sure what that word is. Yotels? Yodel? I'm not sure what is YOTELS is what it looks like, but that's not a word. Mallory, was the judge ruling on this letter? Yes. That last I heard, it's still to be determined. So hopefully we'll hear about that today, tomorrow. If not, I'll find out. Because this is huge, if this is allowed in or not allowed in. Remember, I told you one way to get at Katie, which is Eric's sister, is going through my phone and finding a picture of her girls, even with the boys, meaning the Richins boys, Eric and Kouri's boys. They have 3 young boys. Print 15 copies and send them out anonymously to different media companies. Man, she is like devious. Obviously, don't email the pictures so it's not traceable. She would be livid, all caps underlined, livid, if it got out to the public. You would just have to do it sneakily and be careful. She would try and trace it back to you. If not, no worries. So, right, that just kind of shows her level of deviance, right? Hey, Northwest. I think most of the letter will come in. Some may be redacted. All right, page 5. Sky is having the My Girls do the first interview with Good Morning America. Please tell Chelsea to bring up that he hasn't been to church in the 13 years she has known him. And Eric would brag to her about how much he drank and did pills in high school. Tell Chelsea, different Chelsea. So Chelsea and Chelsea, right? 2 different Chelseas there. Tell Chelsea to say Eric always wanted Kouri to go down for him. For example, he would put drugs in her suitcase when we would travel together. So, yep. Let's see here. For example, he would put drugs in her suitcase when we would travel together, so if anyone got caught, it was Kouri. He would put it in her bag right before they left the house, so Kouri didn't know. Then when we would land wherever, Eric would take them out of her bag, and Kouri would be pissed, and they would argue about it. So again, she told Mom to tell that to Ronnie, and now she's tell Chelsea. Tell Chelsea to say that as well. All Kelsey, I guess it's Kelsey, not Chelsea. So we have a Chelsea and we have a Kelsey. All right. All Kelsey, let's see. All Kelsey to say, have Eric didn't care and would just laugh about it and say, well, I can't get in trouble, as if it was okay that I got in trouble. And then here's Selma. Have Selma talk about Eric in Spain not being able to drink, so he was looking for drugs the entire time, and explain the drink the waitress gave him, and how I called his doctor and went to the pharmacy immediately. Have Allie talk about how the sisters have always been jealous of me because of anything. Here's page 6. They've always been jealous of me because anything they could do, Kouri could do better. Being a mom, college, stay-at-home wife until she built $1 million company, a nice house, car, everything she had, they wanted. This comes down to jealousy, money, and Eric's partying that they don't want to acknowledge, and sadly, an accidental overdose. Lastly, don't forget to work on the gun receipts. We want to file charges and let the prosecutor not do anything about it to use in our defense. Will you buy a box of Crest White? Oh, this is interesting. Will you buy a box of Crest White strips, open them up, put in an envelope, and have Sky give them to me? So she wants Sky to now give her contraband. You can tell her what's in the envelope. I'm sure she won't care. Okay. You're telling a lawyer what she should or what they or should or shouldn't care about. I'll make sure they can't be found in my cell. My teeth are yellow from so much coffee. Hey, Nan, how are you? Let's see. My teeth are yellow from so much coffee and tea all day. I love you. I love you. I love you. Hang in there. We're getting there slowly. You're the best mom in the whole world. I'm so lucky to have you. So that's the infamous walk the dog. All right, so 12:08. They're going to kick in at 12:08. So we're waiting for them to kick in. So, oops, let me see here. Let me put my thumbnail up. So what do you guys think of that? What do you think of the walk the dog letter? Is that damning? Is that going to sink her? Should it be allowed in? What do you guys think? CCG TV, you're standing with innocent until proven guilty. Check your message about the admissibility. Okay, Jenny, let me see here. Where is that? Okay. This is what AI is telling. Okay, as of January, Judge Richard Mrazek has ruled it is admissible. Okay, so the majority of the 6-page letter found can be used by prosecutors. 4 specific sections of the letter were excluded because they were determined to be work product containing her former attorney's legal theories and opinions. All right, cool. Thank you, Jenny. Good job. Good sleuthing there. We have a fantastic group of mods, right? Our mods are great. They help us. They help me. They help you guys. So good job. Good job, Jenny. Thank you for that. So what do you guys think? Everine says, most definitely damning. JMS should be allowed in. Mallory says yes, emphatically. Ruth Ann, yes, it should be allowed in. Awesome. Those were her exact words. I mean, right? Yes. Thank you, Jenny. Appreciate that. Amy Lee, yes. Jenny G is amazing. The jail did find the letter. Yes, Kathy, we watched that yesterday. We watched that hearing specifically about it being found. And remember, they had that. They had the correction officers talking. They had 2 of them talking. So yeah. Aussie, I think Walk the Dog is very compelling for conviction. Mallory, yay, I'm happy the letter is coming in. Tosh, sorry, you need to find a new job. There's a couple of us that are going through that right now. I'm sorry. It stinks. It's the worst. I mean, it's always tough finding a new job, but especially right out at the holidays, before the holidays. Just terrible. Everine says, my concern is the state's ability to prove no prior illicit drug use. By her? By her? Rain collector, yes, allow in. Hellrider, sounds like the letter was made to cover. Maybe. Who will they bring to testify to this? Probably those correction officers, right? The ones that found it, I would think, the correction officer. Rain collector, the karma of them finding the letter makes me believe in the universe. Joanne, I wish Miss Sky would divulge info on her. Might be client, attorney-client privilege. I would think that's what that would fall under. Brad says, I think it will and should be allowed. Defense can then argue it being fiction or just telling them to tell the truth. I think it will be harmful to her. Well put, Brett, I should say Brett. Everine, I don't think so. I haven't heard that they are. I don't think they are. Let's see here. Teresa, I think the letter shows her character and how far she is willing to go in order to get her way. Yeah, I mean, it's definitely witness tampering. She's for sure witness tampering. She's saying that Eric was a drug user, so that means the defense is going to have to prove that he was a drug user, right? Jerry, why would they toss her cell? Were they tipped off by someone? She had a medical emergency, and the correction officers went in, and I think they were just putting her stuff away. I don't know. I don't remember now, even though we just watched that yesterday. Unfortunately, I don't remember. No, Nick Reiner's arraignment is probably, we're not covering it. I'm sure it's going on somewhere else. No room for you, buddy. Good day to you. Welcome in. All right, Jenny, got to make a phone call? No problem. I know, but I wish the client privilege would be discarded in this case. Maybe. I don't know. Both officers yesterday sounded cagey to you, Gordon says. Let's see, are they live yet? Right, still not live. 12:08. They're scheduled to go live. 12:08. Hellrider says they can come in anytime to check for contraband. But was it just a routine? And I know you guys were talking about that yesterday. Is it just routine, or did somebody tip them off? I know she had like a medical emergency or whatever, but like they just go in and just check. I know they can do it at any point in time, but did they do it? She had a medical emergency and they just went in to check because of that? I don't remember. I don't remember why they actually went in. Okay. Oh, Aaron's saying it was at 11, and we'll show it. Maybe we'll cover Nick Reiner later this week because we have Kouri today, Kouri tomorrow. So Friday, maybe we'll do Nick on Friday. We could do Nick. We'll cover Nick on Friday. Amy, good to see you. That's how it sounded to me. Also, they were looking for a letter with cursive because she held a letter up during a video. Right. I remember that. Yeah, that was her mom, right? She held up the. They were having her mom was visiting her, and right. She held it up. I think she saw it there, or they saw it there. The officers can go through your cell for any reason at any time. And Kathy, yeah, they saw her hold up the letter so her mom could see it. Right, exactly. JMS, the guard that found the letter was called and testified about finding during the hearing we watched. Yeah, both of them. There were two of them. They said Sarcasm says they said they saw her showing the letter during a visit. Okay, so that's what it was. All right, thank you guys. Thank you, chat, for acknowledging and dropping info and knowledge. Appreciate that. Let's see, Hellrider. I mean, if it was a tip, definitely, and if she had an issue there, they just check out while they're there. Yeah, well, now that I remember, I do remember that that they saw her holding up that letter to her mom across, the glass partition or whatever, and then that's when they went to go check. Nick will probably be quick and routine. It's only an arraignment, Northwest. Yeah, maybe half hour, if that. But we'll cover it. We'll check it out. Because right now, Friday, we still have like 8 hours of pretrial hearings for Kouri that we missed because of today. So we still have, we still have like 6.5 hours, actually 7.5 hours of hearings we could still watch. Maybe we'll do that on Friday, or we might do an Ego Takes the Stand. We're also keeping our eye out for Paul Canero, because he's still in jury selection. We're going to cover that. We're not going to give up on that. So we will definitely be covering Paul Canero. He's currently in jury selection, so we're going to keep our eyes out for that. Not going anywhere for Paul Canero. Sharon, well, she was on medical, and also they changed her jail. Okay, gotcha. Carolyn, how are you? Dropped in to listen for a while. Miss you guys. Yeah, Carolyn. Good to see you. All right, it's 12:08. Just waiting for the feed to kick in. See if there's any update. Delayed feed of this hearing. We should be up around 12:08 Eastern, 10:08 Mountain. So I'm just waiting for the feed to kick in. Nope, here we go. All right.
Please.
Good morning, Your Honor. Brad Bloodworth, Margaret Olson, Lindsay Shervanack, and Fred.
Appearance, please.
Good morning, Your Honor. Brad Bloodworth, Margaret Olson, Lindsay Shervanack, and Fred Burmester for the state.
Very good. For the defense.
Wendy Lewis, Catherine Nestor, and Alexander Ramos for the defense.
All right. Counsel, as I understand it, we're here today to address the defendant's motions to exclude 3 of the state's experts. Is that correct, Ms. Lewis?
Yes, Your Honor.
The states recently filed a motion to exclude one of the defendant's experts not on the list for today. We'll address that in some fashion in the future. Yes?
Yes, sir.
Okay. Ms. Lewis, do you have a plan on how you want to proceed?
Your Honor.
It's the preliminary matter. My apologies.
Thank you, Your Honor. May I?
Of course.
Your Honor, the state wants to ask the court to make additional findings in connection with its order from yesterday denying the state's motion to determine admissibility of evidence. The court's findings regarding the defendant's financial crimes as it relates to the state's pecuniary gain element argument is clear. In its briefing, the state raised 2 additional arguments that the state asks the court to address. The first is that the defendant caused Eric Richins' death to cover up her financial crimes, and this proves an additional motive as well as the identity and intent elements. And the second argument is that the defendant's...
I'm sorry, no, I just am having trouble hearing. I need you to pull down the mic. Thank you.
And the second argument, Your Honor, is that the defendant's financial crimes show that causing Eric Richins' death was her last resort, and this proves the identity and intent elements. The state asks that the court make intrinsic evidence findings on these 2 arguments and additional findings under Rule 404, as these additional arguments increase the probative, in the state's view, increase the probative value of the financial crimes evidence. Finally, Your Honor, regarding footnote 3 of the court's ruling, The state asks that the court note that the state advanced its complete the story argument in its moving papers before Blackwing issued, and then in its reply papers revised its argument to comport with Blackwing. Thank you, sir.
Yeah, let me be clear. I understood your arguments. I just didn't find them persuasive. The state simply hasn't carried its burden to show a sufficient or persuasive basis that the arguments you just described satisfy the legal standard for intrinsic, or provide a sufficient or persuasive basis to avoid the court's view of the balancing of the propensity inference that is most likely to be drawn under 404B, which implicates the 403 analysis the court made.
Your Honor, I appreciate that, and I don't think that comes through in the ruling. I think the ruling very clearly and specifically addresses the pecuniary gain, and the court, may have built in its thinking as to the other two of the state's arguments, but I don't know that that is reflected in the ruling, and I think it would help if it was.
Okay. I understand your position.
Okay. Thank you, sir.
Anything else on a preliminary basis?
No, Your Honor.
Okay. Very good. Ms. Lewis, my apologies. No, it's okay. You can sit down. Oh, go ahead.
Your Honor, I did want to ask, can I move in and out of the courtroom as business requires?
Out of the well? Or out of the courtroom?
Both.
Yes, that's fine.
Thank you, sir.
Thank you. Ms. Lewis, we're here to talk about 3 experts. Happy to handle those in any particular order. I'm happy to have some legal argument and colloquy before or after taking testimony if necessary. What's your view of what the defense needs to do today?
Well, we're handling different experts, but if we could maybe handle Ms. Amon and Dr. Fox first. I think that if Ms. Amon were to testify and then Dr. Fox, and then we could handle that, and then Kathy, you're doing
the other two.
And then Ms. Nestor's doing the other 2, so I don't know if you prefer an order on those. So either order on the others.
And forgive me, with respect to Dr. Fox, nobody's challenged her.
No, she's going to testify if the court needs to hear it about the scientific reliability of the pathway to violence and why it should be excluded as under 702.
So let's talk about that structurally. Okay. If I have one former FBI agent saying this is not the way we do it in the behavioral science realm, and I have another former FBI agent saying this is how we routinely do it in the behavioral science realm, doesn't that go to weight rather than admissibility?
Well, possibly, but I think it might be more extreme than that. And that's why I think it's important we hear their testimony. From my understanding, that the pathway to violence has not been used particularly in courtrooms and doesn't come anywhere close to meeting the reliability standard under 702. And Dr. Fox, formerly, when she worked for the FBI, also worked in this area and has a lot of information about how that study was conducted. And it could be a balancing act, but I actually think it might be such a huge difference that it would go to admissibility and not wait.
Okay. I have some questions for the state on Ms. Amon first.
May I just briefly address the court?
Sure.
Then Ms. Sherbernack will address Amon.
Okay.
Your Honor, because it's the state's belief that the defense has not even met its minimal requirements under Rule 12.
To do what?
That they specify sufficient legal and factual grounds for the motion. Now, even assuming the court disagrees with that, the papers sufficiently address the threshold showing. As the court is well aware, after Ramash, after cases like Clopton and Gun Hill Dairy and the new Rule 702 flipped Ramash, which tended to keep a very narrow gate to allow very few witnesses through, it sort of flipped it upside down, so it catches almost anything. And even if there's two witnesses who say the opposite thing, they can still come in under that new 702. And by virtue of the papers, the state believes it has met its burden of a threshold showing. Now, the court wishes to address specific issues. I just wanted to lay that groundwork. If the court has specific questions, we've got all our witnesses ready to go, as the court can tell. Mr. Throckmorton is here, and then the other two are on the line. So, if the court wishes to proceed on to specific questions about Ms. Ammon, then Ms. Shervanak can address that.
I appreciate the argument. The defendant's initial briefing was certainly sufficient enough for the state to file an opposition brief that had legal analysis, citation to cases, and consideration of the specifics of each witness's testimony. So the state's argument regarding the insufficiency of the defendant's initial briefing is respectfully rejected. I have specific questions regarding each witness. Within the framework that you described, 702, and then if we're past 702, we have to deal with Rule 403, maybe. So whose witness is Ms. Ammon? Ms. Sherman, I can ask you some questions.
Of course.
You just got to pull that mic closer to you. Okay. In its brief, in opposition to the defendant's motion to exclude Ms. Ammon's testimony, on 2 occasions, and in bold print, the state says Ms. Ammon may become helpful to the jury. Under what set of twists and turns at trial do you see Ms. Ammon testifying? Is it in the state's case in chief, or only potentially in the state's rebuttal case, depending on the arguments and other testimony that comes in from the defense case?
The latter, Your Honor. It would be part of our rebuttal case, depending on what potential theories, evidence, witnesses come in through defendant's presentation.
And one of the examples the state gave was, forgive me, that in the state's view, Ms. Ammon's testimony may be helpful to the trier of fact to rebut an argument that, hey, this doesn't happen like this. This is not the way violence gets committed. Wives and mothers don't suddenly kill their husbands. And I understood the state to be saying, well, there's a progression here. People form this plan, unless it's the emotional pathway to violence. But this planned pathway to violence has a progression. It's been studied. This is how it works. Am I inferring the state's argument correctly?
In part. Okay. I think we don't know which theories, of course, defendant will put forth, but there are multiple theories that could come out at trial where Ms. Ammon's testimony becomes relevant to assist the jury in placing the facts and evidence that they have heard into an analytical framework. And again, Ms. Ammon's testimony, and I don't think this is clear from the defense's objection or from their reply, she is a blind expert. She will not be saying Ms. Richins, and also from the declaration from Dr. Fox, they seem to all miss the point that Molly Ammon will not be saying Ms. Richins fits this profile, therefore she committed murder.
Right.
That's not the testimony. That's not what we would elicit. We agree that would be improper, and that's not our intention with Ms. Ammon's testimony. It's more to assist the jury in a framework to understand how targeted violence occurs. Again,
sometimes, right?
Well, Yes, but also Ms. Amon could describe that in every targeted act of violence, and this is part of her proffer, that there is a framework, a pathway to violence that perpetrators of targeted violence follow. Now, do they complete a couple steps and pause? Do they all follow the same timeline in the exact same sequence? Maybe not necessarily, but there is a framework of perpetrators of targeted violence who follow a pathway to the attack. And all of the targeted acts of violence that have been studied, the perpetrators follow this framework to some extent.
Okay. When you say all, you provoke some questions regarding the Diaz versus United States case that was cited in defendant's brief. Now, in fairness, that case has a holding that goes the other way, right? That said the expert there said, most cases it works like this. Most people that are transporting drugs know they're doing it. And a majority of the United States Supreme Court said, that's fine under Rule 704B. That's not a implication regarding the defendant's mental state or what was in their mind, because it's most, not all. And is Ms. Amon in that bucket of blind experts, or is she going to say, no, this is how it works every time?
I think we would have to ask her that direct question. I mean, and she can explain to the court what her answer to that is and why. But I think to say all the time, always, is extreme. I don't think that's what Ms. Amon's testimony would be, but I would rather not speak for her. If that is in fact what her testimony would be, then we need to address that and explore it. But again, when we're talking about a retrospective analysis, which is part of what she's talking about in the studies of the pathway to violence, they know that these perpetrators have committed the ultimate act, right? They have perpetrated their attack. So that is a different analysis than to say, are there other folks who have started on the pathway to violence and not made it to the ultimate act, to the attack phase, if you will? Yes, those people exist, and Ms. Amon would not know who those people are.
I read her proper. She seems to explicitly acknowledge that people stop at various points along the pathway.
That's my point. So
Okay.
to say that if you start on this pathway to violence, you ultimately will commit an attack regardless, all the time, always, no, that's not her testimony, and that's not factual. But for her to say, in all of these multitudes, decades of studies of people who have committed a targeted act of violence, we know the end result. The attack has occurred. We can place those folks on a pathway to violence. We can put them on these steps and identify the steps that they took to that attack.
Okay. All right. Hold on a second, Ms. Lewis. Anything else you wanted to say at this point, Ms. Sugar?
Not unless the court has additional questions on that point.
No, I understand the state's position. Ms. Lewis.
Well, Your Honor, listening to this, it might actually make more sense for Dr. Fox to go first. I understand the threshold is low. However, under Rule 702, the argument here is this is not generally accepted in the relevant expert community.
Doesn't need to be, though. That's one of two ways to survive 702B. If it's based upon a scientific method or sufficient education, training, and experience that's reliably applied to sufficient facts and data. But as a blind expert, she doesn't need to apply it at all.
I disagree. There's a case, first of all, yeah, the argument is that under 702. There's a case that is out of the Ninth Circuit that is directly on point, and
Is it cited in your brief?
No, because I didn't know about it.
Okay,
It's something
can you give it
I've
to me?
just discovered.
That's okay.
Anyway, it is United States versus Wells. Let me give you the site. 879 F 3rd 900. And that case was also a blind expert who is actually one of Ms. Amon's colleagues in writing the profile for violence, and his name is Dr. I don't know if it's Dr. Reed Malloy is the name of the expert, J.R. Malloy. And There's also, and yeah, I'm sorry, I actually just found this case yesterday, but there's also a 403 and 404B argument, because the way this works in courts when they admit profile testimony, which the Ninth Circuit reversed and said this testimony comes in only very, very limited circumstances. They talk about how it's typically used in drug courier cases. This was a case, a homicide case, where Dr. Malloy was using the precursor to the profile for violence. It has very much the same criteria. It has been modified since then. This was in 2017. And he did a profile of killings in the workplace. He was a blind expert, although he admitted on the stand that he had reviewed the case at hand, although he didn't testify. He testified as a blind expert, although he admitted he had reviewed the case and the defendant. And the court ruled that this is improper character evidence, among other problems, because what happens is the profiler testifies that, so people who commit, in this case, workplace murder, have characteristics X, Y, and Z. And then other witnesses get on and say, well, the defendant had characteristic X, Y, and Z, so therefore, in conformity with that character, he committed the murder.
Yeah, but this is different than that. Like, I've looked at Ms. Ammon's proffer. She doesn't make it that specific. I'm sensitive to that concern. And certainly if she was saying, when we look at domestic violence, homicides, what we see are the following characteristics almost universally. She doesn't do anything like that. There's no level of that kind of specificity. She talks more high level in terms of initial grievance, inability to let it go, form of a plan. I may be missummarizing here. But there's a higher level to it. And when we look at Diaz is even more specific, and somehow the majority of the United States Supreme Court is like, they said most, not all. So the trier of fact can draw distinctions. How do I apply Diaz to Ms. Ammon's testimony to say she can't come in?
I haven't looked at Diaz in a while. I'm sorry.
That is one you cited.
I know it is, and I did not reread that case. So I would actually
we can we'll take a break at some point.
Need a moment to review that, to be frank.
Okay. Ms. Shervinack.
Oh, I'm sorry.
Oh, okay.
I do think that it would be helpful to hear Dr. Fox's testimony. For one thing, this routinely isn't used. It's used at NBAU as an investigative technique sometimes, but it's not used in the courtroom. And that's because of all these problems that Dr. Fox is much more qualified to address than I am in terms of it's junk science is what it is. It's not scientific. It's not used in the community. And I think that does stop it even under our low threshold here.
Well, hold on. But come back to the specific context of this case. The state has noticed Ms. Ammon as a potential rebuttal expert, if necessary, to respond to an argument from a defense witness to the effect of, this is not the way it works. This allegation that Kouri Richins killed her husband is not credible because wives don't kill their husbands. People don't just snap and do this. That would seem to make this kind of explanation of how violent crimes are planned and executed helpful to the trier of fact under 702A to say, well, actually, based upon a retrospective study by the FBI Behavioral Science Unit, there is a pathway in which people do this. Full stop. And then the trier of fact can say this is within or without that body of cases. Tell me why that isn't allowable under Utah's Rule 702.
Well,
now, first of all, if the defense doesn't make such an argument, then the state never calls Ms. Ammon.
I think we're going to need some clarification beforehand. If Ms. Richins testifies and talks about that she and testifies that she did not do this,
That denies committing the crime.
denies committing the crime, then how does that not open the door for them to say, well, of course she committed the crime because she's on this pathway to violence?
No, I don't think they get to do that. That would be more like profiling.
Okay. I still have the whole 702 problem no matter how, and this is the first I've heard it's only going to be used in rebuttal. I think we would actually use less time if we let Dr. Fox
Happy to
go through and explain the problems with the reliability of the science and then go from there, if that's all right.
Sure. Ms. Shervan.
The only points I wanted to make, and the court has honed in on this, but in Dr. Fox's declaration that was submitted as an attachment, she analyzes the federal rule 702 and why Ms. Amon's proffer does not fit within that. There are fundamental differences between the federal rule and the Utah rule, and I don't believe that it's helpful for the defense's witness to make a legal analysis about whether Ms. Amon's testimony does or does not comport with Rule 702. That is for the court to do. So
I agree, but I can sort that out.
And Dr. Fox is familiar with the Utah Rule 702 and is prepared to address that.
Well, yeah, but I don't need her to address the law at all. I just need her to tell me her view.
I understand, but she hasn't now analyzed it under the Utah law. All right. Would it be all right if we go forward with Dr. Fox?
Sure.
All right.
Dr. Fox, good morning.
Hi, good morning.
Okay. Sounds like you can hear us okay.
I can.
Let me turn on the video in the courtroom so that you can see Ms. Lewis.
Good morning, Dr. Fox.
Hi, Ms. Lewis.
So can you just please state your name for the record and tell us what your current position is?
My name is Dr. Brianna Fox. I'm a tenured full professor in the Department of Criminology at the University of South Florida. I also hold courtesy appointments at the Department of Psychology and Mental Health Law and Policy, both at USF. I'm a faculty affiliate in the Mental Health Institute at USF, and I'm also the co-founder of the USF Center for Justice Research and Policy.
Thank you. And could you... Oh, did you want to swear her in? We didn't do that.
Yes, thank you. Dr. Fox, would you please raise your right hand for me? Do you swear that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right, please proceed.
All right. And could you briefly describe your educational background for the court?
Yeah, well, I went to Penn State University. I dual majored in psychology and criminology. I was going to be a pre-law, but I actually changed tacks. I went to the University of Florida to earn my master's, and then I earned my PhD instead of my JD from the University of Cambridge in England. My doctoral dissertation specifically evaluated the accuracy and reliability of offender profiling methods, which is obviously related to the issues before this court.
Okay, thank you. And what's your experience with the FBI?
Well, I was an honors intern. That's how I started. I went on to get a position. They asked me to join them in the behavioral science unit as a research fellow. They were actually acutely aware of the problems that they were facing with Reddit assessment and how inaccurate it is. So that's actually why they brought me on, was to really bring that into the modern era, improve it, use statistics and science, which they were sorely lacking. So that's how I got my start. I worked in the behavioral science unit as a research fellow. I was doing research. I was going over to the BAU. I was training people like Ms. Amon, although I didn't actually work with her specifically, and trying to get them kind of brought up to modern standards. Then I got a position as an FBI special agent. I worked in the Las Vegas division, and in between there, I worked with the Tampa field office in the Field of Investigations group. I actually still work with the FBI. I just did a project with them out in Sacramento.
Let me ask you just briefly, you talked about that you worked with the BSU, and I know Ms. Amon has talked about the BAU. What's the difference between those two divisions?
Yeah, the BSU was really their research arm. That was where they were really tasked with doing the data analysis, trying to develop the new, latest, and best approaches for investigative techniques. We would then go on to train both people at the National Academy, that's a prestigious group of law enforcement that come in from around the globe. We would train them, so our methods would get disseminated into their investigations around the planet. But then we would also go to BAU. We would take what we were doing, implement it. We were also trying to train them to bring them kind of up to what we were doing over in the research arm. BAU was very operational. We were the research folks.
Okay. And have you published research relevant to offender profiling and violence risk?
Yeah, that's actually the main part of my job. I have more than 50 peer-reviewed articles. I've written 5 books. I have over 3,000 citations. My work has been published in the top journals in psychology, clinical psychology, law, sociology, criminology, developmental psychology. So my goal is to actually try to create more established and evidence-based risk factors, trying to understand the development of offending. Again, this is an area that we are really lacking in, so there's plenty of opportunity for that science and data-driven research.
Okay. And do you have experience in violence risk assessment or threat assessment?
Yes, I do. I have extensive experience in both violence risk assessment and threat assessment through my academic research. Obviously, I also get federal grants. I work a lot with the U.S. National Institute of Justice. I have applied professional experience working with law enforcement agencies. This was mentioned before this, but there is a distinction between investigative efforts and then obviously applied efforts, in a legal setting. I would say that my experience as a FBI special agent and of course as a research fellow in the FBI's behavioral science unit, where I evaluated and then tried to help improve the scientific validity of both profiling and threat indicators, is what really has motivated me as a researcher, kind of trying to take that old school approach and modernize it, and really trying to assess the reliability and validity of violence risk assessments, as well as these theories of behavior. That's where I won the early career award in specifically my work on developing theory on why people become offenders.
All right. And you heard us talk in court about the different standards and rules. And have you familiarized yourself with the Utah standard in addition to the federal standard?
Yes, I have read about the Utah Rule of Evidence 702. I have testified as an expert in other cases, so I'm familiar with the federal rules of evidence. And I do understand as well just how to evaluate scientific merit and reliability. I was the editor of our field's premier journal, Justice Quarterly. So as a journal editor, it was my literal task to assess scientific merit and how we can really understand, is this a credible theory? Not every theory gets published just because it is a theory. It really has to meet certain standards.
Is there any objection to certifying that she is an expert in this particular area?
Nobody said she isn't.
Okay. Just wanted to make sure as we move forward. All right. So are you familiar with the Pathway to Violence model?
Yes, I am.
And can you describe what that model proposes, just generally?
Yeah, so the Pathway to Violence model is a group-based descriptive framework. It outlines a sequence or phases of behaviors that are thought of being observed retrospectively among individuals. It's really applied almost exclusively to individuals that commit targeted acts of violence like mass shootings or terrorist attacks. To be clear, it is not a diagnostic tool. It is not a validated risk assessment tool, and it cannot be applied to individual cases. It was not created using data. It has no scientific testing or reliability. It is pure theory, and it was postulated by individuals that, frankly, I don't want this to sound mean, but they have no scientific training.
All right. And is it designed to diagnose or predict whether a specific individual will commit violence?
Again, no. It's a subjective, group-based descriptive framework. At best, it applies only to some cases. I thought the judge's explanation of it was great. It applies sometimes, but in other cases, it doesn't apply. So we really have no idea how often that occurs. It applies sometimes, except for when it doesn't. So it's completely disconnected from data and science.
What's the difference between a descriptive model and a predictive risk assessment?
Well, Group-based descriptive models just summarize patterns or characteristics that are observed across groups of people on the average after the events have occurred. That's ones that are created using data. The ones that I'm familiar with, like when I worked in the FBI's Behavioral Science Unit, the infamous, organized, disorganized profiles, they were created just like by thinking about what we see sometimes in cases, and sometimes we don't. Those have also been excluded as being admissible for that same reason. That doesn't mean that you can't use them if you want to investigatively, but you can't use that later on in court to say, this person fits this profile. So predictive risk assessments, by contrast, are empirically tested. You want to be able to forecast individual outcomes before they occur. And just, a distinction from the group-based descriptive method, you really have no idea how often it applies or it doesn't. Unless there's associated data, you really have no clue how often is it accurate. You can use the words mostly, but it's one person's opinion. There hasn't been a scientific evaluation of this to actually say, this often it applies, this often it doesn't. There's no known error rate, there's no accuracy rate, there's no reliability measure. It's just a, guess.
So that's why it's important in a legal framework that the pathway to violence is descriptive framework and not predictive. Yeah,
it's descriptive. It would be like saying that both of us are female, and females are more prone to, I'm trying to even think of an example that wouldn't, that would be kind of as like detached from the data. But we could say, well, both these women would, engage in, they're both in a courtroom today, so women tend to be in courtrooms. It's like, well, just because the two, people that, our judges seen today, both are in a courtroom, that doesn't mean all women are in a courtroom. The example I use in my undergraduate course, every person who went to the moon eats chicken. That doesn't mean that everyone who eats chicken goes to the moon.
All right. So does the pathway to violence, does it tell us how likely it is that someone will engage in violence?
No. That's a major flaw of it. It has no estimates for the likelihood, probability, risk. It doesn't quantify anything. There's no statistical basis behind it. There's no prospective testing, no base rate adjustment, no error rate. All the reliability measures that we would see as scientists, it has none of those.
And can it distinguish between people who commit violence and those who don't commit violence?
No, I think the major, I keep on saying this, another major problem I have with this is there are lots of people that have those grievances. I can name so many cases off the top of my head that will never go on to commit violence. And we have no idea how often people will follow this pathway and literally never commit violence. Or they do some things and then stop and don't commit violence. There's no associated numbers with these. So people who engage in, out of a larger group and engage in similar grievances, thoughts, and behaviors and never engage in violence, we are unaware of. What the pathway to violence model is doing, they're selecting on the dependent variable. They're selecting people that commit violence and say, oh, all those people do this based on, our thoughts. It's not even based on their analysis of data.
All right. So addressing the reliability and the 702 standards, has the pathway to violence been published in peer-reviewed journals?
No, I was actually shocked. I thought I heard somebody say that before this. I trust when I say I've researched this extensively. Book chapters and governmental white papers are not publications. Those are, they don't undergo a peer review process. I've written 5 books, so I am aware of the process. It's not that. I've also written governmental white papers. There's no peer review process. You can write whatever you want as long as the publisher agrees to print it, you're good to go. And Ms. Amon's proffer, the pathway to violence model, was just discussed only one time in a published paper in the Journal of Forensic Sciences. Again, I don't know how to say this without sounding like mean, but that's a predatory journal. They write to me often and ask me if they can publish whatever I want in that journal. It's not like legitimate, like valid journal. And that paper that was published in the Journal of Forensic Sciences, it wasn't even about the pathway to violence model. It was about political assassination in the United States. The pathway to violence model was only mentioned. It wasn't even a study of the pathway to violence model. So it's never been published in a peer-reviewed journal ever to date. And I think that's saying a lot.
When discussing reliability, why is it important? I asked this, I've had battles on this before with experts, but why is it important that it be published in peer review journals as opposed to other journals or just being available?
Yeah, it's not so high of a standard, but that's a standard for a scientific merit and reliability. We don't give things that stamp of approval if it's not reliable and valid. That's not the highest bar in the world. So to say it was never published in a peer-reviewed journal, I really think that's saying a lot.
Okay. Does the pathway to violence have a standardized methodology?
No, and that's actually one of the reasons why it hasn't been published, I would assume, as a journal editor. There's no operating manual. Everybody what I determine to be a grievance could be different than what Ms. Ammon thinks is a grievance or what you think is a grievance. There's no coding sheets. There's no requirement for evaluators to determine these things using the same criteria. There's no uniform objectivity in this. Everybody can look at it and say, that fits, and there's subjective interpretation behind it, meaning evaluators are not constrained to apply the term the same way across different cases.
All right. So different evaluators could look at the exact same fact pattern and come up with opposite conclusions. Is that fair?
Yes, absolutely, because there is no standardized criteria for what these things mean. They're barely even defined because, again, there's so little peer-reviewed papers even discussing it, let alone zero on it. They don't even invoke it in peer-reviewed publications. It's sort of constrained to these side areas. So an example of this would be two evaluators could use the pathway to violence model and can reach opposite conclusions, and there's no way to determine who's correct.
Okay. So is that consistent with things that are admitted as being scientifically reliable?
No, I think it's actually the opposite. Reliability at its core means, the example again I use in my undergraduate course is if you have two people stand on two scales, you would expect that the scales say the same number. That's reliable. If we have somebody stand on two scales at my gym and at my doctor's office and there's two different results, it's literally not reliable. That's the definition of reliability. Or if you stand on the same scale every day and all of a sudden you're getting different results, it could mean that your weight has changed, but if it's 2 times in the same day, probably not. It means your scale is broken. So, this model is broken.
Okay. Is that connected to inter-rater reliability? I know we had discussed that, and I wasn't entirely clear myself on how that is relevant to the acceptable.
Yeah, inter-rater reliability is, again, since reliability is such a key foundational element of what is scientifically valid, inter-rater reliability is basically this idea that if two people use the same construct, will they get the same result? And if people are having the same scale, implementing it, and get different answers, it's not reliable. It just has a basic foundational level. So you would want the same instrument applied and to get similar results. So two people should be able to look at the same case and have a general agreement that this person either meets these criteria, they would agree they're both experiencing a grievance. That's something that you would expect inter-rater reliability, that's mandated for something to be considered reliable. I would actually argue that this doesn't even have the ability to determine if it's reliable, since there's been no study conducted ever on the inter-rater reliability on the pathway to violence model.
Does it have a known error rate?
No. And that's obviously a problem in terms of false positives. You could say, I think this person, or this is what tends to occur on the majority, that somebody would be on this pathway to violence. You have no idea how often that happens. You have no idea how often you're wrong. You could say that is the case, but we have no idea what percentile of the population actually fits that model, because there is no known error rate.
And why is that a problem in terms of admissibility?
Yeah, well, without an error rate, the court cannot assess reliability. A method that you can't quantify how often it's wrong if you literally don't have that number. And this has never been studied. It has no data behind it, so you have no idea how often it's incorrect.
Okay, and has the model ever been applied prospectively to identify individuals then who later actually do go on and commit violence?
Never.
All right. Is there any scientific data showing how often? I'm almost done, but I'm sorry, what? Oh.
No, I didn't say anything. My apologies.
Oh, okay. Is there any scientific data showing how often people identified as being on the pathway then actually never do commit violence?
No, and without overemphasizing this, there is no reliable data on this. And I'm emphasizing it because that was why I was brought into the behavioral science unit. I was the first and only person at the FBI to do research on mass shooters and terrorists on their pathway to violence. That was literally the task I had. I was the person who did it. And this was in 2000. The first time I started on it was 2010. And then the process of getting access to data was, as you can imagine, quite difficult. I was going through all of it. I was trying to code it. I was the first person to do it. No one had done it before. There was no study ever on this. And what I'd been finding, I didn't have the resources to really complete this in the way it should have been done, and it was never published. So that's why I'm also quite sure there's no publications on it. But it really was so much more complicated than what the pathway to violence model suggests. That's such an oversimplification, and it's so inapplicable in so many circumstances. And like I said, there's no known error rate. So we know it's wrong, we just don't know how wrong it is.
So what data was it developed from, the model?
The pathway to violence model, or what I was doing?
The pathway to violence model.
Oh, it's not based on any data. It's based on, I teach a forensic psychology course, and so there's a great line. I really respect the original profilers. What they did was, groundbreaking back in the 1970s, right? But obviously a lot has happened since 1977. What we've expected, in court, DNA, our standards for what we admit into court has changed a lot. But back then, 1977, when they were developing this, that was what they thought was best. And they developed it off of what they called intuition, educated guesswork, and hunches. And so I always teach my students, that was the 70s way, but we're doing this differently now. And the Pathways to Violence model was developed in that same approach. Educated guesses.
Okay. So Ms. Amon, and I suppose others who've worked on the model, believe that it can be applied after an offense has occurred. And is it scientifically valid after offense has occurred to then go back and use the pathway of violence model?
No, that's like a basic logical fallacy. That was probably on your LSAT exam, that you can't do that. Applying a descriptive model retrospectively to infer that the person therefore fits it is like predicting the lottery numbers after the drawing already occurred. I don't know. I don't know how to describe this another way. It just doesn't make logical sense. It is a logical fallacy to do so.
Well, in fact, an example of that fallacy is the 9/11 attacks. Is that right?
Yes, that actually there's the pathways to radicalization. We've toyed around with this idea. They've all been kicked around and kicked down. But that one was the pathways to radicalization profile. And it was this traits shared by attackers. They're young, male, Middle Eastern. And you could say, looking at the 9/11 attacks, yeah, they all fit that profile. But when you apply it retrospectively, there's 55 million, right, plus people that fit that are young Middle Eastern males. Literally, it goes down from everybody who commits terrorist attacks fit this profile to 0.00000. I don't even know how many digits out. 0%. It's basically 0%. It doesn't fit at all. There's no validity. There's so many many people that fit that profile and never go on to commit a terrorist attack. So what's the actual value of saying this is a pathway to radicalization? There's so many people that would fit that and never go on to commit the act. Cherry picking after the fact and saying, oh, all the people fit that, not only is that a logical fallacy, I would actually say that's, it could be a violation of people's rights, to be able to make that implication of them just without even having a 1% accuracy rate.
So how does that relate to the pathway to violence model?
The pathway to violence suffers the same fatal flaw by implying these group-level descriptives. You're first of all applying it, and we have no idea. It could apply to 1% of people that have a grievance. They, go to a workplace nowadays, right? So many people have grievances. So many people are upset. They're feeling stressed by the economy, by their, situation. They even may say, "I'm so stressed, I'm mad." They will never go on to commit violence. This is an extremely rare base rate event, and low base rate events have very high risk of false positives. And when you are now going to take that and enter it in as an expert opinion, obviously, just me as a scientist, as somebody who supports the research in this area, and of course, as an American taxpayer, I feel very concerned by that.
So let me ask you, you heard the discussion before you testified about if Ms. Amon were to testify in rebuttal, that why someone who is a mother or someone who is in the position of Ms. Richins might commit this offense because of being on this pathway to violence. In your expert opinion, is that helpful to a jury, and why is that problematic?
Yeah, I actually think that the risks are so far beyond the benefits. I mean, there's so many people that experience grievances, anger, even violent ideations. There are a lot of studies on that. So there's plenty of research that can be discussed to talk about the base rate of those. They're high, but then when you look at the predictive ability, how often do they go on to predict violence? Extremely low. The reason is because, if we were that good at predicting violence, think about the problems we have when we're talking about parole. We're talking about, risk assessment, when we're looking at releasing people. We're doing, my big NIJ grant was specifically to do risk assessment to try to identify people who are low, medium, and high risk. This is such a big area because we are so bad at it, even with huge amounts of data, huge amounts of research behind us. There's no way that something like this is able to be better than all of the research and data that we have based on hunches. Our data suggests that things like grievances, feeling anger, violent ideation, they have such a low predictive ability to actually accurately predict violent behavior, because violence is a low base rate phenomenon. Lots of people have these types of feelings. Very few ever go on to commit violence. Even if you fit all of them, you literally have a low probability of actually committing violence. I could actually, look that up in a couple of minutes and tell you what the base rate is, but because this pathway to violence model has never been evaluated, anyone who would say, here's what I think, they're just guessing how often someone would actually go on to commit violence.
Let me ask you, tell me if I'm wrong. When I was looking at the pathway to violence, it appeared that the purpose of it was to try and help identify mass shooters, school shooters. Why has this been put together? For what purpose, if it doesn't actually ever predict who will go forward to commit a violent act?
I'm telling you guys, if we were able to predict with any level of accuracy who was going to become a school shooter or a mass shooter, we would have a much better situation in our world right now. Again, even with accurate data, like we're collecting, looking at this, putting very sophisticated predictive models together, we are so unable to predict violence, school violence, these targeted violence offenses, and domestic violence is even harder to predict. As our judge mentioned earlier, the vast majority of them are emotional. They're not these, long premeditated, thought out things. So the emotional dynamic factors actually have a much higher predictive validity than any type of long-term grievance, at least based on research. if we were able to do this, I would feel much better about my young son, going to school soon. I'm terrified because we are so bad at it. Even from a magnet, huge amounts of money being spent on this type of research, we are still unable to do it with any type of reasonable accuracy, because finding that needle in a haystack, someone who meets all of these criteria but is actually going to commit violence, is so hard to do.
Let me ask you, just for sake of argument, if we were to assume that the pathway for violence had some reliability in the area of mass shooting and school shooting, was it meant to be applied in this sort of case?
Oh, no, and that's actually, again, something I talk about in my undergraduate courses. We have this problem, it's like mission creep. We think, because it applies here, it can apply over here, and that's absolutely not the case. A domestic violence type of scenario, of poisoning, they're so fundamentally different in the way those two things are committed, played out. Applying something that is, even without data, created for the purposes of these targeted attacks that do engage in more radicalization behaviors. Applying that to something that's statistically more emotionally driven, that would be very inappropriate.
All right, so just to wrap up, in your expert opinion, should the pathway to violence be admitted as scientifically reliable evidence that a jury can rely on?
No, absolutely not. If we're basing this on reliability, if we're basing it on, how using it to know that this is scientifically valid, it absolutely not. The logical fallacies that are endemic to this, the huge amounts of unknowns, like how often it's wrong, which would be far more wrong than right. It's akin to like the Barnum effect at circuses, or like psychics. That would be the closest, I would say, in terms of how accurate and valid and applicable this would be to an individual case.
I have nothing further.
Ms. Chervenak, do you have any questions for Ms. Fox?
I do not.
Ms. Fox, may I ask you just a couple of basic questions?
Surely.
You went through the FBI Academy at Quantico.
Yes, I did.
Were the pathways to violence taught as part of that curriculum?
No, it wasn't.
Did you have exposure to this during your career in the FBI?
No, I wasn't. There are these, similar models, like I think they call it like pathways to radicalization, and I just learned about that, and again, like while I was in the BSU, that was one of the things that I was brought on to try to revamp and improve.
Okay, thank you. Ms. Lewis, anything further?
No, Your Honor.
Okay. Ms. Chervenak, anything for Dr. Fox? Okay. Thank you, Dr. Fox. You're welcome to stay connected, but you're also welcome to turn off your video and audio.
Thank you.
Ms. Lewis, do you want to ask any questions of Ms. Amon?
Are you not going to put Ms. Amon? Is the state going to put Ms. Amon on, or only if I have questions, I guess would be
Ms. Chervenak, are you relying on her proffer, or do you want to elicit some testimony from her?
I'll elicit some testimony from her.
Okay. Ms. Amon, do you mind turning on your video and audio?
I don't.
May I swear you in, please? Do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right.
Good morning, Ms. Amon.
Good morning.
Your Honor, before I begin with her testimony, Ms. Amon's CV lays out her qualifications. The state's position is that she possesses the requisite knowledge, training, experience, education to satisfy 702A. If the court sees it differently, I'm happy to ask her some of those questions, but I'd prefer to focus my questions directly elsewhere.
I agree that her CV reflects that she has sufficient education, training, and experience to qualify under 702A as an expert in her field.
Thank you, Your Honor. So, Ms. Amon, I don't think we need to go through all of the steps of the pathway to violence. I think the court has the generalized view of it, but what I would like to ask you are a few questions about how this model was developed, and we'll start there.
Sure. So in terms of how the model was developed, you'd have to, I guess, go back. The scientific research leading up to where we are now started about 100 years ago, give or take, when researchers began studying aggression in mammals. Specifically, cats were the sort of the origin story of this line of research. And researchers noticed two distinct patterns of aggression in cats, depending on the circumstances. In some studies, cats were presented with a threatening stimulus, a very threatening stimulus. And in those cases, they demonstrated intense autonomic arousal. So arched back, fluffed tail, hair along the midline, standing on end, that's called piloerection, pinned back ears. They vocalized, such as hissing and growling, fangs out, claws bared, the whole show. You can sort of think of it as that classic Halloween decoration of the scaredy cat with the arched back and all that. And they very quickly lashed out with an emotionally charged and relatively uncontrolled attack with paws and claws. And that was labeled affective violence. It's affective for the psychological term affect, meaning sort of the state of thinking or emoting or feeling emotions. And then in other studies, the cats were presented with prey, like a mouse. And that was a totally different story. The cats were low to the ground, completely silent. Ears, instead of pinned back, they were open to localize sound. And the cats would inch forward. And they appeared to be planning and carrying out an attack at the moment of their choosing, typically with a bite to the neck or head, a very efficient biting attack that ended the fight really before it began. And over the next several decades, that line of research expanded to other mammals, including humans. And what they discovered was that not only do these behavioral patterns hold true in humans, but they're also biologically distinct from one another. And the understanding came now that affective violence, so that reactive attack, is triggered by lower brain structures in the limbic system, triggering an intense autonomic arousal, as I've discussed, usually accompanied by intense fear or anger, and a cascade of hormones, all culminating in a sudden physical defense against imminent threat, which could be real or perceived. It could be an internalized threat. And the evolutionary basis for that in humans is survival. So if you were an early human out on the savannah, there was really no time to ponder whether that movement in the bush was caused by the wind or a predator. The early humans who acted quickly were the ones who survived. In terms of predatory violence, we now understand that to be characterized by a lack of autonomic arousal or emotional experience and no perception of a threat. And that lack of stimulation allows for higher cortical activity in the brain to choreograph an attack that meets the attacker's goals, whatever those goals may be. And the evolutionary basis for that in humans is hunting for food. So early humans on the savannah who hunted with minimal autonomic arousal, no anger or fear, were better able to engage higher brain functions to plan and prepare in advance, and therefore were likely to return with food for their offspring. Those who could not or did not do that were less likely to survive and pass on their genes. And we know that humans, like none of us would be here right now if our ancestors didn't have the capacity for both of those types of violence. So fast forward to now, there have been studies on neurochemicals and hormones, neuroanatomical brain scans with PET and MRI to look at the differences between these two modes of violence, and all of them support the bimodal nature of violence. So that research evolved more or less concurrently with behavioral studies that were going on in the 80s and 90s on attacks against celebrities, judges, governmental figures, and some others, all of which led to a very clear conclusion that intended violence is a process composed of discrete, sequential, and recognizable behaviors. And the pathway to violence model came into being at the conclusion of that time frame based on the biological data and the behavioral observation data from all of the studies, many studies. So that's kind of a 10,000-foot view of the science in terms of how we got to where we are now.
So how is the pathway to violence used in the behavioral analysis community?
We use it not to predict, but to prevent. And that's a very clear distinction that needs to be made. Prediction is not possible. We don't talk about predicting human behavior. We talk about preventing it. I would liken it to if, let's say, I'm your cardiologist and you came to me and you were very overweight, sedentary, hypertensive, you had high serum cholesterol, you had bacon for every meal, and you were super stressed out. As your cardiologist, I couldn't tell you that you're going to have a heart attack next Tuesday morning at 9:24 a.m. But what I can tell you is that you're at heightened risk for a cardiac event, and we need to manage your condition with lifestyle changes and probably some medication to lower that risk. That's how we work in behavioral threat assessment, and the pathway is part of that. It's only applied in cases where where someone has already presented themselves to authorities, to whoever, as raising concerns for violence. So the person is doing something that has brought concerns of violence to the table. Whoever's bringing us the case, maybe it's a school district, maybe it's a workplace, isn't sure what to do, we would begin to look at the behaviors the person is demonstrating, and being on the lookout for possible pathway behaviors is one of the things that we would do. It's actually considered one of one of 8 proximal warning behaviors that we would look at to decide if this person needs a deeper look. So it's a tool. It's one of many tools we use. It's certainly been subject of many studies in terms of whether or not it's valid for measuring what we want to measure, that is, behaviors that raise for us concern about whether or not violence might be on the horizon.
And is the pathway to violence utilized, or could it be utilized in instances of targeted violence that only include one individual as the target?
Oh, certainly. Targeted violence is targeted violence. They all share behavioral commonalities, particularly where the pathway is concerned. If you understand the nature of the items on the pathway, then you also understand that the majority of them are steps that most targeted violence offenders would pass through. Whether you're planning to kill 100 people or one person, you still have to make the decision to do it. You still have to engage in some planning, some preparation, even if it's very, very simple. Some people require a lot of planning and preparation. Some people require very little to get to a state of readiness. But it doesn't really matter what the size of the targeting is. That's not relevant. What's relevant is that certain behaviors must occur in most cases in order to get someone to a state of readiness to engage in planned violence. I'm not talking about unplanned violence or affective violence. That's not really relevant here. But most people will have to pass through some of those stages, if not all.
Is the pathway to violence model generally accepted in the behavioral analysis or behavioral science community?
Absolutely. It's completely foundational to what we do. I know of no learned and credible threat assessment professionals who don't believe in the pathway. It's at the foundation of what we do. It's included in virtually every aspect of what we consider the body of knowledge in behavioral threat assessment, which I used to administer. I'm a former chair of this national certification program in this discipline, and the pathway is very foundational.
And is that something that you would describe as currently used, or is this a past model that was used in the past, or is it a currently used model?
Currently used. Up until about 2012 or so, it was kind of it was the name of the game. It was the pathway. And then right around 2012, we had the realization that it's but one of 8 proximal warning behaviors, proximal meaning close in time to potential act of violence. And so now we tend to look at pathway as one of those 8. So in terms of more recent studies, in terms of its validation, it's the proximal warning behaviors that we look at. We don't usually use the word pathway necessarily on its own, but it is a discrete behavior as part of the 8 proximal warning behaviors. But it's absolutely used now. It's very, very important to what we do.
Now, if you could explain the retrospective analysis and why prospective analysis is not feasible.
Sure. more. All the studies on pathway and proximal warning behaviors are retrospective. In fact, someone asked me at a conference the other day, where are we on prospective research? And my answer was nowhere. We can't do it. So retrospective analysis is looking backward at cases with a known result, so violence. So let's say I want to look at a single-person homicide in a workplace. I would look backwards at the completed event, knowing that it had the result that I'm interested in, violence, and then I would look for what patterns of behavior can I identify that did occur leading up to the violent event, and then code those. And so I would know that those occurred. So a retrospective study would have a sample of cases and then look backward in time and code the behaviors that we know to have occurred. And that helps us to understand what are the commonalities. You can't, Dr. Fox is absolutely correct that those studies can't be used for prediction. They're not predictive validity studies, but what they do is validate the measure as measuring what we intended to measure. Prospective is, you would need a prospective study to truly call something predictive, but to do a prospective study in violence would be to have a case of concern, and then look for what you believe to be pathway behaviors. And once you've identified them, it would require you to sit back and do nothing and allow violence to unfold and then code your data, which is horrible to even think about. None of us would ever do that. So we use retrospective analysis, and it's widely acceptable in the behavioral sciences as a research strategy.
Thank you. Just a moment. Those are my questions for you at the moment. Thank you, Ms. Ingham.
Just a moment. Good morning, Ms. Amon.
Good morning.
So, Ms. Chervenak asked you how the model was developed, and you told us about cat research, but I didn't hear an answer as to how the model was actually developed.
Sure. So in the 80s or 90s, a number of studies were conducted on attacks against public figures, political figures, judges, other people. And in those studies, it became quite clear that the offenders were typically engaging in a sequential and recognizable cascade of behaviors leading to the violent attack. And so that became the pathway to violence. The data collected from those studies showed that 6 particular discrete stages were happening in virtually every case that was studied back at that time. And so that became the pathway to violence. Does that answer your question?
A little bit. So, but the pathway to violence talks about, well, strike that. Let me rephrase. So you used the analogy of a cardiologist. You said this isn't predictive, it's preventive.
Right.
Right?
Right.
So this only applies after an event has happened?
No, not at all. That's how we have studied it. How we use it is in advance. So let's say, for example, you are a school principal, and a child in your school has risen to your attention as raising concerns for violence for whatever reason. Maybe he's got a hit list, maybe he's stalking his girlfriend. So I would look at that if I were consulting with you, and I would ask for everything you know about the situation and the child, and I would look for evidence of these 8 proximal warning behaviors primarily that we know to be well correlated with subsequent violence, including the pathway. And if I saw evidence of any of those, then I would advocate for active management of the case to try to reduce the violence risk. The general rule is that once you observe 1 or more of the proximal warning behaviors, then some sort of active management is necessary to prevent violence. So we're managing behaviors of concern in the present to prevent violence in the future. We don't know that the child is ever going to be violent, but we're not waiting around to find out. We're going to take active steps to try to prevent and manage.
And you have no idea if absent those active steps, would that child ever have committed violence, true?
No idea is a bit strong, but do we know? No, we don't know. That's correct. Someone can certainly ride the pathway all the way up to one of the upper steps and then never do a thing. That's entirely possible.
All right, so you talked about that it has been subject to many studies. Could you tell me what studies this has been subject to?
Sure. Yeah, I was a little bit surprised to hear Dr. Fox say that it has been subject to no studies. The most recent study that was specifically on the pathway and only pathway came out in 2024 in the Journal of Threat Assessment and Management, and they had a very high, actually high inter-rater reliability score in that study. I would say the majority of studies in the last decade are more on proximal warning behaviors is the label that you would have to search by rather than pathway. They're on, almost more than I can count. Public figures, mass attackers, intimate partner homicide offenders, other sorts of family offenders like paternal filicide, maternal filicide, that kind of thing. Workplace, classroom. The journals are really littered with studies looking at proximal warning behaviors.
Are there any peer-reviewed studies that you can point to that adopt this?
All peer-reviewed studies, all of them.
What are they?
Well, I supplied a list to Ms. Chevernak when they first contacted me, but the most recent one that I mentioned in 2024 is called "Are All Pathway Behaviors Observable? A Quantitative Analysis of the Pathway to Intended Violence Model," and that came out in the Journal of Threat Assessment and Management.
So the same one you just told me about?
Yes.
Okay. All right, so it's not a predictive model, it's a preventive model. It's not capable, you can't generate any numerical score, correct?
No.
Using this. And it's not designed to determine if a specific individual is going to commit violence, correct?
No, I agree with Dr. Fox's description that it's a descriptive model. It describes behaviors that have been observed in studies. I would say its operational use is not in prediction but in prevention, which I think is really a key difference in terms of how we use it in the field.
So it could be useful if someone came to the FBI and said they're thinking about a mass shooting.
I'm not sure I take your meaning.
Well, if it's not useful in predicting violence, and it's useful, as you said in your cardiology example, if someone comes in and says, hey, I'm having these symptoms, then, you can help prevent it. So how is this at all useful in the real world? Because people don't come into the FBI and say, I'm having these symptoms, and you can say, well, you are on the pathway to violence, let me help you. That doesn't happen, correct?
Yeah, that's never happened as far as I know, but how it is used is if I'm looking at a case where someone has already risen to the attention of whoever is observing as someone being of concern for violence, maybe they've been making threats, maybe they've been menacing people, maybe they have a hit list, whatever, that can look a million different ways, then I look at the entirety of the case, as many facts as can be gathered, and then I begin looking for signs of proximal warning behaviors to decide if we're in sort of an imminent countdown potentially to an act of violence, and that's where the pathway to violence becomes quite useful. If I observe someone on the pathway, particularly in late-stage pathway markers, then I might develop, depending on the context, I'd have a lot of questions, but I might become very concerned that we're close to a potential act of violence.
Has this ever actually happened in the real world? Where you have stopped violence based on something that was brought to your attention?
Well,
how can you say that has happened?
We can't. That's what I mean by there's no prediction. I can't. So when we see pathway behaviors or other proximal warning behaviors, we intervene. That's our job, is to intervene. So once we've intervened and there's no violence, how can we ever say that there would have been violence but for intervention? You can't. You can't prove what never happened.
All right. It's fair to say that two evaluators could look at an individual and reach completely different conclusions whether someone's on the pathway to violence or not, right?
Not well-trained evaluators.
So your testimony is that people always come to the same conclusion if they're trained in this?
No.
Okay. So people can come to different conclusions, even if they're all both well-trained people.
I think if they're well trained, they should not come to different conclusions on something as fundamental as the pathway. You can come to different conclusions about how close someone is to violence.
But it's subjective, right? It's not based on scientific data.
Well, it is based on scientific data. All those studies that I referenced in the 80s and 90s that helped Brian Foscule, Randy Vorum, and Robert Fine arrive at the pathway to violence. That's data.
The journal we talked about that it was published in.
No, that's a different journal. There are dozens of studies, but we're talking about the study I referred you to is in 2024, just because it's the most recent one, specifically on the pathway and only the pathway. But the journals I'm talking about we're talking like 80s and 90s.
There's no way that the model can tell us how often it produces false positives, right?
Correct.
And you can't tell us the model's error rate. True?
Correct.
You can't quantify the likelihood that an individual identified as being on the pathway will not commit violence.
I can't quantify whether they will or will not. It doesn't work that way.
Yet you believe you could apply this framework in this case?
I don't know anything about this case, actually.
Well, you know what the defendant's charged with.
I believe it's a homicide, but I don't know any facts and circumstances or if there are other charges.
Okay. Are you familiar with the case United States versus Wells?
I am not.
Isn't Agent Malloy a colleague of yours who helped write The Pathway to Violence?
Agent Malloy? Oh, Dr. Reed Malloy?
Yes.
He's not an agent, and he didn't write The Pathway to Violence, nor did I.
So you're not aware, you gave the example of workplace shooting.
Okay.
So you're not aware that that is the exact case that was rejected as the science being unreliable in the United States versus Wells. You're not aware of that.
I'm sorry, I have no idea what you're talking about.
All right. Have you testified in a homicide trial about the pathway to violence previously?
I have not.
Have you testified as an expert previously?
I have not.
Can you give me any examples where the pathway to violence was used in the courtroom at a homicide trial after the fact?
I don't know.
Okay. I have nothing further.
Ms. Sherbanek, anything further?
No.
Okay. Ms. Ammon, thank you. You're welcome to turn off your video and your camera. Why don't we take a 10-minute break, and then we'll come back. Thank you. Come back at 11:10. Thank you. Court's in recess. Manuel.
All right. So they just froze their feed. But so I'm on the Homeland Security, Behavioral Threat Assessment and Management. So they were talking about this pathway to violence. So battle of the experts there. One's retired FBI. Didn't catch what Miss Amen or Amen. I didn't catch what her full background was because they didn't read it into the record. But let's look up. Okay, so that's the Homeland Security's pathway VP training, the pathway to violence. Pathway to violence. Attacks don't just happen, they're the result of a discernible process outlined by the research of Frederick Calhoun and Steve Weston. So you have a grievance, starts with a grievance, then it goes to violent ideation, research planning, preparation, probing and breaching, and attack. Violence prevention training. Let's see if I can pull this up. So, pathways to violence. So there they are. Attacks just don't happen. They're the result of a discernible process outlined by the research. So first you have to have a grievance. You have to have a grievance, airing of the grievances, right? Then violent ideation, research planning, preparation, probing and breaching, and then attack. So are they saying that Kouri had a pathway to violence? Well, she did research and planning if you believe that Eric was attempted to be poisoned on Valentine's Day, which is February. She was preparing by purchasing fentanyl. Her grievance was, what was her grievance? That she needed the money? I guess that would be her grievance. Violent ideation, grievance spawns thoughts or fantasies. We don't know about that. Research planning, I can get behind that. Preparation, I can get behind that. Probing and breaching, final surveillance plan tested. I guess she tried to previously what do you call it? Previously kill him. And then the attack. Let me see what else. What else is out here? Yeah, so the FBI is talking about mass shooters, and they kind of mentioned that about mass shooting. School behavioral threat assessment toolkit. Mass shooters spend time thinking about violence. They plan, they prepare, often share indicators before their attack. I mean, we hear that a lot, where these mass shooters will have a manifesto or they'll write something, you know. I'm not buying that Kouri had a pathway to violence, though. Are you guys? Do you guys think that Kouri falls into this pathway? But did Kouri know he had changed his will prior to this murder? I don't know. I don't think so. She found out afterwards. I think. Hold on a sec. I think let's see, hold on. Yeah, I think it was afterwards. Yeah, it was afterwards. So let me get back here. So they're taking a break. Suppose we could just watch the live view. So that's where we are. We'll just watch that for a little while. Yeah, do you guys, unalivers or unalivers, this is more for psychopaths or sociopaths. I don't think she fits that model. Do you guys? Kathy, I think she would destroy anything that interrupted her scheme. Mallory, no, she thought she was going to get everything, but Eric changed it when he had a hunch she was trying to delete him. I don't think she fits into this pathway of violence. What do you guys think? I mean, I guess anybody who takes out somebody fits in it because A, you have a grievance. You may or may not plan it, but again, we know that planning doesn't necessarily need to take, hours, days, weeks, months. It could just be, I have a grievance with you and you're pissing me off and I see that knife, I'm going to grab that knife and stab you, right? Isn't that planning? Mel, her pattern of behavior is studied after the fact. Southern Bell, can I do a recap? Sure. I mean, we're sort of doing a recap right now, but Dr. Brianna Fox was on. She's retired FBI. She teaches at University of South Florida. She has extensive violent risk assessment experience. She talks about this pathway to violence model. It's not reliable. So she's basically for the defense, and she's saying it's not reliable. She talks about fitting. She talks about the 9/11 attacks and radicalization, pathway to radicalization, and she says you have 55 million young Arab descent males fit this profile, but there's that maybe only like a handful that actually go out and do acts of violence. So that's why she's saying it's not reliable, and the jury shouldn't rely on it. But so then the state comes in with their own expert, and then she started to talk about cats and how they react to a threat. And Aaron's going to make a short out of that. Kouri should not have been laughing. Kouri's sitting there laughing. Oh yeah. All right, we don't need to see her like that. So Aaron's going to make a short out of that. But she says there's no. The job is to intervene, so you can't prove what will never happen. So it's kind of this battle of the experts. One saying that you could predict it, the other saying that you can't predict it. So yes, and cats, exactly. Let's see. Sharon, she failed once and knew her mistake, so premeditated. Kathy, not every red rum is violent, to more than intended. But she didn't like the sister. Yeah, she didn't like the sisters. That's for sure. You're welcome, Southern Belle. I hope it was adequate. Hope it was adequate. Let's see. Sharon, yeah, planning 1 second, but this pathway is more like developing in time. Yeah, that's what I'm getting as well. This pathway to violence is more like, I can see it for like mass shooters, school shootings, that have a manifesto. We see that so many times where a shooter will, whether it's a mass shooting or whatever it is, we see that a lot, where they'll have a manifesto or they'll have, they'll leave something on social media. I don't see that with Kouri. So I don't see that. Mallory, I'm not sure why the state feels they need to go down this path. They don't need to prove why she did it. They can prove she was broke and desperate for money anyway. Yeah. Yes, and cats. Kathy, absolutely premeditated. Surely she tried before at Valentine's Day. She did. Mel, behavioral patterns have to be studied. Then they can serve as predictors. I have no idea. Not knowing what Eric went through, but I'm sure it's quicker than other methods. It's fentanyl, so I think you just pass out, right? Isn't it like a barbiturate, and you just kind of pass out, and then your heart stops beating and all that stuff? Let me see. Sharon, yeah, exactly. Like more like that fit the model. Yeah. So what is like a death by fentanyl? Let's see, death by fentanyl. Let's see. It depresses the central nervous system and respiratory function. Yeah, so it's like a barbiturate. It's like a, downer, if you will. It causes your heart to just stop, and it causes your breathing to stop, and central nervous system. So he basically just went to sleep. I mean, he's way too young to die, of course, 3 young kids, but I guess that's, in the grand scheme of things, she could have like slit his throat and he could have just, or stabbed him 100 times, We've seen those where people are stabbed over and over and over and over again, and they survive for many, many minutes. It sounds like fentanyl, you just kind of just go to sleep and just, narcotic. Yep. Thank you, Amby. All right. Donna, I have no clue what the cats had to do with the pathway to violence. Kind of didn't look good that she had never testified before. Yeah. Well, she was talking about, I think it was more like instinct, right? Instinctual, like the cats they hunch their back and it's like instinctual. I think that's what she was kind of going with. Hey, Allie. Welcome back in. Linda, I think her rich lifestyle and then left in debt was her pathway to violence. Money is the root to evil. Yeah, look at the Paul Canero, Keith and Paul Canero trial that his jury selection is going on right now. We're going to cover that. Once that starts, we're going to cover that. That was all about greed. That was all about greed. The love of money, not money itself. Well, I think it's just being, it's having a lifestyle that you feel you deserve, right? It's having a lifestyle you feel deserved, and then you get jealous because you see somebody else having a lifestyle that you think, hey, I deserve that lifestyle, whatever that lifestyle may be, right? Whatever that lifestyle may be, I think that's where it comes from. So it's jealousy, and then it becomes greed, and then it manifests itself in whatever form it manifests itself. Really? Got something to say over there? Yeah, you want to come over here, talk to the chat? What do you say, Sid? Come here. Yeah, come here. Come here. Come talk to chat. Come on. Come say hello. Little Sid Vicious saying hello. No, that's my water. What do you have to say? What do you think about this pathway to violence? All right. Off she goes. Sharon, fentanyl is so lethal, even touching it can be lethal, and she had so much around the children. We need some cat input. What do you guys think? Sid's pathway to violence is back there. She's back there. There's her pathway to violence. Let's see. Sharon, power, control, manipulation, been happening since the beginning of time. Yes. All right. Southern Bell, email. Go ahead and send us an email. I can't guarantee anything, but please send us an email. Lock them all up. We do, Sharon. We learn something new about our cats. We learn every day. Our cats teach us something, for sure. Everine got me looking at my cat sideways now. All right, so they are taking a 10-minute break. Let's see. When are they scheduled back? They've been off for 15 minutes. All right. Donna, thank goodness you have dogs. Well, hi. What's up, Riker? Or are you Sid? Is that Sid? I think that's Sid. So they've been off for 15 minutes. So we're waiting for Court to come back in. Let me just make sure that I am live. Yes. Okay, Southern. Yep. Just send us an email. All right. JMS. Yeah, I saw that. So that's CL, right? That's CL. I think that was her maid or housekeeper, I believe, saying they didn't sell to. Oh, okay. The drug dealer saying they didn't sell. Yeah, it was only Oxy. Yeah, could be a problem. Could be a huge problem. Huge problem. Yeah, that's gonna be a huge problem, JMS. I wonder if they're going to address that in these pretrials. I wonder if they're going to address that in these pretrials. All right. Amber, quick recap while we wait. Well, we showed some pre-trials. We showed some pre-trial info, pre-trial hearings, I should say. And basically, so far, we've only had two experts so far about violent risk assessment. So, so Dr. Brianna Fox was the first one. I didn't catch the name of the second. So that was the defense, and then the state had their expert come up, Ms. Amen. Maybe I didn't catch, but she didn't put her name on the record. So they were basically talking about this violent risk assessment, pathway to violence. Did Kouri have it? Did she show? So state's going to say she had it. The defense is saying no, she didn't. And we looked at this. We looked at a graph of pathway to violence, and starts with grievance. Let's see, I lost it now. Where was it? Homeland Security. I had it and don't know where it went to right now. Anyway, you have all these different steps. You have 5 or 6 different steps. So you haven't really missed too much. There's only been 2 witnesses, one for the state, one for the defense. So you haven't really missed too much so far. And then at the beginning, but when we first started back at 9 o'clock, we just showed some hearings, previous hearings. So to be quite honest, you really haven't missed much. Iowa Backyard. Wally no longer does the instant fight attack. That was his initial response when he came here. Now he's still getting used to everything. Good to hear. Jaded Wonder, hello. I've been listening while running errands. You're home now so you can chat. Cool. Eva Reen says, is it me or does anyone else feel the state needs to be a bit more aggressive, and maybe that's just these attorneys' courtroom personalities? These are different attorneys. This is not Mr. Bloodworth. These are 2 different. I haven't seen these 2 before, so I don't know what happened to Mr. Bloodworth there. He is, maybe he'll come in later. These are 2 different attorneys. So I don't know what's going on with that. I don't know what's going on with Mr. Bloodworth there. I have not seen Brad Bloodworth. I have not seen these other 2 attorneys. So I don't know. Amber, do a rewatch when you're off work. Yeah, we showed some. We showed the attorneys talk. They talked to the news. We showed some pretrial hearings, and then again, so far, it's just been these 2 experts. Really, you're really not. You haven't missed much, unfortunately, or fortunately, I don't know. It looks like they might be coming back.
Right.
Area where we see this happening. But it wasn't an expert witness exactly. It was a detective who was testifying based upon experience. And based on his experience, he said that in all his years as being whatever kind of agent he was in drug cases, he always saw this same profile of drug couriers.
I think he said most, didn't he? Isn't that the distinction?
It might have been, I don't know if it was all or most. It was most all.
The key part of the case is that he said most, and that's how Justice Thomas said, well, that's not impermissible under 704B because it acknowledges that there are some outside of most who don't know.
Either way, it's different because he was an experienced witness, not an expert witness. And in this case, Ms. Amon is not an experienced witness. She didn't write this. She hasn't done, she can't get up there and say what the detective said in that case because for a number of reasons. Other people did the studies.
May I cut to the chase a little bit here to see if we see it the same way? I agree with the defense that under cases like United States versus Wells, the expert testimony that Ms. Amon offers cannot be used in the state's case in chief and cannot be used in any part of the case as substantive evidence of defendant's guilt. Here, though, the issue, based on the briefing, is more nuanced. It seems to me that the state could use Ms. Amon's expert testimony in its rebuttal case, and only to rebut a general categorical assertion by the defendant in her defense case that this is simply not how it works. This is not credible that someone would engage in a weeks-long campaign to kill someone in the absence of an imminent threat to their life or some kind of emotional or extreme impetus. If there's that kind of categorical, generalized argument made by the defense, then I think this testimony from Ms. Amon, which is based upon a retrospective study of killings that actually occurred, saying in the retrospective study of killings that actually occurred, people did plan them over a varying level of time, and there were steps they took along the way. As long as the prosecution did not turn the corner in closing argument to say, well, we showed you elements of plan and preparation on behalf of Ms. Richins. You heard Ms. Amon, so that shows it's more likely than not that Ms. Richins killed her husband. They can't do that in closing. That would be using an inappropriate profile-like argument. But to rebut a categorical, generalized statement from the defense that this is simply not the way homicide works, I think that would be helpful to the trier of fact under 702A. Tell me why not.
Well, first of all, this would be the first time that it's ever used that way. You heard Ms. Amon, this has never been used.
Well, that may be because it'd be the first time that a defense has ever made that kind of argument, but I'm not sure we're going to have to cross that bridge here.
Well, we may not, but I think it's never been used because it's not reliable. The study wasn't made even though to pick out individuals who commit violence. It was developed, she said, the only time...
They're not using it predictive in my hypothetical. They're only using it to rebut a generalized statement of murders don't get planned like this.
Well, it can't be used predictive. I think that was pretty clear.
Right, I'm agreeing with you on that. We're past that.
All right, so my point is that when she talked about individuals, though, she talked about how the study applied to assassinations. The study was not developed in any way, shape, or form to look at this sort of instance.
Let's be careful here. I think there's a side of the V that would call this an assassination of a non-political figure, but nonetheless, stay focused with me. Why wouldn't that be helpful to the trier of fact under 702A to understand sometimes killings are targeted? We know because we've studied killings that have actually occurred. Sometimes they're planned. Sometimes they take time for that plan to develop.
I guess I don't understand how that's helpful. Yes, isn't that general knowledge that sometimes killings are planned? I don't understand.
I don't know if it is or not, but it's that would be like if the defense is going to make the argument, these things are never planned. This is simply not the way it works. Now, I don't know if you're going to make that argument, but you're asking me to exclude Ms. Amon under any circumstance, and I'm not sure you've carried that water.
Well, we're asking that she be excluded because it's under I'm going to move also under 403 and 404B. It's highly prejudicial for someone to get up there and tell a jury, I'm an expert, and it's if we were to make that argument, which I don't know. Let's see, we were to make the argument. She's a mother. She wouldn't have killed the father of her children. How prejudicial is it for someone to get up who claims they're an expert, who's not an expert, never has testified, never has used the study in this way, and then tell a jury why we're wrong?
Yeah, you changed my hypothetical. Ms. Amon doesn't comment in any way on the specifics of one mother killing her husband or the father of her children. I'm not suggesting you can't make the argument that Kouri Richins had so much to lose by doing this, it reduces the likelihood that she did it.
But that opens the door for Ms. Amon to come in under your hypothetical
No,
to
it
say,
does not.
no, that could happen.
Please stay focused.
Okay.
A general, absolute, categorical statement by defendant. Murder doesn't happen this way. They're always emotional. They're always in response to a threat. They're always as part of a fight or as part of a criminal enterprise. I don't know what you'd say, but if you want me to exclude her entirely, I'd have to say that there is no set of circumstances in this case under which her testimony would be helpful to the trier of fact, and you haven't carried that burden.
So you're saying that, in your view, the only way her testimony could be relevant is if the defense says this kind of murder would only happen in an enraged emotional state.
Yeah, or in response to a threat.
Or in response to a threat. That's the only way this is coming in.
Right. That seems to be correct. Tell me why that isn't correct.
Well, I don't know that we really even have a problem if that's the court's ruling, that it's only coming in under one specific circumstance. I just think our general objection, though, is that it's just not reliable under 702 under any circumstance. It doesn't matter what the circumstance is. I think that...
This is why I'm not persuaded by that. The defense keeps, at least implicitly, taking the position that if two people could apply this framework and reach different conclusions, it's not scientific, it's not reliable. Is that one of the defense arguments?
Well, one of many.
Sure.
It's not.
Now, that would mean that every physician that testifies in a medical malpractice case is unreliable, because in every single medical malpractice case there are competing expert testimonies regarding the standard of care and whether it was breached. And they're both admissible, and it all goes to weight, not admissibility.
I thought about that as I was listening to her testimony, and I think the difference is, and I don't do medical malpractice, but I think the difference is when we have competing medical experts, it's typically based on actual scientific research and knowledge, and
or
they
their
might have different
training and experience. They're not citing studies most of the time.
But it's based in science. You can get two experts who have a different opinion when they apply the science, but this isn't any applied science of any kind. This is just a completely subjective theory.
But the law enforcement expert in Diaz wasn't applying science either, but he was offering specialized education, training, and experience. That's the subject of Rule 702.
Well, he was not an expert, that's true, but he was
in
applying...
Utah, he would have to be qualified as one in order to say what he said.
I know we see that in federal court all the time. They're applying their own experience. I am a DEA agent. I have arrested 1,000 drug couriers. Of those 1,000, the vast majority fit these characteristics. That's very different than what Ms. Amon wants to testify to. It's very different.
I think the rigor of Ms. Amon's testimony is greater in terms of, here are the studies. We looked at killings that actually occurred, identified these factors. We've published it. We've added it to the model. This is how we use it, full stop.
But none of those studies, well, first of all, she really didn't tell us what any of those studies were, but...
This goes to weight, and Dr. Fox will be able to tell the jury why this isn't going to help you make these decisions.
That's correct. But if none of the studies have to do with the domestic violence case, how is that helpful to the trier of fact?
Because if you're going to make a categorical people don't murder people this way statement, it has nothing to do with domestic violence anyways.
And I think one of the other problems is when she stated you can go all the way down the pathway of violence and then they don't commit a murder. So how is that even helpful?
That increases the reliability of her testimony instead of decreasing it, because it acknowledges that there are people on the pathway that fall off. So it's a most, not all, a la Diaz.
Okay.
You're going to want the last word because I think the state's going to quibble with my ruling here. Ms. Shervanek.
Your Honor, I don't know that I have much to add. I think that the type of testimony that Ms. Amon would offer fits squarely within 702. She has specialized knowledge that would assist the trier of fact in making a fact of consequence more or less likely, and that they could they, being the jury, could use the analytical framework of the pathway to violence, taking the facts that they've heard presented or theories that they've heard presented through witnesses and applying them to a framework that Ms. Amon lays out to understand how a person in a position commits a murder under certain circumstances. That testimony assists the jury in understanding how this case could play out, how it explains a theory or rebuts a theory put forth by the defendant about how this murder was committed and why it was committed. And the jury can use the framework that she presents or wholly discount it if they find it doesn't apply, and that would be up to the jury to decide. But given the type of testimony that Ms. Amon proffered and that we expect her to present as a rebuttal witness, it fits solely within 702, and for those reasons it's admissible.
Okay, I understand the state's position. Ms. Lewis, anything further?
I guess my last word is just that under 702, I don't see any scenario under which this is a reliable science that could be presented to the jury. And I also don't think the testimony was that the pathway to violence is a most. It's an occasional. It's a few. So I don't think that they're... To admit this as reliable under Rule 702 in any matter, I think is inappropriate.
Okay. All right. All right, the issue before the court is whether Ms. Amon's proffered expert testimony should be excluded in its entirety. The motion is made under Rule 702 and 403 of the Utah Rules of Evidence. The court addresses Rule 702B first. It provides that scientific, technical, or other specialized knowledge may serve as the basis for expert testimony only if there is a threshold showing that the principles or methods that are underlying in the testimony are reliable, are based upon sufficient facts or data, and have been reliably applied to the facts. Here, first, it bears noting that Ms. Amon is being offered as a blind expert. She is speaking about general principles, not applying a framework or analysis to the specific facts of this case. Moreover, her testimony is based upon a retrospective study of killings that actually occurred, and based upon that retrospective study, her testimony identifies some commonalities that exist among completed killings, while also acknowledging that people that begin on the so-called pathway to violence often fall off at any of the stages, sometimes begin again and then fall off again. That just because they begin on the pathway does not predict or mean that they will complete a killing. Under Rule 702A, the court finds that based upon her education, training, and experience, as shown in her CV, Ms. Amon is qualified as an expert in this field. And the court finds that her testimony based upon that retrospective study is sufficiently reliable and based upon a sufficient set of facts or data, given her description of those retrospective studies and their updates over time, to satisfy the minimal threshold for reliability under Rule 702B for a blind expert. The real issue is whether her testimony would be helpful to the trier of fact under Rule 702A, and under what circumstances. To be clear, under cases like United States v. Wells, 879 F. 3rd 900, which is from the Ninth Circuit in 2018, Ms. Amon's testimony cannot be used by the state in its case in chief as substantive evidence of guilt. And even if she's called as a rebuttal expert, the state cannot refer to her expert testimony as as a basis for the jury to draw comparisons that would weigh in favor of a substantive finding of guilt. However, in the event that the defense makes an assertion in its defense case that is categorical and general, for example, something to the effect of that it's simply not credible that a person would engage in a weeks-long campaign to kill another person in the absence of an imminent threat to their safety, then Ms. Amon's testimony regarding the retrospective study of completed killings showing a feature such as a preparation and plan over time would be helpful to the trier of fact under Rule 702A to rebut that generalized categorical assertion by the defense. If the defense makes an assertion to the effect of Kouri Richins did not commit these crimes, and one of the reasons you can be sure of that is because Kouri Richins had so much to lose in her personal life and her family life if she had, that is a case-specific level that Ms. Amon's testimony would not be helpful in rebutting. However, if the defense makes a absolute or generalized categorical statement regarding how homicide unfolds or whether it ever unfolds as alleged in this case, Ms. Amon's testimony would be helpful to the trial of fact in rebuttal. And it would not be unfairly prejudicial in a way that substantially outweighs its probative value, because it would not be able to be used by the state as substantive evidence of guilt. Rather, it would only be used to rebut the defendant's categorical assertion regarding features related to homicide. The court acknowledges that pursuant to this ruling, the likelihood that the defendant is going to make such a categorical high-level argument is pretty low, which means that the likelihood that Ms. Amon will ever be called to testify is also pretty low. But the fact remains that there is not a basis to grant defendant's motion in full, because there is a cognizable basis upon which her blind expert testimony would be helpful to the trial of fact under Rule 702A, and which its probative value would not be substantially outweighed by the danger of unfair prejudice under Rule 403. So, the defendant's motion to exclude Ms. Amon's testimony is granted in part and denied in part. She cannot testify in the state's case in chief. The state cannot use her testimony, even if it comes in rebuttal, as substantive evidence of guilt, either directly or by inference. And her testimony would not be helpful to the trier of fact to rebut case-specific assertions of why Kouri Richins did or did not commit the act she's accused of. However, if the defendant makes a categorical assertion regarding how homicides unfold, the court will revisit this issue to determine whether Ms. Amon's testimony should be allowed in rebuttal. Let me pause there for a moment. Ms. Shervanek, do you need any clarification of the court's ruling?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Ms. Lewis, where would you like to go next?
We do Throckmorton.
What do you do, Throckmorton?
Yes, we're Mr. Throckmorton would be
Okay.
next, so Ms. Nestor will be. Do you want to move, or are you okay there?
Ms. Nestor, I have looked at Mr. Throckmorton's report from June of 2023 and his amendment in March of 2025. I'm really familiar with him from other cases in terms of his background and his method. Tell me what you see as the problem in this case.
So, Your Honor, can I come to the...
Wherever you're
I
comfortable,
hate bending
please.
over to
Yeah.
reach that microphone. Hold on. May it please the court, good morning. Your Honor, as far as Mr. Throckmorton's testimony, the objections that we have to his testimony, it's basically focused on the first prong of 702, which is whether or not his testimony can be of any assistance to the finder of fact. And the main concern is his conclusions or lack thereof are basically, I looked at this, I cannot say at all whether Kouri Richins signed Eric Richins' name or didn't. I can't say she did. I can't say she didn't.
Right. You skipped a step, though.
Right. Well, I'm getting.
I mean, he does say with a much higher level of probability that Eric Richins didn't sign it.
Right.
He just can't say that it was with the same level of probability or any, depending on the document, that it was Kouri Richins that made the simulated forgeries.
Right, and the concern that we have is his materials that he provided and that we expect would be laid forward before the jury. Take little pictures of letters and compare them, and all of us are human and we all have eyeballs, or those of us blessed with the sight have eyeballs that work, and we are tempted to look at those things and compare them and contrast them, and it goes back into a jury room. And the bottom line is they're calling the expert to say, I cannot draw a conclusion that Kouri Richins signed these, signed his name, signed the initials. Even his finding that Eric, I believe the finding he had was a strong probability that Eric Richins did not initial the documents, not that he didn't sign the power of attorney, but that he didn't even, a strong probability he may not have initialed them, which is not even to the standard of, beyond a reasonable doubt. It's not anything close to that. And the concern that I have is you're taking an expert who is going to basically say, here's all this stuff, I'm going to send this back in the jury room, y'all can sit there and look at these initials, you can try to figure it out yourself if you think that he did it, but I'm as an expert saying I can't say Kouri Richins did.
May we pause there for a minute?
Yeah.
So my understanding of Utah law is that lay jurors can, in fact, compare signatures in the absence of expert testimony. That is something they're allowed to do.
They can, but the problem is you're trying to layer on top of that this expert who is giving an opinion that's a non-opinion to support a finding that the state wants, right?
Okay. Well, maybe.
And it's not supported by the science. The second prong that we're attacking...
Pause with me for a minute, though.
Yeah.
I apologize.
No, it's fine.
So the concept of the state showing documents and arguing to the jury, take a look at these. You can see with your own eyes that doesn't look like Eric Richins' signature. That is permissible argument, and that is a permissible way to admit that evidence, correct?
I think they could try that. I mean, they could do that.
Right. Okay.
Right.
Then we look at, all right, does Mr. Throckmorton's analysis assist the finder of fact in determining whether the state has carried its burden of showing beyond a reasonable doubt that defendant forged some documents, right? And a step along that way, from the state's perspective, is, well, first we need to show that Eric didn't sign them.
Right.
So focus on that part for me for a moment. Why isn't Mr. Throckmorton's testimony admissible on that part?
Well, one big reason is that the initialing, there is no statement at all that Mr. Richins, so there's two documents at play. There's a power of attorney, which according to Mr. Burmester from the county, they're not even going to get into that unless we introduce the power of attorney as an exhibit. They're not even planning on doing it in their case in chief, which I just found out this morning.
Okay.
But let's say hypothetically for some reason we need the power of attorney. They're not even saying he didn't sign it. Like, their expert is not saying that's not his signature. They're only questioning whether he initialed each and every little blank on the side, right? Of which the expert cannot say. He cannot say he didn't. He cannot say to any degree of certainty whether Kouri did. He said absolutely no conclusion as to whether Kouri did, but he also can't say for sure that Eric didn't.
Well, doesn't he say that there is a strong probability that Eric Richins did not author the ER initials on the power of attorney that defendant allegedly used to obtain a HELOC?
Yes.
Okay. He's used a strong probability for that opinion, right?
Right, but that also provides for the possibility that Eric did initial it, right? I mean,
certainly,
yeah.
and the jury can weigh his testimony.
Right.
In terms of admissibility, it would seem to be helpful to the trier of fact to receive an opinion from a qualified expert as to whether Eric Richins initialed a document or not, right? Because if he didn't, it leaves open the possibility that somebody else did. And then when we go to, well, does he have an opinion as to whether Kouri Richins was the one that initialed it? Right. I acknowledge that his level of certainty there is much lower, if not, there's no conclusive proof one way or the other.
Right.
But why wouldn't you want to let that in?
Right. Well,
if the state wants to call him to say it, it certainly doesn't hurt defendant.
Yeah, if he testifies at all, trust me, we do want that to come in.
Yeah.
The concern that I just have is just misleading this jury about these floating standards, because under the National Institutes of Science report, under the PCAST reports, the reliability of subjective handwriting analysis has been brought into serious question by the general scientific community. I provided those materials in my brief. And to have a layer of persuasion going to the jury of an expert that is relying on a science that has not been generally accepted by the national scientific community. And I specifically identified where in the NIST report and where in the PCAST report the scientific community says, look, this is just a subjective. It's no better than if me and you and the deputy all sat down and just guessed if it looked like it matched.
Doesn't Mr. Throckmorton reference studies saying that certified handwriting analysts are better than the lay public at identifying differences in simulated forgeries?
He does, and we would obviously attack that if he took a stand vigorously. But yes, he does. He states that in his report, which may be enough to get you past the gatekeeping requirement. That's up to the court. I do also have some real concerns about whether portions of this needs to be redacted. One of the conclusions he was asked to, or he wasn't even asked, he did it sua sponte, I think only applies if it's a court, but he did it on his own when he was submitted the documents in question. One of the documents he was submitted on the amended report as recently as a few months ago. Now we're, 3 years after the death, and he's just now being submitted new evidence, right, to evaluate, but that's what happened. And they gave him a report by the like a notary page where the notary had signed, and he just on his own makes a conclusion that a date has been altered, a number, not a letter, not handwriting. There's no evidence whatsoever that either that was asked of him to do, that he's qualified to do that there's any science backing that up.
I don't know that the state's offering that opinion at trial. Am I right about that, Mr. Remerson?
I don't even know what she's talking about.
Okay, so it sounds like a no.
Okay, well then if that report comes in, we're going to ask to redact that section of it.
Reports don't come in, they're hearsay.
Okay.
His demonstratives may come in.
Okay.
He does, in fact, have demonstratives, and those will need to be disclosed to the defense, but the report's hearsay.
Right. And also whether or not, that'll go to wait. We'll deal with that when he takes the stand. So I think really that it's really a two two-based argument that we've presented to the court. Two bases for our argument. One is that we don't believe it's helpful because there is no conclusion. Number two, we question the science of handwriting analysis. I've provided the court with the scientific community's concern about the reliability of handwriting analysis, that it's really slowly but surely being relegated to junk science. And on that ground, we think, and what it adds is minuscule. It provides no guidance to the jury. So as far as we're concerned, if you're going to exercise a gatekeeping function at this point, this would be the point to do it. And we would ask that he be prohibited from testifying as an expert in this case.
Okay. You'll get the last word.
Yep.
Mr. Burmester.
To clarify, the state would offer Q1, Q2, Q4 in the event arguments come out in the defense case in chief. I don't know, we come up with 100 hypotheticals, but maybe something, she's a great businesswoman and somehow puts into question evidence that we might offer, which could include that power of attorney.
And Q1 and Q2 are definitely the power of attorney. Is Q4 also?
Q4 is when Mr. Throckmorton is asked, all right, we have some knowns from Ms. Richins.
Right.
Now, do the same thing you did.
Okay.
So, with regard to those would only, that is how I would see us calling Mr. Throckmorton in rebuttal. Main point is there's not an agreement that they have to introduce the power of attorney before we would introduce it. It would be a whole set of facts that might make that come about.
Is the power of attorney, forgive me, I didn't go back and look, is the power of attorney the basis of one of the forgery charges?
It is not.
Okay. So why would the power of attorney be discussed in your case in chief at all?
Oh, I'm not offering the case in chief.
Okay,
That's precisely why.
I see.
It would have to be some facts that arise in the defense case.
Got it.
That would implicate offering that exhibit, and therefore its authenticity would be at issue.
Understood.
Okay. So that leaves us with just the true stage application signature, which is indeed at issue, identity of the forger and identity of that insurance fraud count.
So there I understand the state's argument to be Mr. Throckmorton helps the trier of fact determine whether we've carried our burden on the forgery count related to that insurance application, because he says, he opines that it was probably not authored by Eric Richins, and it appears to be a simulated forgery. Full stop.
Yes.
Okay. And that, in the state's view, is circumstantial evidence that makes it more likely that it was forged by Ms. Richins.
Yes.
Given other factors related to motive, access, etc.
Yes.
Okay.
I get this. I was in the courtroom in Gersh v. Gersh, so I know the court is familiar with Mr. Throckmorton, and we've proffered all those in our pleadings, all his qualifications. So I don't intend to talk about that. However, there is a notion, and Mr. Throckmorton is here, President Court, we can call him as a witness. He would talk about how handwriting comparison has been used in courts for 200 years, and since the 70s there's been an intense professionalization of that theory, and that history goes to prong C for demonstrating its threshold. I would also just like to address two other things, and that is the pathway forward, 2009. where the scientific community, who's addressing all, what is the status of every single forensic science, and there's a portion about handwriting, and the committee agrees that there may be some value in handwriting analysis. The scientists who composed this document, of course, hold DNA at that time as being the gold standard. Obviously stated there were some things that need to be addressed, but certainly doesn't say it ought not be admitted. PCAST doesn't even directly address handwriting. It says all these other sciences like handwriting, these same things should be applied to them. But none of them say scientific community is rallying around some notion that it's junk science.
Certainly not in the state of Utah. I've looked. I cannot identify any time that Mr. Throckmorton has been excluded in the state of Utah. I can only find cases in which he's been admitted as an expert.
Unless the court has further questions.
I understand the state's position. Ms. Nestor.
Nothing else, Your Honor.
Okay. Before the court is the defendant's motion to exclude the expert testimony of Matt Throckmorton. Mr. Throckmorton is offered to testify that the Eric Richins signature on the True Stage insurance application that is the subject of the charged forgery was probably not authored by Eric Richins and appears to be a simulated forgery written by someone who is familiar with or has access to Eric Richins' known signature. In addition, Mr. Throckmorton has been noticed as someone who may offer testimony in rebuttal or impeachment that there is a strong probability that Eric Richins did not author the ER initials on a power of attorney that the defendant allegedly used to obtain a HELOC on the Richins home, and that there are mere indications that the defendant wrote those initials. The court determines under Rule 702A that testimony, which would come in the state's case in chief and perhaps in rebuttal, respectively, is helpful to the trier of fact because it would assist the trier of fact in determining whether the state had met its burden to show that Ms. Richins committed the charged forgery count regarding the True Stage insurance application and may be relevant to show Ms. Richins' conduct related to the HELOC in rebuttal. Moreover, based upon the court's review of Mr. Throckmorton's CV, his education, training, experience, and his substantial history and experience in testifying, certainly in state courts in the state of Utah, the court finds that he is qualified as an expert in the field of handwriting analysis. Regarding defendant's objection to the reliability of Mr. Throckmorton's analysis, the court finds that his analysis and his methodology, and therefore his testimony, are sufficiently reliable under both rules 702 subsections B and C. Under C, the court finds that Mr. Throckmorton's analysis, because it is performed consistent with and measured against the SWIG-DOC standards, is generally accepted by the relevant handwriting analysis community. Moreover, even putting that aside, the court determines that his methods are reliable inasmuch as he is able to describe the way he compares the questioned documents to known samples of both Mr. Richins, the decedent, and also Ms. Richins, the defendant. He applies that reliable methodology to a sufficient set of known signatures, and he does so in a way that does not ignore any uncontroverted features of those signatures or other uncontroverted facts. That is, he applies his methodology to a sufficient set of facts or data in a reliable manner. Therefore, his testimony is admissible under Rule 702B. Finally, the court is not persuaded that his testimony, the probative value of which has been described, is substantially outweighed by the danger of unfair prejudice or other concerns under Rule 403. For these reasons, the defendant's motion to exclude Mr. Throckmorton in his entirety as an expert witness is respectfully denied. Mr. Burmester, do you need any clarification in the court's room?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay. Next.
Ms. Bonino
Okay.
is next, which Ms. Nestor is also handling that one.
Very good. You ready to turn to Dr. Venino, Ms. Nestor? Ms. Shervanek, is this one yours?
Yes, Your Honor.
May I ask you a couple of questions?
Yes.
Okay. Ms. Shervanek, is there any admissible evidence of domestic violence by defendant against Eric Richins prior to the allegations related to February 14 of 2022?
I don't believe that would be presented in the state's case in chief.
Okay. Is there any admissible evidence that Eric Richins had any subjective knowledge that defendant attempted to poison him on February 14, 2022?
That he had knowledge of it?
Right.
Yes.
Tell me what admissible evidence there is of that. We went through this for a couple of hours with Mr. Wright.
We did.
I spent some time on this yesterday. I don't know that there's any other admissible evidence that would show that Mr. Richins knew that anybody had attempted to hurt him.
Just, may I have a moment?
Of course.
So they're talking about did Eric know before February 14th? That's the question. Did Eric know that Kouri was trying to poison him or do something to delete him before February 14th? So right now, judge is saying he doesn't see any of that evidence. And the state is saying they're not going to present that. They're not going to present that in their case in chief. So let's see where this goes.
I think the court is aware of what the admissible evidence is, the testimony from Josh Kays and Cody Wright, that
Cody Wright's not going to testify, as I understand a trial, pursuant to, not at least regarding the events of February 14, 2022. I don't think he has any admissible testimony regarding that day.
He does. His admissible testimony are his observations, not the content of Eric Richins' conversation, but his observations about Eric Richins' demeanor.
You didn't see him. It was all on the phone.
Right, but his hearing observations about his voice, how he seemingly sounded on the phone during those conversations, and not the content that aren't admissible because of hearsay rules, but there are observations that he could make through that phone call that is admissible.
Proffer that for me.
This is exactly what Mr. Wright testified to previously.
I don't know that he can give that testimony regarding his observation of the manner in which he was talking without saying what he was saying.
I disagree.
You're proffering that Mr. Wright would say he sounded scared?
That he sounded somber, that he sounded concerned. I don't remember the exact words that he used when he testified, so I don't want to misstate those. But certainly he testified that during that phone call, Mr. Richins had a certain demeanor that struck him and that he remembered, and then he testified to what that demeanor was.
Okay. All right, let's assume that comes in. Anything else?
There are also text messages between the defendant and Eric Richins about the sandwich that was left, and
So let's be specific. There's a text message from June between defendant and her friend indicating that she left a sandwich. And then there's a text message from Eric to Kouri at 11:33 a.m. on February 14 saying he's not feeling well, I'm going to go lay down. If I don't feel well, I'll go to the hospital. Anything else?
later in the day. Sorry, I don't have all of those messages at the forefront of my mind.
That's okay.
Your Honor, late in the day, late afternoon on February the 14th, there are text messages between the defendant and Eric Richins, which don't directly, he doesn't directly say something like, you just tried to poison me or something.
No.
But the state will argue that his messages and her non-responses for several hours, and then their ultimate exchange about he says something like, I got dinner for you and left it on the seat of your car, or on the seat of my car. The state will argue that those indicate he was well aware of what happened on February the 14th at about 11 a.m.
Okay. All right. Okay. My concern is that in the absence of admissible evidence, in the absence of the jury hearing the content of Mr. Richins' statements to Kouri Wright, there isn't a basis for the jury to conclude that Mr. Richins was acting inconsistently by staying with Ms. Richins or not doing something more acute between February 14 and the day he ultimately died. And without a reasonable basis to find that he acted inconsistently, I'm not sure why Dr. Venino's testimony is helpful to the trier of fact. And I'm more concerned that under 403, it would invite the jury to speculate about whether there was, in fact, a prior history or prior experiences of domestic violence that aren't in the record.
I think there are other instances, other facts that would be presented at our case in chief that are maybe not on their face what people typically consider domestic violence, meaning physical abuse. And that's the crux of it. For example, if there is infidelity, why do you stay in a relationship? For example,
But
if
does Dr.
someone is...
Venino have anything to say about that?
What's that?
Does Dr. Venino have anything to say about that?
I think these go to the counterintuitive behaviors. These go to manipulation and control that exist outside of physical abuse in these types of relationships, which is exactly what needs to be explained. Because the jurors may have questions of, why wouldn't you leave if you knew you were being cheated on? Why wouldn't you leave if you thought this person was taking your money?
Well, hold on. The lay jurors are perfectly capable of figuring the first one out in their everyday experience. The second one as well. The state, I think, has a more thought-provoking point of, if you knew somebody tried to kill you, why'd you stay with them? Now that, I understand, would require or may allow the admission of specialized knowledge regarding domestic violence relationships and cases. I got that. That's, I think, a valid argument. I'm just not sure there's any foundation for the jury to conclude that this relationship involved domestic violence before Mr. Richins ultimately died.
I think that the court is considering this as domestic violence in the context of a typical physical abuse case that we're not alleging.
I'm not suggesting otherwise. I'm more concerned with Dr. Venino talking about it that way.
And she would not.
Then what does she do that's helpful?
It's in her proffer. She can certainly testify to it, but it is the counterintuitive behaviors, it's power and control and manipulation outside of physical abuse that does not include physical abuse.
Okay. All right. Mr. Bloodworth, did you want to add anything?
Yes, Your Honor, thank you. As it relates to what I would most likely expect the testimony to involve, Valentine's Day, why not? Why if you thought she just murdered you, do you still stay?
Right.
And it seems to me that where the court might be hung up is in the probative value of the evidence showing that he knew versus
or lack thereof, or just lack of evidence showing that he knew.
The probative evidence showing that he knew versus the prejudice that would come along with perhaps an improper inference.
An improper inference of something prior to February 14th.
Prior to February 14th,
right.
Correct, Your Honor. So I don't know that at this point in time the court has the full amount of evidence that Eric knew, despite kind of some proffers just now. This may be a decision that the court wants to reserve on under the scope, kind of make the reservation of the court needs to hear the evidence that Eric knew. Upon hearing the evidence that Eric knew, the court can make a 403 decision. I think the court can make probably the 702 decision part of that today, but I think the court needs more information on the probative value of the evidence that Eric knew.
Okay. Pause there for a minute.
Yes, sir.
Ms. Nesser.
Your Honor, Dr. Venino, I think she's a doctor, she has certainly not been identified as a family relations expert, a good or bad marriage expert, a marriage counselor.
I know, but respond to what Mr. Bloodworth just said.
That's what I'm trying to get to. So if they're trying to argue that there's been infidelity or there's been arguments in their marriage, infidelity on both sides of their marriage, which is an answer to a question about why you wouldn't leave. But that goes way beyond what the narrow area that she's qualified in. She's qualified in domestic violence. If you look at her CV, 99% of it deals with sexual assault victims. A tiny percent of it deals with domestic violence in the home that is not connected to sexual assault. Almost all of it's connected to sexual assault. So her specialty, while they may want to put that case on that, that she was a bad wife or whatever they want to try to argue, this expert is being called to opine about violence in the home, not just being a bad wife or being, controlling or manipulative of your spouse, but of a spouse being in fear due to emotional or physical coercion to the point of being in fear. And there's zero evidence that I've seen in 10 terabytes, what are we up to, 12 terabytes? 12 terabytes of discovery. And if they've got some evidence out there that there was domestic violence in this relationship, and I don't have it yet, I submit it's not coming in. So the prejudice would be outrageous to allow this witness to get on the stand and opine expertly that because there were problems in the marriage, that this was a situation that put Eric Richins in fear of domestic violence.
That's not what Mr. Bloodworth was arguing. He was arguing that I should wait to see how the evidence comes in the state's case in chief to determine whether they've laid a foundation for the jury to draw a reasonable inference that Eric Richins did in fact conclude subjectively that Kouri Richins tried to kill him on February 14th and then stayed with her. If they do, I think their argument that Dr. Venino's testimony is helpful to the trier of fact is stronger, and we can have a conversation about it today or tomorrow or in the future. If they don't lay the foundation, I don't think it can come in because it won't be helpful to the trier of fact, and even if it had some minimal helpfulness, it's the danger of inviting the jury to speculate about whether there was some other history prior to February 14 regarding domestic violence, whether they've misheard the evidence and are confused or misled. That's too high under 403. But Mr. Bloodworth's point on behalf of the state is, rather than doing this by proffer, why don't you just hear it come in and then decide if we can call Dr. Venino after we've tried to lay the foundation for what we think we're going to be able to show.
Well, one of the problems is, if she's going to come in, there's things we as lawyers need to do to prepare for that. One thing, we may want to get a rebuttal witness. We honestly did not believe that her testimony would ever come in at this trial because there's zero evidence of domestic violence on Kouri's part, right? So there are things we need to do to prepare that preparing at the last minute puts us at a significant disadvantage. I think you're always entitled to revisit any ruling you ever make, right? You're the judge. You can revisit a ruling at any point in a trial if the evidence changes or something changes.
Certainly.
But as this evidence stands right now, they have not propounded evidence sufficient to get her testimony in at this point. If they do that later, then they can ask you to reconsider. But right now, I think the only proper ruling would be to rule that there's no standing right now to let her testify. If that changes, you can reconsider it. But right now, they've not propounded that evidence. I've never seen that evidence, and we're a month out from trial. I seriously doubt we're ever going to see it. But that's what we would ask you to do at this point.
You acknowledge there's a little bit of internal inconsistency to what you just said. I agree with the last part that I can say, well, she can't testify until you lay foundation.
Right.
But once I say they've laid foundation, you're going to be right on the horns of the same dilemma you just described in terms of needing to have a rebuttal expert prepared to go.
Right.
Okay.
Well, I mean, if it depends on your ruling, how we approach that, right? I mean,
talk to me about, assume that there was foundation in the record today, that there was admissible evidence that Eric Richins had a subjective belief, well-founded or otherwise, that Ms. Richins attempted to poison him on February 14, 2022, and elected not to do anything about it. It would seem that would satisfy the 702A standard for helpfulness for the jury in terms of explaining why people who suffer violence in a domestic relationship don't immediately get out of it.
That still doesn't mean that there's any evidence of that violence in the relationship. Even if
you got to accept my hypothetical.
Right.
That he subjectively believed that she did and didn't get out. That would seem to open the door to Dr. Venino's testimony as helpful to the trier of fact. Do you disagree?
I would disagree with that.
Tell me
obviously. Well, based on her area of expertise, as I read her proffer, her theory is, it's almost like we use the word grooming in child sexual assault material cases, but that idea of being in such a violent and traumatic relationship that basically a person just gives up. It's kind of the
Well,
burning
that's
bed.
not what she says. I mean, quote, there are many reasons that a victim of intimate partner abuse doesn't simply leave an abusive relationship, including love/hope for change, economic constraints, lack of perceived acceptable alternatives, social isolation, and fear.
Right. There's no evidence of any of that.
No, but in my hypothetical, there would be evidence that he believed that was the case.
Okay. Accepting that hypothetical, that evidence that does not exist now somehow appears at trial for the first time ever,
right,
and is allowed in, even though we object like crazy because they didn't give it to us before. The argument would be that her testimony, my understanding is she's a blind expert, right?
Right.
So she's not going to be able to take that evidence and analyze it anyway. So how does it change her position at all from right now?
Well, because right now, in the absence of the foundation that you assert is missing, that I have concerns is missing, that Mr. Bloodworth is saying, hold the phone, let us lay it at trial. I agree that her testimony would be unhelpful because it's not relevant to
Right.
the facts of the case.
Right.
If they lay the foundation, it suddenly becomes relevant to the facts of the case.
I don't know. I think it gets very, very painfully close to opining on the mental state. I mean, it's the same argument that you raised before when you were talking about the testimony of the profiler, right? Like, how close are you going to walk to that line that you're giving an expert opinion about what's inside someone's brain and then extrapolating that, one step over to defense counsel table, right? And I mean, basically her testimony would be under circumstances where someone believes that their life is in danger. It's perfectly rational for them to stay, so it must show that they did believe it, but that they just didn't act on it. I mean, she's opining on what would be in Eric Richins'.
They'd offer her testimony for the inverse.
Right.
The fact that he didn't leave is not necessarily an indication that an attempt in his life didn't happen on February 14th.
I mean, I had a case very similar to this one time. I had a rape case where the victim of the alleged rape testified wholly inconsistently, like 6 different times about what happened to her, to the extent of like where it happened, how often it happened, in what position it happened. Everything was just absolutely in every statement she gave. And the federal government called a witness to testify, an expert, to testify that rape victims are more likely to be confused. So the fact that her statements are consistent with trauma and make it more likely that she was a rape victim, right? And we have this huge battle over that, about how far can you use an expert to explain away your inconsistent evidence, right? Evidence that's inconsistent with guilt. And it shouldn't be that you should be able to call an expert witness and say, hey, we're presenting something that's wholly illogical and irrational, but we're going to call this expert up here and say, well, this certainly would be a perfectly honest reason why Mr. Richins would believe that, it was a healthy thing to stay with someone who just tried to murder him, right? And so it eliminates their problem with their evidence, and it goes into his state of mind, which an expert shouldn't be called to testify about.
Well, we could talk about that under Diaz.
Right.
But, okay, I understand your position.
Yeah.
Ms. Shermanek, Mr. Bloodworth, anything else today?
No, sir.
Okay. Let me take it. Oh, I'm sorry.
Sorry, Your Honor.
That's okay. Anything else on the record at the moment?
No, sir.
Let me take a 10-minute break. Okay, thank you.
Now, Judge is going to take a break to think about that one. The other ones, he's been ruling right from the bench. Arwen, it's okay. Yeah, we just got it for YouTube. Just got to be careful. You can say grape, that's fine, but just got to be careful. But yes, she did say that. She did say that. All right, so Judge is going to take a 10-minute break, I think he said. The other motions he's been ruling right from the bench. So let's go back. Actually, we heard quite a lot now. That first little section before the break, there was really not much to recap, but this time we can actually recap. All right. So he comes back to, oh, that's right. So they took the break after hearing from Melissa Ament and Dr. Brianna Fox. So the judge comes back, Judge Mrazek, who's fantastic, love Judge, comes back and what are they going to do? We'll just do the thumbnail. Comes back and says, it's not credible someone would engage in weeks-long campaign to delete someone. The study from Ms. Amant is based on retrospective deletions. Why wouldn't it be helpful for the jury to know what, that was planned? The defense is asking that she be excluded under any circumstances, and they feel it's prejudicial because she's claiming to be an expert and has never testified. So ultimately, the judge ruled that he granted it in part and excluded it in part. So she can't testify in the case in chief. She can't testify in rebuttal if evidence of guilt. So basically, hold on a sec. He does find that her testimony is reliable and meets requirements, but will her testimony help the jury? So if the defense makes this an absolute, that it's absolutely about, hold on a sec. I'm getting lost in the weeds here. I'm getting lost in my because I'm thinking about this, what we're talking about right now. I'm going back in my notes. So the defense motion to exclude Miss Emmett's testimony, he is saying he's going to grant it in part, but she cannot testify in the case in chief, nor can she testify in the rebuttal if the evidence is of guilt. She can just kind of talk in generalizations about this pathway to violence. So she can just talk in generalization. She can't say, yes, Kouri's guilty because here's the pathway to violence. So that motion was kind of a win for everybody. Both sides kind of won and lost, if you will. All right, then the next testimony was Mr. Throckmorton. Fantastic last name there, Mr. Throckmorton. So this is about Eric's signature and the fraud that Kouri is perpetrating, allegedly. So it has to do with two documents, power of attorney and then true stage application. So she apparently forged his initials on the true stage document and signed his power of attorney. Now, the state isn't even planning on bringing in the power of attorney unless the defense brings it in. So if the defense doesn't touch the power of attorney, then there's nothing to talk about, right? It's the point is moot. So the defense was getting hung up on it's a strong probability that Eric didn't sign the document. Strong probability. So state comes back in and says, we're not going to offer that unless the defense brings it in. So the judge ultimately denies it. The defense motion to exclude it, he denies it. He believes it is admissible. He thinks Mr. Throckmorton's conclusions are acceptable by the handwriting community. His methods are reliable. So it was initials on her power of attorney and then a signature on the home equity loan. So he's going to let that testimony in. But only if the defense brings in the power of attorney. So, Sharon, is CL now on Kouri's side? Well, apparently CL has changed their testimony, saying it was only Oxycontin. So that's why it's going to get really interesting where that's going to go. So CL now is saying, and I don't know, Aaron was talking about it, you guys were talking about it. I haven't seen that yet, but apparently instead of being fentanyl, it was just Oxy. So I don't know where. I can't find any place that talks about it other than Erin said she saw it, and then I think Lazy Boys, you said you saw it somewhere too. All right, so then the next testimony was about Josh and Cody, which I'm assuming are friends of Eric's. So now they're saying this is going towards, did Eric know he was being poisoned before February 14th? Oh, and then there's this Venito, who's not a doctor, but I think they said Dr. Venito. So this is all about, would you stay in a relationship if you knew, A, you were being poisoned, or B, you were in a situation such as your life was being threatened? So they talk about Josh and Cody, but Cody won't testify. So why even bring it up? Oh, because he's going to talk about, if he does testify, it was all on the phone. So Eric called him, and it was all Eric's demeanor. So Cody, if Cody does testify, it's all going to be about how Eric sounded. And judge is like, well, how did he sound? And state said, well, Cody says Eric sounded somber and scared. So he's going to testify to that demeanor. So he can't say, Eric told me this. Eric said, hey, Kouri's trying to poison me, but he's going to say he sounded somber and scared. I don't know how we'll have to see if that testimony comes in. That one's, I don't know. Right now, the state's case is looking a little, I don't know, flimsy is the right word. So far today, and I know they have far more many witnesses, but so far the witnesses today right now for the state, I'm kind of like, So you talk to your buddy on the phone, and your buddy's saying, oh yeah, he sounded somber and scared. Is that really a conclusion? Can we jump to that conclusion? Can the jurors, the triers of fact, can they say, oh yeah, Eric was afraid for his life? I don't know. I'm not buying that one. The handwriting one, whatever. I'll be the trier of fact of that. Let me see the handwriting. Here's Kouri's handwriting. Here's Eric's handwriting. Let me compare the two, and I'll be like, oh yeah, she forged it. I don't think I necessarily need a expert or somebody to come in and tell me that. But and that sounds like what the state's trying to say. The state's saying, hey, we're going to send this back, and we'll let the triers of fact determine if it was forged or not. All right, so Cody may or may not testify. Josh, we really don't know what he's going to say. But apparently there was a text. Even the texts sound kind of weak. So there was a text between Eric and Kouri about a sandwich. February 14th, Eric texts, I'm not feeling well, I'm going to lay down. And then the judge is like, whoa, wait a minute. The thing about the sandwich was between Kouri and a friend a while later. It wasn't like Eric saying, hey, I just ate a sandwich. What did you do to me? I'm going to go lay down. No, it was, I'm not feeling well, I'm going to lay down. Could have been bad mayo. It was an egg salad sandwich, right? Or egg sandwich. I think it was egg salad. Could have been bad mayo. I don't know. That's a reach as well. That's a big stretch for me. I don't know, man. How do you guys feel right now? I am not happy with the state's case right now. I know they have a lot more witnesses. I know they have a lot more evidence. But right now, I'm like, especially if CL comes in and says, yeah, I never sold her fentanyl. I only sold her oxy. I'm not happy about that. Michael, I thought he said that it was forged, but he couldn't say that Kouri forged it. Seemed that would be good for Kouri. Yeah, it was a high probability. That's what they were arguing about, Michael. It was a strong probability that Eric didn't sign the document. So, yeah, in a nutshell, he's saying it's a high probability, strong probability that Eric didn't sign it, but did Kouri sign it or not? So there's no way to prove that. I don't know, man. There's no way to prove it. Totally agree with you. Feel the state's case is weak right now, right? Widespread. I think the state has a very good case as long as the walk the dog letter is admissible. That's true. Yeah. I agree. I agree. I'm just talking about right today. I'm not feeling very warm and fuzzy for the state right now. Just based on what we're seeing so far. I know they have more evidence. I know they have more witnesses, but right now, is it just going to hinge on that walk the dog letter? And then that was after the fact. That's after the fact. So I guess that shows, consciousness of guilt. I guess they could go that route. I don't know. Just not feeling solid right now. All right. So let's continue on. Then this Veneto, Dr. Veneto, but then defense said Veneto's not even a doctor, not an expert in fidelity, marriage, qualified in DV. So 90% of her CV has SA. So this expert is being called to opine about violence in the home and not a spouse being in fear. And they haven't even seen it, and there's no evidence of DV. There's absolutely no evidence on either side. So the judge rules if the state can't lay that foundation, then it's not coming in. But he then took a break, I think, to weigh upon it further. Mallory, I think it will all come together. We are only seeing pieces. True. The trial is going the last weeks. It was like 5 weeks, I think. I think they're saying 5 weeks. And they're saying 5 weeks. Let's see, Iowa. Isn't this just determining what witnesses can and won't come in? So yeah, yep, that's what we're talking about right now. Yep, no, it's you're right. I'm just saying right now I don't feel warm and fuzzy with what the state is saying with these witnesses. That's all. So so then they're talking about a DV outside of physical abuse needs to be explained. Why wouldn't Eric leave if he knew about being poisoned? We talked about that yesterday, right? We're like, why on earth, like you know, and not, I'm not victim blaming at all. I'm not saying that at all. I'm saying people have been saying, why wouldn't Eric have left? You know, so why wouldn't he have left? Possibly for the kids. He had three boys that he wanted to make sure were okay. Maybe if he tipped his hand, if he was afraid. He tipped his hand and says, hey, I want to get a divorce. Look what happened with Amber and Johnny. You know, maybe if Eric said, hey, I want to get a divorce, who knows what Kouri would have done. You know, there's lots of things, lots of reasons why you stay in a relationship, you know. Damn it, Dana. I don't think he knew. I don't think he knew. You don't think he knew, or you don't think he knew? Sherry, how can Carmen change your story? Won't that be an issue? Yeah. We haven't seen any pretrial hearings yet about. The only thing we heard, I think the first hearing we watched, they talk about Carmen or CL. That's where we hear about CL, and then it's Carmen in her walk the dog letter. So that's the only time we've heard CL was in that first hearing. Arwen, sounds like they have a good case, but are not handling the case well. Sparkling Princess, I think they have a strong case. All right. I mean, I guess we'll just have to wait and see. Raj, lots of reasons. None of them are good. We're good, unfortunately. Yep. The danger in leaving works both ways. It can be dangerous for the male too. Yeah. Again, I just go back to Johnny Depp and Amber Heard. He said, "I want to get a divorce," and look what she did. Let's see. Pamela, we know that Eric didn't sign it. We know she turned it in, regardless who actually signed his name. Yeah. So there was forgery on somebody's part. So process of elimination, we can go and we can say it was her, because who else would have turned in a power of attorney and true stage application? Let's see. Dana says, I think he suspected it, but probably gaslit himself into thinking that was crazy. Yeah, I mean, we've all been there. We've all been in relationships where we look back and say, wow, why did I stay that long? You know, how on earth did I stick it out? Whether it's, you know, crazy mentally, emotionally, physically, or all three of the above, spiritually, you know, spiritual vampires and all that. People sometimes just drain you and you stay in a relationship. It doesn't even have to be, you know, intimate or whatever. It could just be a friendship. We all know people like that. And we've all been in relationships like that. So looking back, you can say, wow, how did I stay in that relationship for so long? You know? All right, Mallory, I hope the state presents well. You can have a strong case and lose because you do a job at presenting facts that the jury can follow and understand. There's a lot of evidence. Make it perfect. Don't be lazy. All right. Aussie, yes. Thank you for agreeing with me. Yeah. I don't think we're going to get an actual lunch break because they're taking these little breaks. So I don't think we're going to get a lunch break. Amy Lee saying yes. Yes, yes, yes. Pammy saying yes. Yep. All right. Amby here, a power of attorney has to be signed by both parties. Yeah, and it has to be notarized. Yeah, you guys were saying that. Yeah, I mean, that's like a legal document. I would think it would have to be notarized too. Well, maybe, okay, so maybe she signed it and then handed it in, and then that's when they're like, no, this isn't valid. Maybe that's what happened. I don't know the full story on that. Widespread Panic says, a successful gaslighter can convince you that you can't live without them. That is true. Arwen, he may not have been sure if she tried to poison him or not. I'm thinking you said him. She may have been a bully and had him under her thumb. Possibly. JMS, the prosecution is doing fine, but I can't make any judgment on how they're going to do until I hear the case in chief. From what I have heard, they have a strong case. Let's see. Oh, Missy's calling out certain people. Iowa Backyard relationships. Yes, I knew that it was time to cancel the wedding when I realized that I was going to run if I ever got preggers because I didn't want him raising a child. Wow, yeah. Sorry, Aussie. It was unintentional. I didn't mean to call you out. Pammy, yes, agreeing. Thank you. Sorry, Aussie. Aussie. Oi, oi, oi. Yes, Iowa Backyard. Glad you saved yourself, for sure. Showa. All right, waiting for Judge to come back. Judge, I gotta get his name now. Mrazek, right? Judge, I just say Judge M, but Judge Mrazek. Fantastic judge. Absolutely love Judge Mrazek. Listen to me, Dr. Everett. He and Judge Everett and Judge Kranick, those three are just spectacular. Love those guys. All right, he's been gone 16 minutes. So should be coming back soon. Mary, I don't like these defense lawyers. They seem to reflect the same character as their criminal client. Dishonesty. Lazy boys. Don't pick on Aussie. Arwen, if she turned in those policies, she must have known her husband hadn't signed them. Yeah, then there's the fraud. I was going to say there's the Freud. Freudian slip. There's the fraud. Sharon, he's ruling on this testimony of Veneto and, oh, here we are. Looks like we're coming back.
Okay, Ms. Nestor.
No, Your Honor.
All right. The issue before the court is the defendant's motion to exclude Dr. Sherry Veneno, who is an expert noticed by the state or disclosed by the state to give testimony about domestic violence relationships, to include characteristics, dynamics, patterns, and victim trauma. Dr. Veneno is disclosed as a blind expert who is being offered to testify regarding a set of principles regarding domestic violence relationships without having reviewed or opining on any case-specific evidence. The state asserts that characteristics of domestic violence victims are relevant because when applied to the facts of this case, they will help a jury understand, for example, why Eric Richins continued to live with the defendant after she allegedly administered fentanyl to him on February 14, 2022. Currently, the court has not seen in the record a non-speculative basis for the jury to draw an inference that Eric Richins had any subjective knowledge of Ms. Ms. Richins' alleged attempt to poison him on February 14, 2022. And in the absence of a non-speculative basis for the jury to draw that inference, that is, that Eric knew that his wife had attempted to hurt him, there's no relevance to Dr. Venino's testimony regarding the dynamics of domestic violence relationships, because there would be no foundation for the jury to conclude that the relationship between Kouri Richins and Eric Richins qualifies as a domestic violence relationship. In the absence of that foundation, Dr. Venino's testimony would not be helpful to the trier of fact under Rule 702A, and given its lack of probative value, it would be inadmissible under Rule 403, not only as not being relevant under 401 and 402, but also under Rule 403 as inviting the jury to speculate about whether there was some other evidence of a domestic violence relationship between these two that wasn't in evidence in the court. It might confuse the jury regarding the testimony that is admissible. It might mislead them regarding the reasonable inferences to be drawn from it. So sitting here today, there isn't a basis to allow Dr. Venino to testify. However, the state makes a reasonable point that the court hasn't seen all the evidence, isn't aware of all the evidence, hasn't seen how it would come in, and the state may yet be able to lay the missing foundation during its case in chief. And so while the court determines that sitting here today, there is not a basis to allow Dr. Venino to testify, the court acknowledges that that basis may arise through the state's case in chief if the state in its case in chief lays a sufficient foundation for the jury to draw a non-speculative inference that Eric Richins was aware that defendant tried to hurt him on February 14, 2022, the court will revisit defendant's argument that Dr. Venino's testimony should nonetheless be excluded under Rule 403, given the entire context of the evidentiary record at that point. In so ruling, the court also rules that Dr. Venino is qualified to offer this type of testimony under Rule 702A, and that her testimony, if it becomes helpful to the trier of fact, and if it survives a 403 balancing test, satisfies the minimum threshold for reliability under Rule 702B. Ms. Shervanek, Mr. Bloodworth, do you need any clarification of the court's ruling?
No, Your Honor, that's sufficient. Thank you.
Ms. Nestor?
No, Your Honor.
Okay. All right. Any other expert witness issues we need to handle today, Ms. Lewis?
Not today, Your Honor, no.
Okay. Mr. Burmester?
No, nothing.
Ms. Shervanek?
No, Your Honor.
All right.
No, Your Honor.
Okay. Sitting here at this moment, I'm not prepared to get too deep into the other motions in limine. May we take those up tomorrow? Any practical considerations that we need to think about, or are we just going to handle those one at a time tomorrow based on the papers?
Those are mostly going to be mine, Your Honor. Some of them are Ms. Lewis's. Alex has, I think, one or two. Mr. Ramos, sorry. The only question we had, and I'm just not sure, so these motions were filed privately because they deal with evidence that we're asking not be admissible at trial. I didn't know if the court intended to have the hearing public or not public, because once it's aired, it defeats the purpose of why it was all filed privately.
There is some space between the way we talk about stuff and the documents. For example, there are certain documents or transcripts in which the state is seeking to admit a portion but not the whole thing, and it's sometimes because the part they're not seeking to admit would be unfairly prejudicial, not relevant, inflammatory.
Right.
Nonetheless, your point is well taken. Do you have a request?
I mean, obviously, it would be our preference that it all be private, and then maybe your ruling could be public. Because your ruling can craft it in such a way that you don't reveal inadmissible evidence. But it seems to me that the danger that a bunch of inadmissible evidence is going to be broadcast to all of our jury who now have received jury questionnaires and know they're on deck could be problematic. So we would ask that the hearing be sealed and then maybe just the ruling be made public.
Okay. What's the state's position?
No objection to that, Your Honor.
All right. Tomorrow, January 8th, the court has set a hearing to hear oral argument on numerous motions in limine filed by the state and by defendant related to a number of pieces of testimony, documents, audio recordings, video recordings, other pieces of evidence. The admissibility of those things is as yet undetermined. And the court is persuaded by counsel's stipulation that to ensure the integrity of voir dire and the jury pool, and in recognition of the fact that potential jurors have already filled out their questionnaires, and so there would be a reduced ability tomorrow, the day after, to investigate whether they're exposed to information regarding inadmissible evidence. The court finds that it is necessary to close tomorrow's hearing to the public and to seal the audio recording of it so that it is available only to counsel but not to the public at large. The court's ruling regarding what is admissible and what is not will be part of the public record. Any clarification on that, Ms. Nestor?
No, Your Honor.
Mr. Bloodworth?
No, Your Honor.
All right. Folks, we're likely to get some weather tonight and tomorrow morning. Is 9:30 an appropriate time? Do you need a little more travel time?
10.
That's fine. 10 a.m., Mr. Bloodworth?
Yes, Your Honor, that works. I have one other
Please.
issue.
Go ahead. Oh, I just had a question. I don't know if you're prepared to answer this, but we do have a number of motions tomorrow, and in terms of expediency, it would be helpful if you have specific things you'd like us to be prepared to address. Maybe if we knew some of that in advance, if there's particular case law you want to discuss.
No, I'm going to be going off. I mean, I do have lots of practical questions about, all right, who's offering this? How's it coming in? Right? Is this case in chief? Is this in repeat? I need to understand the order of events. But I will go off the papers. And I'm happy to follow your lead in terms of the order in which you want to do things. So talk to each other. If you want to do Mr. Ramos's first so he can go do something, that's fine. Will you just tell me how you want to
He doesn't get to leave.
Okay. Anything else, Ms. Lewis?
No, Your Honor.
Mr. Bloodworth?
Your Honor, clarification on the sealing.
Yeah.
The victim and defendant's family are permitted in the courtroom?
Certainly victim representative.
Just one.
Just one.
Okay.
Yeah. Would be similar to what we would do for jury selection, for example. So during individual voir dire, victim representative is allowed to be present. I don't even know if Ms. Richins wants a family member present.
I'm sorry. No, out of abundance of caution, because they've received subpoenas, it's probably better they not.
Okay. So if you would pick a representative for the Richins family?
I think there's two that are designated.
That's fine. I understand. Yeah.
Your Honor, one more thing. The state in some of its motions have styled them as motion to pre-admit.
Right.
The defense in some objections have said the state lacks, or the court lacks authority to pre-admit. I don't fully know what the answer is, but...
Well, no, I certainly have the authority to say that, for example, defendant has admitted that she wrote a certain letter, so 901 is satisfied.
Sure, that. But as far as the relief the state is requesting, if the state has styled it as a motion to pre-admit, the state would like to amend any of those stylings to a motion to determine admissibility.
Understood.
Thank you.
Okay. some of my questions will be, is there a genuine issue regarding the the authenticity of this document? Who's your witness that's going to bring it in? Something like that.
Yes.
Okay.
No, we're nothing further.
Okay. Ms. Nestor, Ms. Lewis, Mr. Ramos, I'm not suggesting that the defendant should do anything other than put the state to its burden of proof and require them to lay a foundation for stuff they want to admit. However, I do want you to be at least a little bit thoughtful on both sides of the V here about the juror's time and the court's time. And so if there are indisputably authentic documents that you can stipulate regarding authenticity and foundation, but you want to reserve and then discuss your arguments regarding admissibility, let me know which one those
Your
are.
Honor, I actually have been spending a great deal of time on that. I've come up with lots and lots that we're willing to stipulate to authenticity. I told the prosecution I would get that to them, I think Monday, but something came up in my family and I wasn't able to do that, but I will try to get that to them by Friday.
Okay.
But there's quite a few documents that we're not going to have a problem with authenticity, and we're not going to ask them to bring in sponsoring witnesses or like jail calls and bank records and pictures and all that kind of stuff. And I mean, I'm doing it one by one, and will have a comprehensive list by Friday, hopefully.
Thank you.
Thank you.
Okay. Mr. Bloodworth, anything else today?
No, Your Honor.
Okay. Ms. Lewis?
No, Your Honor.
All right. We'll reconvene 10 a.m. tomorrow morning. 2 victim representatives are welcome to attend. The rest of the public will be excluded tomorrow. Please travel safely. Nice to see all of you. Please take care. Court's in recess.
All right, so actually this thumbnail, so now we're going to go back to our pretrial prep. I guess it is all still pretrial prep. So you heard right out of the horse's mouth, you heard that because of there have been some jurors that have been screened already, or no, wait, they haven't been screened, I'm sorry. The questionnaires have been sent to the jurors, potential jurors, and they don't want to risk anything of potential jurors seeing any of this the next tomorrow, which they're going to go through documents, recordings, a bunch of evidence. Boy, I really wanted to see that. Really wanted to see that. But it's not going to be, they're not going to stream it. It's going to be closed. So tomorrow's hearing is going to be closed. All right, so to back it up a little bit, the defense motion to exclude Dr. Sherry Venito regarding the whole DV. She's a blind expert, which means that's just she's blind to the case. She doesn't know anything about the case or the history of it. She's testifying to just a set of principles. She's not going to testify to anything specific about the case. He says right now there's no basis to allow her to come in unless it comes up in the state's case in chief. So he's gonna kind of wait until that happens. So then the ending is that it's not going to be streamed tomorrow, which really stinks. Stinks. So I know it makes sense, but man, it does. Sparkling Princess, I agree. All right, so we're going to go on. It's only 3:30 here, so we're going to go back to our pretrial prep. Let's just go back to our pretrial prep. I still have 7 hours of preliminary hearings, so I'm going to split that up into, we're going to do 2.5 hours now, and then we'll save the other 5 hours for Friday, because tomorrow is Davine Michaels. Davine Michaels is being sentenced tomorrow. So tomorrow we're going to jump off Kouri, and then we'll jump back to Kouri on Friday, and then we'll also pick up on the Nick Reiner on Friday. We'll cover that because obviously you guys all know AJ has withdrawn, so we'll cover that on Friday. All right, so first things first. Let's get back to Kouri because I want to know as much as I can about this case now. So let's go here. All right, I gotta put myself over here. All right, so this is from, this particular one is from August 27th of 2024. Oops, didn't mean to do that. All right. All right, just give me a second. And then I'm going to go get some lunch. I haven't eaten lunch yet. So I'm going to go grab some food after I get this queued up. All right. Sharon, yes, it will be streamed. When the trial actually starts, yes, it will be streamed. They just don't want the jury to be, tainted, if you will. Did that come up? Did that come up? Here it is. All right. Yeah, no, it'll be streamed. It'll definitely be streamed. It's just they just don't want the jury that has already been questionnaires have gone out to the jury. They just don't want them to, see news, see anything that would taint them. To be quite honest, that's the best word I can use. So, all right. So we'll go back. Let's. Hey, I've got still 8 hours of content. Kouri's given us a lot of content. So this is 2.5 hours. This is from August 27th of 2024, as you can see. And I'm going to go grab some lunch while I queue this up, and I will be back in a moment.
And the court should fully consider it. What happens before a charged event and what happens after a charged event is probative of the event, particularly in this case. Let me maybe explain in some greater detail.
Sure.
I guess further to that point, Your Honor, to consider the attempted homicide in isolation or as a discrete event, I think would be an error. The best evidence of the attempted homicide by poisoning on Valentine's Day is the actual homicide by poisoning 17 days later. All of the defendant's motive that existed for the homicide also exists for the attempted homicide. And maybe let me just kind of detail some of that for the court. I don't want to belabor the briefing, but there's some highlights there.
I agree with you. The financial motives that existed in March existed in February.
That's correct. But it's not only the financial motive, Your Honor. There is, and I don't want to recap it unless it's helpful for the court. I can recap the financial motives.
I think I have those sufficiently in hand.
Your Honor, the second motive that is just as present in February as it was in March, 17 days later, was her love interest in Mr. Grossman and their planning of the future. And specifically, the purchase of the $3 million Midway mansion where she discussed raising children and farming with him about a month earlier.
I guess what I'm saying is you don't need to prove motive beyond a reasonable doubt. The state has shown probable cause for motive.
So then I guess the takeaway, Your Honor, is that the same motive for the charged homicide it's identical to the attempted homicide.
I agree.
Okay, I will move on.
Yeah. And candidly, I think the state has probable cause that she procured fentanyl prior to February 14th. The state has shown probable cause that she wanted something stronger after February 14th and saw it again. Made a reference to the Michael Jackson stuff, which I think at least in the preliminary hearing stage I can take judicial notice, refers to a well-known event in which someone took a controlled substance and died. I'm tracking all of that. Where I stumble or where I pause is, do we have an evidentiary foundation for a non-speculative inference that she actually gave Eric Richins a controlled substance on February 14th?
So we do, Your Honor. Let's...
Or attempted to do so.
Sure. Let's kind of focus in then on February 14th with the understanding that she, 2 days earlier, the probable cause understanding that she 2 days earlier purchased fentanyl from Ms. Lava.
Got it.
Okay. So her conduct on Valentine's Day helps establish that she, in fact, provided the fentanyl to Eric Richins. And so her conduct that day starts early in the morning when she purchased a sandwich from the Mirror Lake Diner.
Well, we know she makes a purchase from the Mirror Lake Diner, right?
Yes.
We don't know that it's a sandwich based upon admissible evidence.
Sir, we do.
How?
The invoice from the Mirror Lake Diner entered into evidence as Exhibit 66.
Go ahead.
Shows I think it's labeled on the invoice as breakfast sandwich.
Yeah, bagel sandwich.
Okay, bagel sandwich. And Your Honor, we also know from the defendant's own words that in her text message with her best friend, she admits to purchasing a sandwich that day.
Remind me, which exhibit is that? We're going to need to talk about that.
I'm going to need some help on that.
I know what you refer to, but I just need to look at it with you.
Yeah, I might have it in my notes, Your Honor. If not, we're working on that on the side.
But keep going. We can go chronologically.
So we know from the invoice and from her text message that she purchased a sandwich that morning from the Mirror Lake Diner. We also have, as the court's seen, bank statements that confirm a purchase, phone call that confirms an order. The receipt corroborates, the invoice corroborates that the phone call is related to the order in Exhibit 66. So she purchases the sandwich from the Mirror Lake Diner, and I think it's something like a 9:07 pickup is what the invoice shows. We then know at 9:43, the defendant, it's Exhibit 8, Your Honor, is a text message with her best friend.
Okay.
We then know at 9:43, she text messages her paramour that she's on her way. And at 9:49, she sends him a navigation screenshot that shows her kind of leaving the Camas area with an arrival time at some unknown destination approximately an hour from then. We also know, based on her text activity with her paramour, that they were essentially together all day. And we know that because, as the court can see, they text frequently throughout the day. But throughout that day, they weren't texting with each other. And I think the reasonable inference is they were not texting with each other because they were together. While the defendant is an hour or so away from Eric Richins with her paramour, Eric Richins has some medical event strong enough that he texts the defendant and says he's considering going to the hospital. We have that text exchange in evidence.
Okay.
Feeling sick enough to go to a hospital, and then sleeping in the garage, which he also texts, for about 2 hours, which is consistent with no activity on his phone and associated devices. All of that is consistent with the reaction to fentanyl.
I've read it, but I can't remember the number. The number for the 1102 from the person that lays that foundation regarding a reaction, if any.
Yeah, so that's the toxicologist, Matt Slauson.
Okay, thank you. Keep going.
Your Honor, also in evidence is literature from the Mayo Clinic, which lays a similar foundation. Okay, so we now have, right, in the chronology of Valentine's Day 2022, the defendant and her paramour an hour or more away. Eric Richins is sick enough that he's considering going to the hospital, and he's inactive for 2 hours. All of that consistent with fentanyl poisoning. And then, at that point, the defendant's own words are kind of important here because he texts her, right, of his illness, of considering going to the hospital, and what she says is chilling. She says, take a nap. And then she doesn't check on him for 2 hours. She doesn't come home, she doesn't text, she doesn't call, she doesn't check on him. Their next communication is 2 hours later when Eric Richins checks in with the defendant. Notably, throughout the day, Valentine's Day, and thereafter, the defendant's reaction to Valentine's Day events is consistent with the consciousness of guilt. She had texted on February 11th and 12th significantly with her drug dealer during a time frame that corresponds with the drug dealer's purchase of fentanyl at the Maverick and the Draper.
Right.
Those texts are deleted from her phone. She texted with the drug dealer 30 times, about 30 times with Mr. Kouri testimony. On Valentine's Day, and those texts are deleted. There is no good reason the defendant is spending Valentine's Day with her paramour and texting her drug dealer 30 times. Eric Richins texted the defendant a photo while he was texting her about feeling ill and considering going to the hospital. That photo is deleted from the defendant's phone and also from Eric Richins' phone. That is in the moment consciousness of guilt. The next day,
forgive me, I don't recall testimony from Mr. Kouri or any documentary evidence about when those images were deleted. Now, I acknowledge they were deleted sometimes after they were created, but...
Fair, yeah.
Okay. Okay.
The next day, after Valentine's Day, February the 15th, 2022, the defendant lamented to her paramour, if he could just go away, that life would be so perfect. And then 2 weeks later, she assured her paramour, life is going to be different, I promise. Hang in there until Friday. On Friday, Eric Richins was dead. We've referenced Exhibit 8, the text messages that the defendant sent to her best friend.
I don't think that's 8. I think Celebrite is 8. Can you give me that number?
Well, Your Honor, it would be found in the Celebrite extraction.
Oh, my apologies. Okay.
So,
It's not like a screenshot. It looks like a download.
Let's get there together. I need the exact language of that. It would be... Okay, got it. So this is, we got to be specific about this, a June 18, 2022 communication, correct?
Yes, Your Honor. It's June 18, 2022. I can give the court some context, which the court's already familiar with on the timing. The timing relates to the same allegation kind of is wrapped up in the attempted homicide charge that was made in the civil litigation. And timing would suggest, I think it is reasonable to infer, that they were discussing this text is a discussion of the Valentine's Day 2022 incident as put forth publicly in the civil filing.
I have some questions about this when you're done going through the evidence.
Okay.
I also have questions about the February 15 text messages, so just put 2 pins in those. I'm not questioning the existence. I didn't know those pins exist.
No, sure. That glance was to get a copy of whatever the February 15 text was.
Well, it's if you would just go away, ... and then I promise we'll be together on Friday or words to that effect.
Yes, Your Honor. We can discuss those kind of texts when we're both looking at them.
Okay.
The text to her best friend regarding Valentine's Day. The defendant says, it was Valentine's Day and Eric and I were both working from home that day. We know that to be false. We know that to be false from her text messages with Eric himself. We know that to be false from her text messages with her paramour. We know that to be false from the navigation screenshot. Continuing with the text, she says, he, meaning Eric, never broke out in hives or used an EpiPen. She did not know that. She was not with him. The court can reasonably infer that the opposite is true. She is lying about being with him. She is lying about him not breaking out in hives. She is lying about him not using an EpiPen because she knows those facts are indeed true and indeed inculpatory. So do you want to discuss those texts, or should I continue on with further answering your question is how the homicide charge kind of relates directly to the attempted homicide charge?
Well, let's pause here for a second.
Yes, sir.
We also skipped over or didn't mention in that recitation. Remind me of the date where she asks CL for something stronger.
So, Your Honor, that I don't know that I know a precise date. It's somewhere around February the 25th.
It's here somewhere. I think it was 12 days later, right? Okay.
And Your Honor, the court raises an important point, right? I said at the outset that the best evidence of the attempted homicide by poisoning is the actual homicide by poisoning 17 days later. And the defendant learned from the attempt and applied it to the homicide. And we see that with what the court just raised. She wanted something stronger. She learned that whatever she used on Valentine's Day wasn't strong enough, which is why she went back and asked for something stronger. But she had a similar MO, right? You know, her MO is to go to the drug dealer, procure fentanyl, and 2 or 3 days later, 4 days later, administer the fentanyl. That is the same. The drug is the same. The drug dealer is the same. The timing is the same. But she learned. She learned she needed something stronger. She also learned how to administer it. She learned that putting it in a sandwich where Eric Richins could take a bite, feel the effects, set the sandwich down, was not the proper way to administer a fatal dose of fentanyl. Instead, she administered it with a lemon shot, where Eric Richins would throw it back all at once. She says that in her journal article, her journal note at Exhibit 49. And she learns that it takes a truckload of fentanyl to kill him. She learns that one bite in a sandwich isn't enough. It has to be stronger, it has to be administered at once, and it has to be a lot. And that's why Eric Richins' toxicology shows 5 times the lethal amount in his blood and 20,000 nanograms per milliliter remaining in his gastric fluid. The attempt and the homicide are connected in MO and lessons learned.
If we view, let's imagine for a moment that everything through February 15, well, February 26 stays the same. Imagine Eric Richins is still alive. The text message on June 18 gets sent. I imagine you tell me we'd still have probable cause of attempted murder.
We would, Your Honor. And I guess that goes back right to the standard of this hearing. You know, all reasonable inferences go to the state.
Right. And I hear you telling me it's a non-speculative inference that you tried to poison him because we have her admitting that you ordered lunch from here at the diner. We have him having a significant enough event that he contemplates going to the hospital. We have text messages on February 15 that draw reasonable inference that you wanted him dead. We have her out looking for something stronger when he did not die on February 14. We have a financial motive. We have the medical foundation. The difficulty is, right, and maybe this just highlights the low threshold that is the probable cause determination. And I imagine this is what Ms. Nestor or Ms. Lewis is going to tell me, is this turns just about every possession charge into an attempted murder charge if the spouse has some medical event around the same time. But here you'd say...
And the spouse dies 17 days later under very, very similar circumstances. Same MO connection between the two.
And is it 404 that lets me connect the dots here?
I don't even think the court has to go to 404. I think the court can connect. Certainly it's probative. So, yeah, certainly it's relevant. I guess the court could connect the dots through probative, but there's no doubt, especially, returning to the fact that this is a domestic violence case. The court sees the consistency in the domestic violence
defendant's conduct throughout. The motive is super strong. I mean, I know we've kind of agreed that the motive is present in both circumstances, but
it's equally present. It's separated by merely 3 weeks.
Correct.
Yeah.
It's equally as strong. Now, Your Honor, the court raised, that this isn't speculative, and it's not. And Schmidt kind of talks to the notion, the point, right, that the court's job here is not to sift through the evidence and find the most reasonable explanation, just to make sure that the state's record, the most reasonable inferences, just to make sure, rather, that the state's inference is reasonable. And we leave the most reasonable inference question to the jury.
Okay. All right, so if you've got probable cause for count 2, you've got it for count 4.
Yes, I think 2 goes out, or 4 goes out, 2 goes.
Right. I think I understand the state's position here. You will, of course, get the last word on counts, on all the counts, but certainly counts 2 and 4. I have some questions regarding some of the financial counts.
Yes.
Bear with me for a moment. All right, count 8 for insurance fraud. What is the conduct that forms the basis of that count? Count 7, the $100,000 true stage policy. I'm following the state's argument. I'm not sure what count 8 refers to.
Yes, Your Honor, and in the statute under count 8, the insurance fraud statute has different non-exclusive, or I guess different exclusive theories of presenting an insurance fraud claim.
Certainly.
And then count 8 is kind of the broadest claim. It's the scheme claim.
Well, for count 7, right, it's either it could be the forged signature, it could be the false representations regarding how Eric got the fentanyl in him. Either one of those, I think, would get you there.
Yep.
Let's just say it's the false statements regarding the fentanyl.
Sure.
You have a forgery count regarding the false signature, I think, in either, bear with me, 9 or 10, or maybe 11. Candidly, I think 11 is the forged signature on the $100,000 policy.
Sure.
So
that relates to the claim, right? Count 7 is a false claim.
Right.
On an insurance policy. Count 8 is a scheme devised to get the money falsely from an insurance company.
But
can or cannot involve a claim.
Fair enough, but is it the... I acknowledge that we don't need to get into merger today, but
sure.
Is it the forged signature on the $100,000 true stage?
Sure. It's the signed application on January 28th and 29th. It starts with the application for the policy that issued on February 4th.
Right.
10 days before the attempted homicide. A month before the homicide. It starts with that signed kind of application that the court will recall. There was no way for the insurance company to contact Eric Richins. Rather, they can only contact the defendant, right? The defendant used her business P.O. box. The defendant used her email. The defendant provided an improper phone number.
Okay.
And so submitting that application begins the scheme.
Got it.
And the scheme continues through the false claim for the money. And the evidence of that is the claim log we submitted into evidence as Exhibit 67. But different than the false claim where the mens rea and the actus rea is just submitting a false claim with the intent to get paid on it. The scheme is much more sweeping. The scheme in count 8 is I'm going to submit a false application for insurance on Eric Richins' life, I am going to then cause his death and then seek money.
Understood. All right, so with respect to the 3 forgery counts, 11 is allegations regarding Eric Richins' signature on the application for the $100,000 true stage policy.
Correct, Your Honor. That's the policy of Exhibit 17.
What is 9 and 10?
9 is the fraudulent bank statement that the defendant provided to Ironbridge, and 10 is the similarly fraudulent statement that the defendant presented to Boomerang. That's the cut. Those are the cut and paste job statements.
And so the forgery count of 9 is related to the mortgage fraud count that is in 5, right? And then the forgery count of 10 is related to the mortgage fraud count in 6.
Correct.
Got it. Okay. Thank you. Anything else you want to put on the record at this time?
No, Your Honor, I'll be back.
Very good. Ms. Lewis, how are you?
I'm fine, thank you. I'm going to address really just counts 1 and 3 and a little bit of 4, and then Ms. Nestor is going to address count 2.
Okay.
And the remaining counts.
Tell me where you see the gap on count 1.
All right, well, here's where I see the gap on count 1. So I understand that there was a finding made at the detention hearing. And I understand that the court can consider the transcripts from that hearing. However, I think we're in a kind of an interesting situation, because the burden of proof has to be at the preliminary hearing, and the court does need to make a new finding at this hearing. And I actually think, interestingly, that this is a situation where additional information that came in makes it less likely and makes it more difficult for the state to establish a reasonable belief as to the first element of aggravated murder, that she actually intended and knowingly killed Mr. Richins. Because what we learned yesterday is we have now the affidavit, or the 1102, from Ms. Lauber. Well, what that really tells the court is only one thing, is that she believes she gave fentanyl to Ms. Richins. She doesn't know what she gave Ms. Richins. Whatever she gave Ms. Richins has been through at least 3 people before it came to Ms. Richins. Ms. Lauber got it from somebody, Mr. Crozier, who got it from somebody else that we don't know who that other person is. None of these people manufactured it. None of these people tested it. So we don't know what was given to Ms. Richins.
I don't disagree that we don't know, but knowing is not the legal standard that I'm required to apply today. So tell me why Ms. Lauber's 1102 is insufficient to support a reasonable belief in the parlance of preliminary examination law that the stuff that she provided was fentanyl.
Well, let's look at the distribution counts and examine that.
Yeah, we can do it. All right, go ahead.
So, looking at the distribution, and then I'll backtrack a little. So, Detective O'Driscoll said that he had no way of knowing, that he did not know what was in the pills.
He just knows that they are blues or greens, which, given his experience with, he didn't say narcotics, but with controlled substances, is consistent with street fentanyl.
Blues, he said.
Okay, there you go.
Anyway, I was trying to remember if this was in the record or not before I said it out loud, so that was my pause there. But I have never seen a distribution case where we don't have anything that was distributed.
You mean a preliminary hearing or a trial? Two very different universes.
Well, personally, neither. Okay? Personally, I have not seen it either place. But I don't think just an individual who's a drug addict saying, I thought I gave her fentanyl, I mean...
Doesn't that form the reasonable belief, though? I mean, by all accounts, Carter Lawler knows the difference between a controlled substance and not.
Well, that's not in her affidavit. How do we know that? How do we know that she knows the difference?
With respect, she's in drug court and she faces controlled substance convictions. So apparently she has some experience with it.
But Detective O'Driscoll testified that she said initially, and she said it in more than once, that she knew nothing about fentanyl. She didn't deal with fentanyl. It's not her drug. And he said that.
These are great trial arguments, but I question whether this would be sufficient to... These concerns are sufficient to rule that there's only a speculative basis rather than a reasonable basis.
And I understand.
There was provision of a controlled substance.
I mean, I understand your position, where you're headed with this, but I do think we want to, for the record especially, Detective O'Driscoll testified that he cannot say with any certainty what happened to those pills. We have no knowledge, no testimony, no evidence, even if those pills were fentanyl, what happened to them after February 25th. I mean, the third ones were allegedly received after Mr. Richins' death, which is interesting in terms of what these pills were actually for. And I think, and again, maybe a trial argument, it's interesting that if that was the purpose of these pills, that they were still being handed out afterwards. But he said he could not testify what happened to those pills. He cannot testify what was in those pills. And he does not know how, if those pills were given to Mr. Richins, and if they were, how they were given, who gave them, did he take them himself. There isn't any evidence as to that. And I understand, the position and the very low standard we're looking at here. I get it. But that would be...
To be clear, the court's position is based on an application of the standard, not because I have an independent belief of what did or didn't happen.
I didn't mean to imply that it was your personal belief. I understand the standard. And your application of the standard. Our position is still that there needs to be something more when you look at everything that's been presented as evidence in this case up to this point. And particularly on the distribution count, I think it's
3 or 4.
Well, to both, but there's additional, of course, problems with the February 14th distribution.
With if there is evidence sufficient to support a reasonable belief that Kouri Richins put some drugs in a drink and handed it to Eric Richins, there's probable cause for the count 3, right?
Yes.
Okay. All right.
You're right. But I think I've made my argument on that. And I just don't think that anything that happened from any of the other witnesses, of course, goes any further to show anything about count 1. It goes to the motive, which is an element of count 1, especially the Ms. Harrington's testimony. I understand that. But nothing that they said, I think, goes to intentionally or knowingly administering the drugs.
Well, the motive would provide some foundation for intentionally or knowingly. Let me put it differently. If there was no motive, the inference would be harder to draw, correct?
Yeah, you're correct.
Okay.
I think that covers what I have in our record on that. I don't know if you have any other questions, but Ms. Nestor will talk about counts 2, and then that, of course, relates directly to count 4. And she'll address the financial ones.
Okay. I think I understand your position on 1 3.
Okay. Thank you.
Good morning, Your Honor. May it please the court. If the court would indulge me just a couple minutes. I know you're so familiar with preliminary hearings. You do about 1 billion of them a year, probably. But I do just want to talk about what they are and what they mean to this system and to my client. So Utah is a state that has decided not to employ the grand jury system to determine whether someone should be prosecuted for a felony crime. Utah has decided to place the entire power of whether someone's going to be dragged away from their home in handcuffs to a courtroom facing serious charges to the discretion of these people at this table. It's their power to fill out an information.
I have some role in the process.
I'm talking about before they get to you. I haven't got to that part yet. Right. You're jumping ahead of me.
Okay.
But what brings them to you is the people sitting right here. And it's their opinions, it's their beliefs. They're not a grand jury, they're prosecutors, they do their best. So what we have created to protect clients from that awesome power that sits at that table is this process of a gatekeeping, that instead of delegating that to a grand jury, people in our society that come together and close doors and hear the evidence and decide whether there's enough to put someone through this, they bring it to you. You're the gatekeeper. And this preliminary hearing is a critical right that every single individual who they decide to write a charge against has. And when we come before you, we recognize that it's a low standard. We recognize that probable cause means that. It just means enough to charge you. It doesn't mean enough to convict you. It doesn't mean enough to determine you committed a crime. It's enough to charge you. But that charging decision does matter. And it's going to have a huge, huge impact on the way this case plays out, on the evidence that is brought before the jury, on who will be witnesses, determining what charges get past this gate, you the gatekeeper. So we believe very, very, very strongly that the charge of attempted murder has not met the lowest standard even of probable cause. And that as rare as it is for a judge to say there's not even enough to charge here, it is anticipated that that will happen on occasion, which is why you do thousands of these, right? Because every once in a while, they don't get up to that level. And we think in this case they haven't done it, and we'd like to tell you why. So thank you for indulging me in that.
I agree with everything you said about the law.
Okay.
What is the essential element of count 2 that you believe the state has either shown no evidence of or insufficient evidence to draw a reasonable inference regarding?
Causation. 100% causation. So, in order for them to establish an attempted murder,
right,
they have to show that Ms. Richins took some act that caused someone to be in danger of death, right? She had to have caused something that put them at risk, right? Whether they actually died, obviously it's attempt, right? So I think it's critical that you understand the timeline of that day. And I want to walk it through, and I know it may take us a couple of minutes, but I think it shows so clearly that they cannot make the connection. And it's indisputable evidence that's in the Celebrate that has been downloaded off their phones. There's no debate about what happened on those phones, okay? So, in Exhibit 6, there are substances of text between Eric and Kouri that say exactly their communications that day. I want to go back to the very beginning, which is the receipt, which is Exhibit 66 from the Mirror Lake Diner. It shows that Kouri's credit card swiped at 9:07 a.m. and that she ordered a bagel breakfast sandwich and an omelet. There is a statement under the sandwich that it's over hard, which means it's an egg sandwich. There's an egg in that breakfast sandwich, and I think that's important because I don't know about you, but I'm not eating an egg sandwich 2 to 3 hours after it's brought to me. You eat it quick or you don't eat it. So she brings an egg sandwich home at 9:07. This actually hasn't come in, but I think the court could take judicial notice because of the address on Ms. Carrington's exhibit about the Willow Creek home where they resided. It's about 5 minutes away from this cafe, and I don't think the DA will, or the county attorney will dispute that.
Nothing in Camas is very far away.
Nothing in Camas is very far away. So it's about a 5-minute drive from the cafe to their home. So best case scenario of her credit cards being swiped at 9:07, she's getting home around 9:15 in that area. Maybe.
Is there any evidence that she actually went home?
Correct.
Well, I'm asking.
There is. On her phone. On her phone, the printout of her phone shows her returning back to. Well, actually, they've introduced that exhibit that they blew up that showed that she was on her way to the house, and that's from her home.
Okay.
So she was at home. So there's a period of time where she's at home between 9:15 and 9:41 a.m. with eggs to eat. Now, it is a fair assumption that when you bring eggs home, you eat them quickly. So it is perfectly possible, and just as inferential, that she could have had breakfast with her husband that morning together. And let me tell you why I believe that that's proven in the state's own case. Because at no point in any conversations, any texts between Kouri and Eric, does he ever tell her that he's feeling sick until he tells her at 11:40 something that if I'm still feeling this bad, I'm going to go to the hospital. So it sounds very much that they've already discussed that he doesn't feel well, right? So it is perfectly consistent with Kouri Richins' statement to her friend. They ate breakfast together. Which would make it pretty hard to poison someone when they're sitting there and you're handing them their food and watching you hand them their food. So then you have Eric between 10:21 and 12:06, and these are reflected in exhibit number 38, which shows the locations of calls made by Eric.
Could you pause for a second?
Yes.
Is there a statement that they ate breakfast together?
They just talked about her telling her friend lying that they were together when they ate.
So, I just want to make sure I'm not missing anything that you're seeing. Quote, forgive me, folks. I didn't even make him a fucking sandwich, those fucking idiots. It was Valentine's Day, and Eric and I both were working from home that day, and I ordered lunch from Mirror Lake Diner.
Well, that was months later, and she hadn't seen the time. She hadn't been exposed to any of
Hey, folks, I need you to take a deep breath. Is there any evidence that she has a backward-looking statement saying, I ordered breakfast?
Well, that's the only statement that we're aware of.
Okay.
But at that point, she hadn't seen the time. So she's remembering if it was breakfast, lunch, whatever. I mean, that was months later.
Right.
But she admits she got it at Mirror Lake. She admits they ate it together. She mixed up the time of breakfast and lunch. I mean, there's no debate that she was not there at lunchtime. That didn't happen. So, so that's clearly a mistake. So she leaves the house at 9:41 and is gone for the rest of the day. Eric drives to multiple other locations after she leaves.
Do we know, help me out, do we know that? Or
Yes.
was he doing the estimating from home? This was unclear to me from the testimony.
So in the Celebrate exhibit that is Eric's phone, it shows where he's making calls from.
Okay.
And so he makes calls from, I think he goes to it looks like the Smith's grocery store, the Walmart. He goes and runs some errands. He's making business calls ever since Kouri left, the whole time. After he's eaten the egg sandwich, he's driving around, he's making calls. Then he texts Kouri at 11:27 and talks to her about some soccer fees that the boys owe. And then says a few minutes later, so between 11:27, he's talking about soccer, and 11:33, so he hasn't seen Kouri now in 2 hours. He says, I'm going to go lay down. If I don't feel better, I may go to the hospital.
Right.
And I must respectfully point out that when the prosecution talked about her saying, go take a nap, and how that was chilling, he pulled that completely out of context of the rest of what she said in that text.
Do you need me to come home?
Would you like me to come home? Jesus, is that bad? You know, she even at one point later in the day talks about, he says, I wish you were here, and she's like, I would cuddle you. So that is very misleading to pull that statement out, and I need to correct that for the record. But regardless now, he hasn't been in her presence for 2 hours. If he ate that sandwich, he ate it around 9:30, give or take, at the latest. So in that period of time, he's been running errands, doing business calls, texting Kouri, very benign, normal day-to-day texts. Nothing about, I'm about to die, nothing like that. He takes a nap for 2 hours. Then he gets up. They text romantic texts, wish you were here, like to cuddle. That's at 1:43 when he just woke up. The same period of time well, I'm sorry, that's not before. I withdraw that. Continues to make work calls from 1:50 to 2:30. Goes to a soccer game with his kids from 3:52 to 6:11. Takes the boys to get some food. Leaves food for Kouri in his truck as they go back to the game because Kouri is running late. And that's the day. That's the day that they are now saying that you can infer she tried to murder her husband. There's no evidence he ever took a pill from her. There's no evidence that she ever, if she put fentanyl in his egg sandwich at 9:30 and he ate it, he would not be okay for 2 more hours. He would not be. And there's zero evidence. There's not one piece of evidence from Eric himself that he ever took anything from Kouri that day, that he felt bad up until 11:33 is the first time he feels bad. Now, I think you asked a fascinating question when you asked the prosecutor, do I need to consider the death as support for probable cause of February 14th looking backwards? And I think that's a really important inquiry, because obviously, if you look backwards, everything you're looking backwards at shades how you look at something that happened before. But if you look at that count in isolation, there is no evidence that supports an opportunity for her. There's no evidence to support that he took anything. There's no evidence to support that he had fentanyl, OxyContin. And as a matter of fact, he told, wait, I have to think if this is in.
Can I ask you some specific questions about
Yes.
this? So let's take it one piece at a time here in terms of events after February 14th.
Yes.
In your view, can the court consider Ms. Richins' text messages to Mr. Grossman on February 15th? Can I consider them at all?
Can you consider them? I mean, I think you can consider anything you want to consider in terms of...
Well, see, that's the question. The Utah Rules of Evidence say, no, there's all kinds of stuff you can't consider under any set of circumstances, and it's often a difficult slalom course to ski. We did some of this yesterday morning, trying to get a sense from the defense of whether or not the court can consider things like the text mentioned, quote, if he would just go away, end quote. Or as evidence of an inference that she wanted him not around anymore.
But that could be divorce. That doesn't have to be death.
I understand, and we're not in a trial, and I'm not a jury, and so I have to contend with black letter law. Let me just get this out. I really am genuinely interested in your response. I acknowledge there are multiple credible inferences that can be drawn from this evidence. Several of them innocent. But I'm not allowed to pick and choose. I am not allowed to weigh the relative reasonableness or credibility of the inferences. I'm required to draw all reasonable inferences in the state's favor, to view the evidence as a whole in the state's favor, and identify is there a reading of the evidence that supports a reasonable belief. And so when you say things like, look, this evidence, she went home, I imagine Mr. Bloodworth is fighting the urge to jump up and say, and that just shows she went home to give her the sandwich. That just shows he went home to give her the sandwich. She went home to give her the sandwich. And so the reason I ask about the stuff afterwards, the text messages, her statement regarding ordering them lunch, being home together.
So the text message certainly could be considered for the death, right? Because he's still alive.
Well, I got that.
February 15th.
But that's not my question.
Right? So how does the statement on the 15th relate to something that didn't happen? She's talking about it in the future, right? Like,
I guess the question is, if on February 15 she has a text message showing a desire to have him not around anymore, why can't I consider that for her mental state on the 14th?
she doesn't say he should be dead.
I know, but we're talking in terms of reasonable inferences here.
It's, criminal defense lawyers look at these phones, and it's pretty terrifying to think that someone's going to go back and look at text that you wrote about your spouse, years later, and put it all into a cone of literal death threats when you say, I wish he'd leave, he's getting on my nerves, I want to leave the house, I'm going to leave him, I want to divorce him. They put in Eric's divorce meeting with his divorce lawyer. I mean, this was not a perfect couple. They didn't have a perfect relationship. But to take a context, one single text, and to say that that gives you a reasonable belief that she tried to kill him the day before, I don't see the connection at all.
Okay.
I don't think that is a connection.
So I hear you saying you can consider a judge, but it doesn't have any weight.
I don't think it does.
Okay. Same response regarding her June 18, 2022 text to her friend?
That's what we just said, where she has not seen yet the time. Like, she hadn't had an opportunity to review the timing. So if she mixed up lunch and breakfast, but everything else in there is consistent with what happened that day.
What about her text message on or about February 26th to Carmen Lauber saying I need something strong?
Again, that's after the 14th.
It's a backward-looking statement, though, or at least it's comparative.
Well, apparently she had recently apparently according to Ms. Lauber, she had just recently got something from her. So,
right.
that could be not connected to the 14th at all.
Okay.
So,
or more specifically, not necessarily referring to what she got on the 11th, but it could be from the 25th.
But I mean, you have a claim that Mr. Richins was poisoned on the 14th. There is no medical evidence. There is no connection. There is no causation. There is nothing but pure speculation that because they believe she tried to kill him and successfully killed him in March, that must mean she tried it before. That is not enough to reach a reasonable belief that someone, and that's the question you asked at the very beginning.
Right.
Just because, it's like a backwards acting in conformity argument.
Yes.
It's a backwards 404B evidence.
Well, this is my question.
Right.
Does that exist?
Which, by the way, 404B's whole purpose of existing in every state in America and in the federal system is exactly to avoid this kind of prejudicial leap of because somebody did something once, they must have done it again. That's the whole reason we have 404B, is to prevent that.
I acknowledge that. I imagine you would acknowledge as well the numerous exceptions and the lengthy or the deep body of case law regarding exceptions to the general bar to propensity evidence. And so here, when Mr. Bloodworth makes references to modus operandi, he's arguing to some of those exceptions.
Right. Well,
In your view, does 404B work backwards, or does it only work prospectively?
it only works prospectively, in my opinion. But the analogy as to why this is such damaging and risky analysis can be found in that rule, baked into that rule that our legislatures and our Supreme Court recognize that that's very, very dangerous to base a prosecution on somebody, well, somebody used drugs once before in their life, they're probably guilty this time. That's the whole thing we're trying to avoid in our system. And that's the whole basis for their argument on the attempt. That's the entire basis, because they know they don't have proof. They don't have medical proof. We heard testimony about allergies. We heard about all of that. So, I mean, there's innocent explanations for everything that happened on the 14th, every single thing. So that doesn't lead to a reasonable belief. They're 100% relying on an action and conformity argument.
I don't think we heard the admissible testimony of allergies, but I take your point.
I'm sorry. I'm trying really hard
That's okay.
to separate it in my brain.
I understand.
I actually think it's included in the, I believe it's included in some of the exhibits, but we'll just leave it alone just in case I'm wrong about that. I can check that while he's back up. But having said all of that, you know, the distribution charge that is connected to the attempt charge, if the attempt charge doesn't have probable cause, the distribution charge doesn't have probable cause.
I agree.
They both have to go.
May I ask you about the consciousness of guilt argument that the state makes?
Yes.
Which I understand to be my words, not the state's. Why is she lying in her text message to her best friend in June about what happened on the 14th?
I think the only thing she got wrong was breakfast or lunch.
Well, I think her location about her being home all day is one of the things they lean on. We were working from home that day, and
I mean, that's easily provable. So it's not like when she's talking to her friend, she's trying to remember the day back, you know, a few months later. And she got part of it right, I mean, and part of it wrong. And I just don't know if it's just, I mean, how do we know that, what purpose would that be? How would that serve as a lie?
well, the argument is that she's hiding the fact that she was with another person besides her husband on that day.
Okay, that's a good reason to lie, because you're with your boyfriend, and you don't want to admit you're with your boyfriend.
Right.
I mean, that's not conscious of guilt of killing your husband. That's not wanting to tell people you were hanging out with your boyfriend.
Okay. That's one credible inference, right?
Yes.
All right. Would you say that it's not a credible inference that the reason she's lying to her friend is because she had the scheme to be not present when
she admitted she was present with him, and she was. She brought him breakfast. Okay. So that's true. That inculpates her more than exculpates her. That's the opposite of covering herself. She's putting herself in the house with him on the day that they're claiming he was attempted to be poisoned. It's a statement against interest.
Okay.
In my opinion. Okay. So I don't really need to argue the distribution. You get that. All right. So the only other things that we have on the fraud type arguments. I do think that the state never established jurisdiction or venue for any of those counts. I don't believe we've heard any proof about why this court has jurisdiction over these acts. They did not establish where they occurred.
Why isn't there a reasonable inference that Kouri Richins was making these applications and forming these schemes from Summit County?
And they have to show that. You can't just out of whole cloth make that up. There's no evidence that occurred.
Well, the standard of proof is the same for every element of the crime, right?
But
So
there's no evidence that was submitted.
She lives here. Her business was based here. I think there's a basis for reasonable belief that she was initiating these contacts, forming these schemes from Summit County.
Well, I just want to make the record.
Okay.
I don't believe they've established jurisdiction or venue on any of those counts. Furthermore, on the, I don't see why the two insurance fraud counts don't merge here.
Correct me if I'm wrong. I'm seeing several merger issues in this information, but merger is a fact issue that's handled after conviction. Am I right about that? Not at a preliminary hearing.
Not after conviction, before. You said after conviction, you meant after.
Is it before submitting it to the jury or after?
Merger?
Yeah.
I always do it as a pretrial motion, but
Okay.
I may be wrong. Maybe two, you're wrong.
I don't think it gets considered, though, at a preliminary hearing as a matter of law.
Well, I think if you determine at a preliminary hearing that two counts are actually one act, that you cannot push forward one of them, absolutely, I think you can do that.
Do you
But
have a citation for that? I thought it was the opposite at a preliminary hearing.
well, I think you would just argue that they can't make two separate counts. So there's not sufficient reason to believe that a second crime was committed because it's all one. So that's your finding. That it's a reason. You can't reasonably believe the second crime was committed because it's just one crime. Because the scheme swallows the allegation of the filling out of the application. I mean, it swallows it. So,
I'll take a look at this.
yeah. And then I think on the rest we would just submit on the other counts, Your Honor.
All right, so let's just be clear. To the extent that merger needs to be considered as part of the probable cause determination, that's going to mean that 1 and 3 merge, right?
Yes.
2 and 4 merge.
No, not 1 and 3. Attempted murder is on a separate day. It wouldn't.
1 and 3, 2 and 4.
I'm sorry, let me look at what 1 and 3 is. I'm getting my numbers mixed up.
So the distribution counts merge into the ag murder and ag attempt, right?
No, those would be two separate crimes.
Tell me why. You can't commit them without doing the distribution, right?
Right. I think they don't merge though. They're separate crimes. Like distribution is a separate offense than the attempted murder.
Okay.
So they
then
would merge.
Why isn't, on the one hand, forging a signature and then on the other hand, making a false statement when trying to collect on the claim? Why aren't those two separate crimes? What is the merger
Because
you're
they're
arguing for?
the two insurance fraud charges, because that is the same offense. Insurance fraud is not two separate offenses. And what they did is they said she created a scheme to wrongfully get insurance fraud. And part of that scheme was she signed the application and they just charged insurance fraud twice. I'm not talking about the forgery, I'm talking about the two insurance fraud charges. I think they merged.
All right. And just to be clear, you think they merge because it is the same fruit of the criminal conduct. That is, there was only one policy.
Right. That's correct.
Okay, I understand.
That's correct.
Thank you.
Thank you. Can I just have 1 minute before I sit?
Of course.
Just one more thing, Your Honor. And I guess maybe the last thing I would say too is there's so many reasons that Mr. Richins could have not felt well that day and taken a nap. And to get over the hump of saying you're going to stand trial for attempted aggravated murder, which is about the next to most serious charge you can ever be charged with, because he went to take a nap, is pushing it, Your Honor. We're just asking that the court exercise your gatekeeping function. Let's remove that from the confusion it will cause the jury, the prejudice it will cause the jury, the complete lack of foundation. We're asking that the court take the rarest of steps and say, this one will not go forward. And we submit on that.
Okay, I understand your position. Thank you. Mr. Blood.
Your Honor, real quick on just the merger issue, it's two different policies. Count 7 relates to the $250,000 two-stage policy. Count 8, I think, relates to the $100,000.
That's not the way it is charged. I think that is, you're going to need to amend the information if you want to do that. And frankly, I don't think there's any allegation of fraud, or there's any. Tell me why there's any reasonable belief regarding fraud related to the $250,000 policy.
Fraud in the claim, saying that I don't know why Eric Richins.
That's not what she said with respect to the $250,000 claim. That was only with respect to the $100,000 claim. It's two separate diaries. This is why I'm asking.
Your Honor, I think
they were paid out at different times.
Sure, in the one diary, though, they discussed both policies.
I don't think that's true. You can show me, but I looked at them carefully yesterday. They are separate diaries regarding separate policies.
Let me ask you this, sir. Is this an issue you're considering, and so I can show it to you, but I don't know that it's
I understood you to be saying count 7 is based upon statements made during the process of collecting the proceeds in June. Count 8 is the scheme to get the policy with intent to kill Eric Richins to collect it.
So, testimony is the call log for 2022 policy. This is the call log for 2017 policy, which there's 250, 100. There's the scheme. This is the 250. Yes.
Are you referring to the statement, Mr. Burmester, of no known drugs, occasional cannabis use?
No, that
came out of the medical records.
Your Honor, it's Exhibit 18, page 1. It's the last note.
I see what you're referring to. So this is 1803. Hold on a second. Let's get to the bottom of this. My apologies, I had it backwards. Okay, count 7, thank you for this clarification, is with respect to the $250,000 policy. Got it. Thank you for that clarification.
Your Honor, regarding the 404B discussion, the purpose of admitting the evidence is further to many of the exceptions, propensity, intent, preparation, lack of accident, nearly all of them. 404B just relates to whether or not the defendant acts in conformity with her character, whether that's prospectively or retrospectively is irrelevant. Most of the defense's argument against Bind over the attempted homicide count, as the court kind of noted, a lot of that goes to jury. A lot of that was arguing countervailing evidence. As the court is well aware, the standard today is notwithstanding countervailing evidence, whether that's countervailing evidence of how quickly Eric Richins eats his eggs, or whether he goes shopping beforehand or afterhand. It's countervailing evidence. It does not apply to the court's analysis today. Part of that countervailing evidence, I find it ironic that counsel argued we hadn't heard one piece of evidence from Eric Richins. What questions does the court have?
I understand the state's position. I understand you to be saying conduct in March is evidence of other acts admissible to prove an MO. I understand the state's position.
And the lessons learned, I think, is very important.
Sure.
You know, we've had some discussion with defense counsel also as it relates to the standards at issue for the probable cause determination. And I think the court has sufficient evidence when viewed in the light most favorable to the state, when giving the state all reasonable inferences, notwithstanding the countervailing evidence, to find probable cause here even without the 404B part. The 404B part helps, certainly, but I don't even think it's necessary for the court to get to a probable cause determination. And, you know, Schmidt, in discussing probable cause, references that probable cause in a preliminary hearing is the same as probable cause for an arrest warrant. And if the state were to set forth all the evidence it has put, referenced in its brief, argued here today, and charge an attempted murder, and ask for an arrest warrant on the information.
Or a search warrant.
Or a search warrant.
Right.
And if the state submitted it to 100 judges in Utah, 100 of them would issue that warrant.
Check to speculation.
It's an argument. Overruled. I understand the state's point. Okay. It is 11:29. We're going to come back at 11:50. Oh, Ms. Nestor, my apologies.
Quickly, I checked the ME report. It did reference the fact he was positive for COVID, but it did not talk about allergies in the ME report. That's where I thought it might be. But I'll keep looking and see if I can find it. But I do know that he did test positive for COVID.
Understood. Thank you. 11:50. Court's in recess. Thank you.
All right, looks like that one's over with. I thought that we would have like another hour to go. All right, it's almost 5. All right, I guess we could end it. We could end today. It's almost 5 here on the East Coast. I have 2 more hearings to show. One's 4.5 hours. The other one's an hour. So, do you want to watch that one for? Well, what should we do? What do you guys want to do? We have, I know, I can't get sick. I'll try and stay healthy for you guys. Okay, we're gonna end it. All right, we're gonna save, so that's 5 hours. We have 5 more hours worth of trial. So we'll call it a day now. We'll call it a day. Yeah, we've been going since 9, so it's almost 5, 9 to 5. I put in a full day, Missy. I think I can retire now. Michael, you want to go eat pizza? Yeah, I think we'll end it. We'll end it. All right. So tomorrow is Davine Michaels. If you guys remember her, she's the one that decapitated her husband. Right? They were married. I'm pretty sure they were married. Right? Yeah. God, I got to revisit that. All right. So check it out. So her sentencing is at 11. So what we're going to do from 9 to 11, we'll show like her opening statements, her closing statements, closing arguments, I should say, verdict. So we'll kind of do a little pre-sentencing prep. So that's Davine Michaels. So Davine Michaels all day tomorrow or until she ends. Hopefully she may only go like an hour. So we're going to have to figure out what to do if she ends at like 1 or something. So anyway, all right, you guys, not married his son. Right. Okay. I got to revisit it, Mallory. So many cases going on, right? So she married his son. I remember that. And they never got married. So they didn't get married. All right. Anyway, I'll 11. Yes. Yeah. 11 o'clock Eastern. We'll go on at 9 Eastern. Michael, I know that's early for you, but it's 8 o'clock your time, 8 o'clock, California, because she's in California. So, or no, she's in Nevada. Sorry. She's Las Vegas. All right. I got to switch off of Kouri and then switch on to Davine for tomorrow. All right, you guys, thank you so much for joining us. Big news from today is that no live streaming for Kouri tomorrow. Judge doesn't want it, agrees with the defense, doesn't want it streamed because, Rafa, can you see him? He's literally at the door. He can't really see him. He's like at the door, like hanging. Anyway, judge agrees he doesn't want evidence to be shown to potential jurors, so they're not going to be streaming tomorrow live. Alan Jackson is no longer the attorney for Nick Reiner. What else? Those are kind of the big ones we're covering. And then Davine Michaels tomorrow. So obviously lots of cats to show you. Got all kinds of kitties, surrounded by kitties. What do you have to say for yourself? Are you Riker? What's up, Riker? What's up? Good girl. And we got Houdini over here with the leg out. I mean, come on. Seriously? Little chicken leg? Little chicken leg there? Yes. Oh, okay. Good girl. All right, you guys. Have a great night. I will see you tomorrow. Thank you, mods. Thank you, Aaron. Thank you, chat. Thank you for spending your day with us today. Tomorrow, 9 o'clock Eastern, we're going to pick up on Davine Michaels and her sentencing. So I'll see you then. Have a good night, guys. Bye.